Court officer? ವರ್ಷದ್ದು
26.
ಅದು ಓಲ್ಡ್ ಅಲ್ಲ ನೀವು ಕೊಡಿ. ಎಸ್ ನೋ ಡೇಟ್. ಎಸ್
My Lord's permission, if I could.
wait.
It's a father-in-law's petition. There's a matrimonial proceedings initiated.
Men come this side. Yes.
It's a father-in-law's petition, my lord. It's a matrimonial proceedings that are initiated between the husband and wife, my lord. She filed the complaint subsequently after 1.5 years of the proceedings. Notice was issued. My interim order needs to be considered, my lords.
Fresh notice is issued.
What is it, my lords? There's an interim order.
Notice and no stay will come. Give it. Yes.
My lords, I've been moving this matter since February, my lords.
No use, madam. I will post it when it is to be posted. Give it.
My lords, matter for.
Wait, someone's there. Wait.
My lord, the worker has fallen and injured himself during renovation work. Now MD is arraigned as accused, my lords.
Fresh matter.
Fresh matter.
Yes.
My lord's
Now tell
matter
me.
at 2:30 today.
Devaki.
I've been not named as accused in the complaint or in the FIR, my lords. Subsequently, in the remand application, second remand application, I've
Can
been
be.
named.
So
There's
what's-
no allegation against me, but there's threat of arrest. Police are harassing me every day, my lords.
Take
Continuously
secure
from-
bail.
My lords, the matter, there's no direct
Secure
allegations
bail.
against.
Remand order not stay ಕೊಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
No, my lords. They've issued
What is the
35
offense?
clause 3.
What is the offense?
Fabrication of documents and forgery and cheating, my
No.
lords. My lords, the matter may be
Secure bail,
kindly
madam.
taken up at the end of the list, my
No,
lords.
madam. You are in custody.
No, my lords, but there is
Then
immediate
tomorrow.
threat of arrest, my lords.
Tomorrow.
My lords, due to the pendency of the proceedings, petitioner is unable to
Connected
renew his passports, my lords.
ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಅದು ಯಾವ್ದು ಪಾಸ್ಪೋರ್ಟ್ ನಾಳೆಗೆ
My
ಹಾಕಿ.
lords, and another connected matter, my lords, same.
ಕೊಡಿ. ಎಸ್ ಫಿನಿಶ್ ಫಾಸ್ಟ್.
PMLA proceedings, my lords had given a.
Fresh or pending?
It's pending, my lord. This is
ಡೇಟ್
only
ಕೊಟ್ಟಿದ್ದ
one fresh.
ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್
My lords had given a date for today, but it's not
ಯಾಕೆ
listed.
ಡೇಟ್
my lord.
ಬಂದಿಲ್ಲ ಮೇಡಮ್?
Kindly be taken up
ನೋಡಿ.
tomorrow,
ಎಸ್
my
ವಿಲ್
lord.
ಸಿ ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಡೇಟ್ ಗಿವನ್ ಅಂಡ್ ನಾಟ್ ಕಮ್ ಟುಡೇ ಇಟ್ ವಿಲ್ ಕಮ್ ಟುಮಾರೋ.
My lords,
Tomorrow the
138
date will be
proceeding.
given, my lord.
If it is date given today and is not listed, it will come tomorrow.
My lords, 138 proceedings.
I'll
The-
come. Wait. Yeah.
Apprehension of arrest, my lord.
Why?
Now they are 25 years, but 10 years back, POCSO case, they have filed FIR now, my lord.
Give it. 2:30.
My lords,
Why 2 matters?
My one on him and another on their mother, father and uncle.
FR number?
No, my lord.
ಸರಿ. Yes.
2025 matter, lordship. ಒಂದ್ಸಲ list ಆಗಿತ್ತು, ಅದಾದ್ಮೇಲೆ
ಕೊಡಿ.
reach ಆಗಿಲ್ಲ, lordship.
ಕೊಡಿ ಅದೆಲ್ಲ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ. ನೀವು 10 times ಮೂವ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇನೆ. ಐ ಟೋಲ್ಡ್ ದಟ್ ಲೇಡಿ ದಟ್ ನಾನು ಯಾವಾಗ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀನಿ ಅವಾಗ ಮಾಡಿಸ್ತೀನಿ. ಕೊಡಿ. ಸ್ಟೇ ಇದೆಯಾ?
138.
ಸ್ಟೇ ಇದೆಯಾ? ಇಲ್ಲದೆ ಇರೋದೆಲ್ಲ ಬರ್ತಾ ಇದೆ, ನಾಳೆಯಿಂದ ಬರುತ್ತೆ. ಎಸ್.
My lords, 138 matter.
ಓಹ್ ಅದ್ಲೇನು ಅರ್ಜೆನ್ಸಿನೇ ಇಲ್ಲ. ಕೊಡಿ ಬರಲ್ಲ.
My lords, 138
ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
matter. My lords, 138
10
matter.
times ಮೂವ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇನೆ. ಕೊಡಿ.
The
OS
proceedings.
is pending since 5 years.
Give it.
OS is pending since 5 years.
OS ಆ?
Civil suit is pending,
so?
your lordship. Now he has come up with criminal case, your lordship.
Give
Already
it.
one case
Fresh is it?
fresh, your lordship.
No urgency there. Give it. It will come.
The kidney patient, he is.
ಅದೆಲ್ಲ ಬೇಲ್ಗೆ. ಕಿಡ್ನಿ ಪೇಷಂಟ್ ಎಲ್ಲ ಬೇಲ್ಗೆ 482 ಅಲ್ಲ.
Every day he is called to police
No.
station and
No. Give it. Yes.
tomorrow, your
My
lordship.
lords, my
It will
lords,
come. Fresh matters will come. Yes. give it.
my lords, 138 matter. The check name and the petitioner's name are different.
Give it.
And
Fresh matter.
Fresh matter, my lords.
My lord, that's old matter, my lord.
Give it. Old pending ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ.
A fresh
Fast. You
matter,
should be
my
fast in giving. Men ಈ ಕಡೆ ಬನ್ನಿ. ಇಲ್ಲಿ ತಗೊಂತೀನಿ ಬನ್ನಿ. Yes.
That's pending matter, my lord. Fresh matter, my lord. 498A case against
ಕೊಡಿ.
the husband. My lord, there is a urgency in.
Husband.
Husband, my lord, there is a urgency in this matter.
ಏನ್
This
urgency?
498A case came to be registered against the husband.
Hmm.
Since he denied to give majority of shares, my lord, now she is not allowing me to run my school. Every day she is
ಪರವಾಗಿಲ್ಲ.
coming there.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. Every day she is coming there. She is your wife.
Lord, this is my family business. my
So
lord.
what? Give it. No urgency there. Wait. ಅಲ್ಲಿ ಬರ್ತೀನಿ ಇನ್ನು. Wait. Yes.
My lord,
Give it fast.
my lord,
How long will I take? Only your memos. Give it.
for locating stay, my lord.
ಕೊಡಿ give vacating stays.
My lord, for respondent number 2, my lord, this is a cyber crime, my lord.
Give it.
8,000 crores of source code
ಈಗೇನ್
has
ಸ್ಟೇ ಆಗಿದೆಯಾ?
stay ಆಗಿದೆ, my lord. We have filed.
ಯಾರು ಕೊಟ್ಟಿರೋದು ಸ್ಟೇ?
My lord.
ನಾನೇ ಕೊಟ್ಟಿರೋದಾ? ಕೊಡಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Yes, my lord. No further investigation.
ಕೊಡಿ
has happened.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ಮೇಲೆ ಕೊಡಿ.
My lord, kindly refuse.
Give all the memos now.
The matter has been
Give
already
it.
Energy engineer, NBW has been issued against him.
230.
My lordship, 230.
NBW 230 ತಗೊಳ್ಳಿ.
Pension is held up, my lordship.
No problem. Give it. Yes.
My lord.
You'll get it with interest. Don't. Yes.
The matter has already been quashed against other accused, my lord.
Give it, madam. Yes.
My lord, 311 application was allowed on 23rd February, my lord, but on the next date, the very same stage was closed, my lord, for cross-examination of the IO. It may be-
Tomorrow.
My
Give it. Pending memos, please give.
My lord,
No
entry
dates.
order has been vacated, my lord.
No dates, madam. Give it, yes.
My lord.
That's by a reasoned order, coordinate bench is vacated. I am not going to grant. Give it, yes.
The arguing counsel did not appear at the last.
Can't help. Give it, give it.
It's a
Yes.
fresh matter.
Now stop, put bidi.
For tomorrow, my lord, the urgency is, the complaint is against my friend, my lord.
ನೀವೇ ಅಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೀರಾ, ಈ ಕಡೆ ಬನ್ನಿ. ನಾನು ಈಗ ತಕ್ಷಣ ಇಲ್ಲಿ ಬರಲ್ಲ, ಅಲ್ಲಿಂದಾನೆ ಬರೋದು.
Just because I'm a friend of the person who has cheated him, he has falsely implicated me, my lord, for tomorrow.
Tomorrow.
My lords,
Fresh matter.
Men this side ಅಂತ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಇಲ್ಲೇ ಬರ್ತಿರಲ್ಲ.
my lords, this is an urgent matter.
Urgent matter ಎಲ್ಲ ಕೊಡಿ fast.
The director, if it could be,
Give it, yes.
there's a company petition that has
Give the
been filed.
memos.
And then
What's the
there's
urgent?
an IPO process underway.
Okay.
There's an IPO process underway and the ex-shareholder has filed a,
Fresh matter,
yes,
please give.
if it could be, if any short date could be.
It'll come in this week or Monday, definitely give it, yes.
There is a stay operating.
If tomorrow,
Vacating stay, give it. Give it.
My lord, there's an urgent matter. My
Ah,
lord,
yes,
fresh
now
matter for
stop.
withdrawal.
Fresh matters ಎಲ್ಲ ಕೊಡಿ. First fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. First fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
2:30, may I make a mention?
2:30 wait. Fresh matters ಬೇರೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lord, atrocity act, my lord.
ಎಲ್ಲ fresh matters ಕೊಟ್ಬಿಡಿ.
ಇಲ್ಲ, my lord.
2:30 ಬೇಕಾದ್ರೆ ಇರಿ.
ಇಲ್ಲ, 9th ಬೇಕು, my lord.
ಅದೇನು ಡೇಟು?
ಅಯ್ಯೋ for stay.
Not asking for 2:30.
All fresh matters please give.
These Attica Gold companies.
Fresh matter.
Fresh matter.
Mention you please.
Give it, we'll see. Yes.
We won't give date. 2:30 only.
No, ಏದ್ರಲ್ಲೇನು ಅರ್ಜೆನ್ಸಿ ಇರುತ್ತೆ ಕೊಡಿ.
Vacating
ಸ್ಟೇಗ ಕೊಡೋದೇ ಇಲ್ಲ ನಾನು, ನೀವೇನು ಹೇಳಿದ್ರು ಕೊಡಲ್ಲ. ಹರ್ಡ್ ಬರುತ್ತೆ ಅದ್ರ ಪಾಡ್ಗದು. NDPS ಅಲ್ಲಿ ಸ್ಟೇ ಇಲ್ವೇ ಇಲ್ಲ. ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ, ಬರ ಏನು ಚಿಂತೆ ಇಲ್ಲ, ಕೊಡಿ. That's not an urgent matter at all. It will come anyway. No problem, sir. It will come, sir. Give it.
Atrocity, my lord. Petition is.
No, sir. Pending matters, no fixing of dates. Give it.
Student, my lord. Atrocity, my lord. Petition is a student, my lord.
2:30 wait.
Petition is a student, my lord. Atrocity, my lord.
Fresh matter tomorrow.
as fresh matter,
ನಿಮ್ದಾಯ್ತು. All turn is over. Wait.
Requesting for.
ಎಲ್ಲಿಗೆ ಬೀಳ್ತಾ ಇದ್ದೀರಾ, ಯಾಕೆ? ವೈ ಹಾ,
Requesting for 2:30.
ಅಟ್ರಾಸಿಟೀಸ್ ಯಾವ್ಯಾವ್ದಿದೆ ಅದೆಲ್ಲ ನಾಳೆ ಕೊಡಿ. ಅಟ್ರಾಸಿಟೀಸ್ ಕೇಸ್ ಸುಮ್ನೆ ಕೊಡಬೇಡಿ. ಇಲ್ಲರ್ ಯು ವಿಲ್ ಫೇಸ್ ಅಟ್ರಾಸಿಟಿ. ಎಸ್. Vacating stay, wherever vacating stay is there, give it.
My lord.
Wherever vacating stay is there, give it.
Squashing of 138 proceedings.
Fresh matters kodi. It will come in 27, sir. If you have not moved it, en madakagala kodi.
Squashing of 138.
Give it, sir. Will you wait, please? Yes, give it. Atrocities ಯಾವ್ದು ಎಲ್ಲ ಕೊಡಿ. Renewal of passport application ಹಾಕಿದ್ದೀರಾ?
Squashing of.
Now why are you all waiting still? ಎಲ್ಲ 2:30 ಬೇಕಾ?
Fresh matters, 2:30.
ಎಲ್ಲ 2:30 ಗಾ?
Attica Gold.
Seriously? One ನಿಮಿಷ, one minute. ಏನ್ ಮಾದೇವ್? Wait. ಏನ್ 2:30 ಬೇಡ ಕೊಡಿ. ಯಾಕೆ ಕೋರ್ಟ್ಗೆ ಹೋಗಿಲ್ಲ? ನೋ ನಥಿಂಗ್ ಕೊಡಿ. ಏನ್ ಚಿಂತೆ ಇಲ್ಲ ಕೊಡಿ. ನಾಳೆ ಲಕ್ಷ್ಮಣ್ ಅಲ್ಲಿಂದ ತಗೊಳ್ಳಿ, ಇಲ್ಲಿ ತಗೋಬೇಡಿ. ಮಾದೇವ್ ನಾಳೆಗೆ ತಗೊಳ್ಳಿ, ಅದು ನಾಳೆಗೆ ತಗೊಳ್ಳಿ. No problem, give it. Fresh matter. Monday.
Squashing of.
ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ಒಂದ್ ಮೆಮೊನು ತಗೊಳಲ್ಲ. ಪ್ಲೀಸ್ ಹ್ಯಾವ್ ಪೇಷನ್ಸ್. ಎಸ್. ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ತಗೊಳ್ಳಿ. ಆಯ್ತು ಕೊಡಿ. ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ 2:30 ಹಾಕಿ ಮೇಡಮ್. ವೈ petition is in custody? Why? Pending matter. ನಾಳೆ ಸರ್, ಯಾಕೆ? And there is no case for you. ಕರೆಕ್ಟ್ ಆಗಿ ಏನ್ ಬೇಕು ಹೇಳಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಮಂಡೇ ಏಕೆ ವಿಕ್ಟಿಮ್ ಇಲ್ಲ, ಕೇಸ್ ಇಲ್ಲ, ಯಾಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ? ಅದಕ್ಕೆ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಮಂಡೇ yes.
My lord, squashing of
Give it.
My lord, may I mention for truth?
For check bounce offense, 420 cases filed in Bangalore.
Fresh
Fresh ಅಲ್ಲ, ಈಗ
ಪೆಂಡಿಂಗ್ ಕೊಡಿ.
some months, my lord, thereafter, like,
ನೋ ಪೆಂಡಿಂಗ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಟು you wait.
this matter,
What's the hurry?
I did
Wait.
not appear.
ನಿಮಗೆ ಹೇಳಿದ್ದು what's the hurry? Wait.
But
Yes.
on 15th October 2025 it came, I did not appear, therefore it adjourned.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ಕೊಡಿ. ಎಸ್ ಗಿವ್ ಇಟ್ ಸರ್. ಪ್ರೆಷರ್ ಪೆಂಡಿಂಗ್ ಮಂಡೇ.
Let's squashing of 138.
ಮಂಡೇ
Let's squash.
ಮಂಡೇ
Squashing of 138 proceedings.
ಮಂಡೇ.
Please, fresh matter.
ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ.
Fresh matters.
ಯು ಆರ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಫ್ರೆಶ್ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್. ಆಯ್ತು, ಟುಮಾರೋ ಪ್ರೀಕಾಗ್ನಿಸೆನ್ಸ್ ಕೊಡಿ ಎಲ್ಲ. ಮೇಡಮ್ ಅದು ಪ್ರೀಕಾಗ್ನಿಸೆನ್ಸ್ SPP ಗೆ ಹೇಳಿ ಎಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿದೆ, ಅದ್ರ ಜೊತೆಗೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ.
My lord,
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ ಸರ್.
my lord,
Settlement, whoever is holding settlement memos, when you want, just write and give it. Whenever you want.
Monday, juvenile being tried before an adult court, which would otherwise do.
Juvenile, Monday.
Similar case, my lord, Foxo.
Juvenile, Monday.
Victim is a minor.
Monday. Renewal of passport, ಕೊಡಿ. Application ಹಾಕಿದ್ದೀರಾ? Yes.
my lord, I have attempted suicide 3 times in this matter.
You have attempted suicide. Why?
69 case. And
You have attempted suicide.
Petitioner play hide and seek.
Hide and seek.
Absconded and the council also retired from me.
You are for the respondent.
My lord,
Who's playing hide and seek with you?
The petitioner, my lord. Petitioner is absconded and even council retired from the case. And
Council also is playing hide and seek.
They are assaulted on me again.
Oh. You are for the complainant.
Respondent.
ಅದೇ ಕಂಪ್ಲೇನೆಂಟ್.
A complainant, yeah.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
Vacating stay.
ಅದು ಹೈಡ್ ಅಂಡ್ ಸೀಕ್ ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್.
my lord, one submission.
May-
My lord, I'm a aged lady, my lord.
ಕೊಡಿ ಸರ್. Tomorrow.
NBW have been issued.
Tomorrow.
Kindly,
Requesting for 230.
What is it?
My lord, it's a 498 complaint filed against me in Yelahanka police station, against me and my parents. We got anticipatory bail. Now a fresh FIR is filed in Davangere station and
230.
tomorrow they have called for
230.
investigation. 230.
FR ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ,
FIR.
ಇಲ್ಲರ ಬರಲ್ಲ.
I'm the daughter of the accused. My bail condition relaxation is dismissed. my lord.
ನಾಳೆ ಆಗ್ಬೋದಾ? ನಾಳೆ.
ಇನ್ಲಾಸ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ, ಆಂಧ್ರದಲ್ಲಿ ಇದ್ದಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಕೂಡ ಫೈಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಟುಮಾರೋ 2:30 ಮೇಲೆ.
ಇಲ್ಲ, ಮಂಡೇ.
Fresh case, mother-in-law lodged a complaint against the daughter-in-law.
Obviously, who else? Daughter-in-law against mother-in-law. Monday. 2:30, Monday. Yes.
The exonerated,
DE exoneration.
my lord, predicate offense exonerated, EMLA exonerated. The ED released, recently released only 44 crores of deposit. They are not released the interest, which accumulates around 50 crores, another 50 crores. Kindly, my lord.
Monday.
My lords, matter for 230, my lords,
Why?
138 matter we have for the accused, my lords, pursuant to settlement discussions, we have cleared the entire check amount. Then the complainants have resided from the settlement, my lords. Now NBW has issued, my lords, has been issued, my lords. Kindly have it at
Tomorrow.
2:30, my lords.
Yes.
My lord, 2:30, my lord. Petitioner's advocate, my lord.
ಅದು ಬಂದಿಲ್ವಾ? ಮೇಡಮ್ ಹೋಮ್ ಸ್ಟೇ ಅದು ಹಾಕಿ 2:30 ತೊಗೊಳ್ಳಿ.
My lord, petitioners are
ಯಾವ ಸ್ಟೂಡೆಂಟ್ ಆದ್ರೆ ಏನ್ ಹೇಳಿ ಈಗ? ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ವಾ?
my lord, 2:30.
ಎಕ್ಸಾಮ್ ಸ್ಟೇಷನ್ ಬರೀತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ ಸ್ಟೇಷನ್ ಕೂರಿಸ್ಕೊಂಡಿದ್ದಾರಾ? ಬೇಲ್ ತಗೊಂಡ್ಮೇಲೆ ಏನು ಲಾಲ್ಬಾಗ್ ಕಾಣ್ತಾ ಇದೆಯಾ? ಕೊಡಿ.
2:30, my lord.
ಕೊಡಿ.
Petitioners are advocate, my lord. Petitioner advocate ಇದ್ದಾರೆ, ಅವ್ರ against complaint raise
ನೀವು
ಮಾಡಿ.
ಅಡ್ವೊಕೇಟ್ ಅಲ್ವಾ? ಇರಿ ಸ್ವಲ್ಪ. ಎಸ್. Give it, sir. Yes.
ಇದ್ರಲ್ಲಿ
ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್
ತಾಯಿಗೆ
ಇನ್ನೆಲ್ಲ ಮಂಡೇನೆ, ಅನ್ಲೆಸ್ there is some urgency.
ತಾಯಿಗೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ
ಪರವಾಗಿಲ್ಲ ಮಂಡೇ.
ಅಲ್ಲ ಪೆಂಡಿಂಗ್
ಪೆಂಡಿಂಗ್
ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ
ಪೆಂಡಿಂಗಾ
ಲಾಸ್ಟ್ ಟೈಮ್ ರೀಚ್ ಆಗಿಲ್ಲ ಇನ್ನೊಬ್ರ ಮುಂದೆ ಕೋಆರ್ಡಿನೇಟ್ ರೀಚ್ ಆಗಿಲ್ಲ
ಅದ್ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅದಕ್ಕೆ ತಾಯಿಗೆ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತ
ಸರ್, ರೀಚ್ ಆಗದೆ ಇರೋ ಮ್ಯಾಟ್ರಿಗಳೆಲ್ಲ ನಾಳೆಯಿಂದ ಹಾಕಿಸ್ತಾ ಇದ್ದೀನಿ. ಸ್ವಲ್ಪ ತಾಳ್ಮೆ ಇದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. ದಿನ 10 ಮೆಮೊ ತಂದು ಕೊಟ್ರೆ ಏನ್ ಸೊಲ್ಯೂಷನ್ ಅಲ್ಲ ಅದು. ಕೊಡಿ, ಬರುತ್ತೆ ಕೊಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ತಾಯಿಗೆ
ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದ್ನ ಈಗ ನಾನು? ಏನು ಇಲ್ಲ.
ತಾಯಿಗೆ ಪಾರ್ಟಿಷನ್ ಕೊಟ್ಮೇಲೆ
ಇಲ್ಲ ಸರ್,
ತಮ್ಮನ ಕಡೆಯಿಂದ ಕೇಸ್ ಹಾಕ್ಸವ್ರೆ ಮಗನ ಮೇಲೆ.
ಈಗ ಏನ್ ತೊಂದ್ರೆ ಏನೀಗ?
ಟ್ರೆಸ್ ಪಾಸ್ ಹಾಕ್ಸವ್ರೆ ಅದೇ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್,
ಬರ್ಲಿ
ಏನ್ ತೊಂದ್ರೆ.
ಮಂಡೇ
ಕಲಬುರ್ಗಿ ಬೆಂಚಾ? ವೈ ಯಾವ್ದು ಕೊಡಿ? ಫ್ರೈಡೆ 12 ಗಂಟೆವರೆಗೂ ಮೆಮೊನೇ ತಗೊಂತಾರೆ ಅಣ್ಣ. ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ, ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಮೆಮೊ ಕೊಡ್ತೀರಾ ಹೆಂಗೆ? ಎಲ್ಲ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ. ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್. Give all the memos. Give all the memos. Give off all the memos.
The only
all the memos kodi. Ella fresh mat idre Monday, pending mat idre date kodti.
the only issue in this,
Give whatever be the issue, give the memo.
I am the
Give all the memos.
I am the national coach for the yoga
Give all
team.
the memos. ಏನಾರ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಸರ್. ಏನು ಹೇಳಬೇಕಾಗಿಲ್ಲ, ಮೆಮೊ ಕೊಡಿ. ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ.
There's some urgency in this.
Please give all the memos. Vacating stay idre application. Give all the memos. Give all the memos. ಏನೋ ಆಗಿರ್ಲಿ, give the memo.
Connected matter is disposed.
If you want to give the memo, give the memo. Call the cases, please. Call the cases. Yes. Memo ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ ಸರ್. ಮೆಮೊ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ ಸರ್.
One matter for 230.
ನೀವು ಅಜಯ್ ಎಲ್ಲಾ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲಿ ಬಂದ್ರೆ ಮೆಮೊ ತಗೊಳಲ್ಲ.
There is a stay in my favor, but the matter has not come up, my lord.
No problem sir, give it. ಎಲ್ಲ ಮೆಮೊ
Any date may be given, my lord.
ಯಾರು ಸ್ಟೇ ಇನ್ ಯುವರ್ ಫೇವರ್ ಅಂದ್ರಲ್ಲ ಯಾರು?
My lord.
There's a stay in your favor.
There's a stay in my favor, but what has happened is, my lord, the respondent, that's the complainant, she has went and informed the company, because of which he has been removed from the job. From 1 year, I've been trying to get this matter listed because of the pending matter, he is not getting any job also, my lord.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
My lord, at least any date may be given. Any date, my lord.
My lord, connected matter is disposed.
Why yours is special, ಬೇರೆ ಯಾರಿಗೂ ಸ್ಪೆಷಲ್ ಇಲ್ವಾ?
No, nothing like that, my lord.
ಮತ್ತೆ just keep quiet.
He's the only breadwinner, my lord. That's the only problem.
My lord, 69
project also. Give it.
He's got aged parents also, my lord.
If you want to give the memo, please give the memo.
My lord,
Sir, given any date may be given.
Call the cases, please. Yes.
69 BNS, the petitioner is in custody, my lord.
ಯಾವ ಕಸ್ಟಡಿ? 230 ತಗೊಳ್ಳಿ.
Waiting for
Yes.
My lord.
Give the memos, please.
My lord, connected matter is disposed.
Give all the memos.
my lords, one submission waiting for submit.
I am not giving dates, not taking anything. ಇವ್ ಯಾವ ಮೆಮೊನು ತಗೋಬೇಡಿ.
My lords, waiting from here,
Call-
my lord,
call
for
the cases.
submission, my lords. Your lordship has not heard on.
Give the memos if you want to give. Yes.
My lords,
Call the cases, please. Yes. Call the case.
my lords. My lords, there is one urgency, my lords. The petitioner, when the petitioner was in abroad, my lords, a extortion case was registered against the petitioner. my lords.
So what?
No, my lords, when the petitioner came back to India, one more case was registered. No, my lords, the petitioner is here, my lords. The petitioner wants to travel abroad for a limited period, my lords. If IA is pending, my lords.
Friday ಹಾಕಿ.
Please.
Yes. ಏನ್ ಬೇಕಾಗಿಲ್ಲ. ಏನಕ್ಕೆ ಬೇಕು ಗೋಲ್ಡ್ ನಿಮ್ಗೆ ಈಗ? No problem. No issues, no issues. ಒಮ್ಮೆ ಕೋರ್ಟ್ ಹಾಲ್ ಅಂತ ಗೊತ್ತಿಲ್ಲ? ಎಸ್. ಇನ್ಮೇಲೆ ಕ್ಯೂ ನಿಲ್ಲಿಸ್ತೀನಿ, ಒಬ್ಬೊಬ್ಬರಾಗಿ ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ಲಿ. ಬೇಕಾದು? I'll ask them to stand in a line. If you are creating chaos like this, I'll ask you to stand in the line. ಒಬ್ರು ಮುಗಿಸ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರಲಿ. That's the best, I guess. ಇಲ್ಲದೆ ನೀವು ಯಾರು ಏನು ಮಾಡಲ್ಲ.
Sir, one humble submission.
No adjournment, please. Yes. No. Yes. From tomorrow, make a line. Make 3 lines. I'll finish line by line. ಎಲ್ಲ ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡಿದೆ. ಮಂಡೇ 250 ಮ್ಯಾಟ್ರಸ್ ಇದೆ ಅಂದ್ರೂ ಅರ್ಜೆನ್ಸಿ ಇವತ್ತೇ ಬೇಕು. ಎಸ್ ಲೀವ್ ಇಟ್. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಕರೀರಿ.
Appearing for the petitioner in serial number 1, Your Lordship.
ಎಸ್ ಸರ್.
Your Lordship, the petitioner being aggrieved by the proceedings initiated against him by the respondent for the theft of electricity, Your Lordship. But in fact, the petitioner has been paying his electricity charges and may correctly, Your Lordship, as per annexure.
In the meantime, next.
Number 2.
Petitioners are accused 2 and 3, finding some allegations without hearing the complainant. The interim order cannot be considered. 1 HCGP to emergent notice. Next. Doreraj.
Appear for the petitioner, my lord.
Here for petitioner, my lord. It's a civil dispute, my lords. OS numbers are pending, my lord.
Horrible. Come after charge.
No, my lord, sir.
No, sir. Kudi.
Civil dispute is
No
pending, my
problem.
lord.
Yes, sir.
And MFI is also pending. My
No
lord.
problem, sir. Serial number 4, Allah.
Yes, my lord. Petitioner is widow, my lord, sir. She is
This petitioner is what, sir?
widow, my lord. She is the
So what,
purchaser
sir?
of 2011, my lord.
ಇನ್ನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ? ಕಂಪ್ಲೇಂಟ್ ಬನ್ನಿ. ಇದರಲ್ಲಿ ನಾನು ಎಂಟರ್ಟೈನ್ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಅಂತ. Come after charge. The petitioner is before the court calling in question the registration of a crime in crime number 317 of 2025 registered for the following offences. The learned counsel appearing for the petitioner submits that the petitioners the civil dispute pending between the parties has generated the subject complaint, and both the civil dispute and the complaint run on the same fulcrum. The said submission is noted only to be rejected for the reason that the matter is still at the stage of investigation and the complaint is in great detail. The complaint reads as follows. In the light of the aforesaid complaint, there is no warrant of interference at this stage, reserving liberty to the petitioner to knock at the doors of this court once the final report is filed, and the said final report would go against him. The petition stands disposed. Next.
5.
I am for the petitioner in this case, my lord.
1 HCGP to emergent notice.
My lord, one submission, my lord. There is
Take
a discharge.
Mastercard, sir.
My lord, discharge application pending in this trial court, my lord. I am not.
Then you come after discharge. The petitioner is before the court seeking the following prayer. The petitioner would submit that against the order of drawing the petitioner into the array of accused while filing the charge. The petitioner is before the court calling in question proceedings under section 138 of the Negotiable Instruments Act. The primary contention inter alia of the petitioner is that the company is not made a party. In the light of the judgment of the Apex Court in the case of Anita Hada versus Godfather Travels Private Limited 2020-2012 5 SEC page 661, there shall be an
of complete disclosure, my lord. After I filed the petition,
319
ex parte, they go and get the company impleted, my lord. I have carried my memo, but that certified. We filed in February. They do it.
petition attack. Yes. While instituting the proceedings, company was not made a party. The learned counsel, however, the learned counsel would now submit that after the notice was issued, now in the month of
I filed on 18/2 and they impleted on 9/6, my lord.
on 9/6, the company is implemented as a party respondent to the proceedings without even hearing the present petitioner. On all these factors, in the light of the aforesaid, there shall be an interim order of stay of further proceedings where the petitioner to the next. In the meantime, stayed Paniraj. Yes. Interim order badwa. Kottayt. Yes, next.
8.
A3 and A4, 498A. Yes.
9.
Seriously. Husband illa 2 and 3. Yes. 85.
My lord, 10, serial number 10, I appear for the petitioner, my lord.
Own certificate ಇದೆಯಾ?
Yes, my lord.
In the meantime,
Charges are
next.
already flamed, your lord.
Charge frame ಆಗಿದೆ ಯಾವಾಗ?
17/126.
The learned counsel appearing for the learned HCGP on instructions and verification of the records would submit that charges have already been framed. Matter is at the stage of trial. In the light of the petition itself preferred before this court after the framing of the charges and the evidence set into motion, there is no warrant of interference at this stage. In the light of, in that light, reserving all liberty to the petitioner to knock at the doors of the appropriate court. The said circumstance, reserving liberty to the petitioner to urge all the contentions before the court at the appropriate time. The petition stands disposed. Next.
318, my lord. Offense under 318/126. The complainant, she is demanding back the service charges paid, my lord, to my company.
Correct. 30 pay, come to page 36. Page a planet. 8,30,000.
Yes, yes, my lord.
Heard the learned counsel Akshita Shetty appearing for the petitioner. The complainant and the petitioner had agreement,
MOU ide. MOU.
had entered into a memorandum of understanding. The breach of memorandum of understanding or the disputes that have arisen because of the memorandum of understanding, the petitioner, the complainant has sought to set the criminal law into motion for the aforesaid offences. While so doing, also alleges offence punishable under section 126 of the BNS/341 of the earlier regime, the IPC, finding none of the ingredients for either of the offences that are alleged in the case at hand, permitting further proceedings would run foul of plethora of judgments and become an abuse of the process of the law, albeit prima facie. In that light. Yes.
12.
For the petitioner, my lord.
1 no, 2 and 3. 85. Next.
13.
Interim order has.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, 2 and 3 ಮಾತ್ರ, ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ. ಎಸ್ ಅಂದ್ರೆ ಹಸ್ಬೆಂಡ್ ಸ್ಟೇ ಇಲ್ಲ ಅಂದೆ, ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ ಅಂತ.
ಇಲ್ಲ 12 ಅಲ್ಲಿ this is a matter of private complaint wherein
so what sir?
Regarding
next
13.
Serial number 13, I am appearing for the petitioner. Here, there is a civil dispute which is in our favor.
Go to page 38, sir. Yes.
Yes, brother.
Page 38.
Page 38.
ಹೌದು, ನಿಮ್ ಪೆಟಿಷನ್ ಅಲ್ಲೇ.
Yes, brother. Police notice.
1 HCGP 2 emergent notice. Yes, next.
And I have sought for stay
No,
of
sir,
the.
not a case for stay.
The reason is this, brother.
Not a case. Reason may be manifold, not a case for stay. Yes, next. 14, 1. Alla 12 in the meantime must confuse I think. Yes, 12 in the meantime. 498 alla.
14, I beg to appeal for the petitioners.
14 husband no, 2 and 3 stay. Yes, 85. Next.
15.
For the petitioner.
In 302 application allowed?
302 application. Seeking permission to engage.
Correct. ಏನಾಗಿದೆ?
That has been rejected on the ground that as a matter of right you can't.
Correct. As a matter of right you can't. We'll only permit you to assist the prosecution.
My lords.
No separate counsel, only assisting the prosecution.
No, the thing is.
Thing may be anything, sir.
That
is the law.
Theft is 2,87 lakhs.
Amount ಏನಾರು ಇರಲಿ, that is the law. Law does not depend on quantum of amount here. 302 ಗೆ I will permit you to assist the prosecution. You can't engage a separate counsel and contest.
Do that.
ಅಷ್ಟೇ, simple. ಅದು ನಂದೇ ಜಡ್ಮೆಂಟ್ ಇದೆ. ಪಾಸ್ ಓವರ್. ಮಧ್ಯಾಹ್ನ ಮಾಡ್ತೀನಿ. Next.
Shall I wait?
In the meantime.
17.
16 and for the.
Stayed, madam. Yes.
17.
Offense number 118 clause 1 of PNS and
1 HCGP to emergent notice.
This is a sumo
75. Yes. Next.
18.
In the mean, ಅದು ಸೇಮ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕೊಡಿ.
Connected matter.
ಈ ನಂಬರ್ ಕೊಡಿ ಸರ್. ಇಲ್ಲದ್ರೆ ಸ್ಟೇ ಕೊಡಲ್ಲ ಈಗ.
ಅಲ್ಲ 7547.
ಎಲ್ಲಿದೆ ಸ್ಟೇ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ?
ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿರೋದು
ನೆನ್ನೆ ಸುಮಾರು ಇತ್ತಲ್ಲ ಸರ್, ಎಲ್ಲಿದೆ ಕೊಡಿ ಅದು.
ಅಲ್ಲಿ ಪಾಸ್.
ಎಸ್. ನೀವು ಪಾಸ್ ಆನ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಅಷ್ಟೇ, ಇಲ್ಲ.
My lord, it's connected matter is on 10th, my lord.
No, not
Which one,
this,
madam?
not this. Wait.
ಯಾವ್ದು ಮುರಳಿ ಅವ್ರದ?
Number 19.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರ್. ಈ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟ್ರ್ ಯಾಕೆ ಬಂತು? ರೆಗ್ಯುಲರ್ ಇದು ಬಂದಿದೆ.
ಅಲ್ಲ, ಅದು ಮುಂಚೆನೆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿತ್ತು ಅಂತ ಬಂದಿದೆ.
ಸರಿ ಆಯ್ತು. ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ.
Please.
20 ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ.
19.
ಫ್ರೈಡೆ. 19, sorry, 19.
20.
175 for violation.
175(3) and 175.
In the meantime, yes, next.
21.
My lord, in this, what has happened? Complainant daughter joined for PhD in the Kuvempu University, my lord, to do PhD. That to 7 years before, my lord. There is the rule to complete the PhD, my lord. Duration is within 3 years. It has to be completed. Even if you take double duration, also it will happen 6 years, my lord. In that also she has not been completed. Later, what has happened? My lord, the reason is very disciplinedly I conducted.
Discipline.
Because I am a professor, my lord.
Correct.
In the university, I am a
So
senior
discipline
professor. Please, my lord. Because when we are doing a PhD and all everything, the researching, I guided very sincerely everything, but she has not done. She has not been completed that PhD.
Why did you take
later, my lord?
Money.
No, my lord. The reason she has not been completed. She's intention is to award that PhD. She was in that intention.
Award that PhD now.
My lord, I have
You had intention to award. She had intention to avoid.
No, my lord. The reason is, my lord, she is unable to complete that. For the reason indirectly she been approached like this, my lord. That too later, after 7 years she been filed this PCR, my lord. For the reason
ಯಾಕೆಂದ್ರೆ ದುಡ್ಡು ಇಸ್ಕೊಂಡು ನೀವು ಕೊಟ್ಟಿಲ್ಲ ಅವಾರ್ಡ್ ಅಂತ.
No, my lord. It is not.
Discipline ಆಗಿ ಮುಗಿಸಿದ್ರಿ, ಆಮೇಲೆ ಅವಾರ್ಡೇ ಬಂದಿಲ್ಲ.
If it is so like that, my lord, before 6 years only she would have been could have been complained, my lord. Now what has happened?
ದುಡ್ಡು?
My lord,
ಎಷ್ಟು ಇಸ್ಕೊಂಡು?
no, nothing is no transaction, nothing is there, my lord. Even single rupee also not been transacted. Nothing is there. Simply whatever the complaint governments, based on that they've been filed, my lord. This is the fact. Kindly.
In the meantime, next.
22.
In this case, my lords, this is a case filed under offense under section 69 of BNS.
What is 69?
It's for a false marriage.
False marriage? What is false marriage?
Deceitful means, my lord.
False marriage ಎಲ್ಲಿ ಬಂತು?
Whoever by deceitful means or by making.
Now you have done that clearly here.
No, my lord, because.
Because what?
They both knew each other. There was a consensual
Knowing
relationship.
each other, so what?
There was a consensual relationship between both, my lords, and there is a suicide note also where she has.
ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
ಅದ್ರಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ಯಾರಾ ನಂಬರ್ page number 30, para number 4 ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. I know him. He can never forget me. It might be because of his situation. He did nothing wrong.
Petitioner is before the court calling in question the proceedings. Sorry, charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ ಸರ್.
Registration of a crime for offense punishable under section 69 of the BNS. The complaint is the gist of the complaint is as follows. Page 24 will mark ಮಾಡಿದ್ದೀನಿ. The petitioner and what is the Singham house?
It's an apartment where they stay.
Singham house.
Yes, ma'am.
Oh. Yes, ಹಾಗಾದ್ರೆ stay ಇಲ್ಲ.
I mean, there's also annexure D, my lords. It's a medical.
And what is Godrej house?
That's also apartment.
How many apartments you have?
2. They stayed in 3 different rented apartment, my lords. Rented.
So and so. A perusal at the complaint would clearly indicate that the acts between the two were consensual for the reason that they were living together for months. It is now alleged that it is on the breach of promise of marriage. Nowhere in the complaint it narrates that there was any talk of marriage between the two. Since the acts are consensual, permitting further investigation to the case at hand would run foul of the judgment of the apex court in the case of Deoram Modelayar Sonar 2018-19 SEC page 191. Next.
Stay may be granted.
Yes. Put it in. Next. 311 application allow ಆಗಿದೆಯಾ?
Dismiss ಆಗಿದೆ.
Dismiss ಆಗಿದೆ.
307 proceedings.
Let's tomorrow, we'll dispose it tomorrow.
Please.
Fresh matters, next.
24.
318. Sale agreement was entered. The sale agreement is terminated by issuing a notice. The amount is refunded.
Refund ಮಾಡಿದ್ದೀರಾ ಪೂರ್ತಿ?
Refund ಆಗಿದೆ. They
The
have
whole
acknowledged.
amount?
They have acknowledged.
In the meantime, next.
25.
Meantime.
26.
108 KP Act. ನೆನ್ನೆದಾ?
ಟಿಪ್ಪು ಜಯಂತಿ.
ಯಾವುದು? 26.
26.
Stayed, yes.
4 accused quash.
ಕೊಡಿ. Quash ಆಗಿರುತ್ತೆ.
Yesterday alone.
We'll quash it then, same. ಅದು JY, covered, same order. Co-accused quash ಆಗಿರುತ್ತೆ. Next.
27.
For the petition. My lord, case and counter case, my lord. Only against me, my lord, 307 has been. Grievous hurt has been, and in my case, my lord, the major assailant was, alleged assailant was accused number 1. He's died, my lord. During investigation itself, he has died. And as per the injury wound certificate, my lord, I have suffered 4 injuries, and they have suffered only 1 injury, my lord.
Oh, injury
Yet they
versus
are-
injury.
ಹೌದು. Lordship, may kindly see the wound certificate.
No, sir,
The-
go.
ಅಂದ್ರೆ Lordship, may kindly see.
ಅಂದ್ರೆ ಏನಿಲ್ಲ.
They have visited my house and assaulted us. In
You have
defense-
visited their house and assaulted
No, no,
them.
no. Your Lordship, may kindly see the counter case. And Your Lordship, may kindly see the charge sheet, Your Lordship.
ಅದೇ 44 ನೋಡಿ ಅಂತ ಹೇಳಿ.
44 ಅಲ್ಲಿ. Lordship. 17. Lordship, may kindly see. The
ಅದರಲ್ಲಿ
allegation
ಏನು
is-
ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲ, ಇದೆ.
ಆಮೇಲೆ,
Against
ಮತ್ತೆ
A1, my lord. A1, he is no more. He is died during the.
A2 ಬೇಕಾ ಎಲ್ಲಿದೆ ಅಂತ?
Yes.
ಇಲ್ವಾ?
ಅಲ್ಲ, ಇದೆ. ಹೇಳ್ತೀನಿ Lordship. A2 ಆರೋಪಿ ಮೃತ A1 ಆರೋಪಿಯನ್ನು
ನೋಡ್ಲಿಲ್ವಾ ನೀವು?
ನಾನು ನೋಡಿದ್ದೇನೆ. Lordship.
ಬನ್ನಿ, ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಕರೆದುಕೊಂಡು ಬಂದ A2 ಆರೋಪಿಯು ಬಳಿ ಮಾತನಾಡುತ್ತಿದ್ದಾಗ A2 ಆರೋಪಿಯು ಕೈಯಿನಿಂದ ಸಾಕ್ಷಿ ಎರಡರವರೆಗೂ ಸಹ ಹಲ್ಲೆ ಮಾಡಿ ಇನ್ನೇನಾದ್ರು ಬೇಕಾ?
ಅಲ್ಲ, ಎರಡಲ್ಲ.
ಎರಡೇ ಅಲ್ಲಿ ನಾನು ಓದಿದ್ದು A2 ಅಂತ.
A1.
A2 ಸರಿ
And
ಓದಿದ್ದು.
my lord, recovery is from complainant. In this case, the long was recovered from the complainant. Your Lordship. may kindly
ಲಾಂಗೋ
see.
ಶಾರ್ಟ್ ಅದೆಲ್ಲ ಇಲ್ಲ. ಗೋ ಸೀಕ್ ಡಿಸ್ಚಾರ್ಜ್. No, sir, not a
And
case.
one more aspect, my lord, legal fact is that.
Legal fact.
Allah. Case and counter case should be tried in one court, my lord.
That
Now
we'll
here
see.
in this case.
ಅದು ಗೊತ್ತಿಲ್ಲ ಇನ್ನು ಏನಾಗ್ತಾ ಇದೆ ಅಂತ ನೋಡೋಣ.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
That
ಅವ್ರ
frame
ಮೇಲೆ ಟ್ರೈಬಲ್ ಬೈ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಂಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್
That is
ಟ್ರೈಬಲ್ ಬೈ
307,
ಸೆಷನ್ಸ್
sir.
ಕೋರ್ಟ್. ಎಸ್.
ಯಾಕೆಂದ್ರೆ ನಿಮ್ಮ 307 ಇರೋದ್ರಿಂದ ಕೋರ್ಟ್ ಆಫ್ ಸೆಷನ್ ಟ್ರೈ ಮಾಡಬೇಕು. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕ್ಯಾನ್ ಟ್ರೈ ದಟ್ ಆಲ್ಸೋ. ಕೋರ್ಟ್ ಆಫ್ ಸೆಷನ್, ಸಾರಿ, ಕೋರ್ಟ್ ಆಫ್ ಸೆಷನ್ ಕ್ಯಾನ್ ಟ್ರೈ ದಟ್ ಆಲ್ಸೋ.
that also can be tried.
ಅದು ಡೌನ್.
Lordship, may kindly see the wound certificate shows that I have suffered more injuries. They have suffered simple injuries.
This is injury versus injury.
Yes, my lord. Because here, while filing charge sheet, my lord.
No, sir. Not a case for
factored in bias.
ವಿನೋದ್ ಕುಮಾರ್, ಇಷ್ಟೊಂದೆಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ ನೀವು. ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್. ನೀವೇ ಹೇಳ್ಬಿಡಿ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ ಇಲ್ವಾ? ವಾಟ್ ಇಸ್ ದಿಸ್ ಮತ್ತೆ? No, sir. Not at all.
Yes.
Seek discharge.
Much.
Yes.
28.
Identical matter ಯಾವ್ದು ಸರ್?
It's not identical.
ಹಂಗಾರೆ in the meantime, next.
29.
Identical matter ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ ನಾನು?
That is writ
ಅಲ್ಲ,
petition.
ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ ನಿಮ್ದು ಏನೋ.
Writ petition, Lordship.
Writ petition
related to civil
Yes.
matter.
All right, yes, next.
29.
Petitioner to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement of such service. 27 fresh matters in the meantime, next.
30.
Complainant and the accused of the brother suit for partition.
Very good, sir. Heard the learned senior learned counsel Kalyan Basuraj appearing for the petitioner. A perusal at the summary of the charge sheet ಆಗಿಲ್ಲಲ್ಲ?
Charge sheet ಹಾಕಿದ್ದಾರೆ.
ಆಗಿದೆ. Perusal at the summary of the charge sheet would not indicate not even a titter of ingredient of offence punishable under section 126(2) of the BNS, which is 341 of the earlier regime, the IPC. The learned counsel taking this court through the documents appended to the petition would further demonstrate that the complainant petitioner, the subject crime is registered for all the aforesaid reasons in the meantime. Next.
31.
1 HCGP 2 MR. 31 in the meantime. Next. 32 1 HCGP 2 emergent notice.
2 and 3 no allegation Malaysia.
No.
What Malaysia? Lady ಮೇಲೆ 2 3 is no
Yes.
3 ಮೇಲೆ no allegation.
Barley.
Malaysia.
Yes.
ನೋಡ್ತಾ ಇದ್ರು ಅಂತ ಅಲಿಗೇಶನ್.
ಪರವಾಗಿಲ್ಲ ಈಗ ನಾವು ನೋಡ್ತಾ ಇರ್ಲಿ ಬರೋಣ.
ಸ್ಟೂಡೆಂಟ್ ಮೇಲೆ ದಟ್ ರೀಸನ್.
33 Nehru.
Section 306.
Accused number 1. 1 HCGP, 2 emergent notice.
34.
Yes.
Charge sheet has been filed.
Charge sheet format. Next.
35.
Speedy disposal. ಏನ್ ಕೇಳಿದಿರಾ?
Your quash the
Thanks,
charge sheet, your lordship.
I will only direct speedy disposal.
Your lordship, that
No
the-
quashing.
Directly, your lordship, that the proclamation directly issued summons without serving of summons, your lordship.
ಟ್ರಯಲ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ, ಕ್ವಾಶಿಂಗ್ ಎಲ್ಲ ಕೇಳ್ಬೇಡಿ. ವಾಟ್ ಇಸ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್?
Next date 30th, your lordship.
30th?
30th this month.
July 30th.
The petitioner is before the court seeking quashment of the entire proceedings and inter alia seeks quashment of the order of proclamation.
Settlement ಆಗಿದೆ ಚೆಕ್ ಕೇಸಲ್ಲಿ ದುಡ್ಡು
No
ಕೊಟ್ಟಿದ್ದಾರೆ.
problem. Proclamation. The learned counsel of the petitioner submits that the procedure that is to be followed for issuance of an order of proclamation is admittedly violated in the case at hand. In that light, the learned and would further submit that the next date of listing before the concerned court is 30th July. Therefore, the order of proclamation shall stand suspended, subject to the condition that the petitioner would appear before proclamation would stand revived automatically, and the concerned court is at liberty to pass necessary orders in accordance with law. With the aforesaid observations, petition stands disposed.
Petitioners, your lord.
Petition.
Two accused.
Petitioners,
Please.
yes.
Please.
36.
Please.
Notice.
7, kindly see, my lord, the allegation, lordship kindly appreciate page number 10. My lord, the from date 7/12/2024 to 3/2/2026. My lord, they have been taken action by the association as well as society. My lord, kindly see even they have issued notice also. They kindly see, your lordship may kindly see annexure C, my lord, dated 6/6/25 and 28/12/25. Then, my lord, the 9/6/25. My lord, thereafter, my lord, only with an vengeance, my lord, the respondent number 2 has lodged this complaint.
One, no, now, notice for now, we'll see. One HCGP, 2 emergent notice.
After taking 3
Well,
action,
emergent
my lord,
notice returnable by the 30th of July. We'll see on that day.
please.
Yes.
37.
In the meantime,
38.
split 22nd, split 22nd, yes, in the
39.
fresh matters.
PCR referred case, my lordship. PCR referred case, my lord. Offenses. Owner is a subsequent purchaser, my lordship.
In the meantime, next.
Please.
40.
OS number.
MA number 6 of 2020.
OS ಇಲ್ದೆ MA ಬಂತಾ?
Please, my lord. OS, there was a temporary injunction.
ಅದನ್ನ ಕೊಡಿ ಸರ್,
Please,
ನಂಬರ್
my lord.
ಕೇಳಿದ್ನಲ್ಲ.
1 of 2020.
1 of
2020, my lord.
2020.
2020.
MA.
MA 6 of 2022 and MA number 1 of 2020.
ಎಲ್ಲ ಒಂದೇ.
Please, my lord.
ಇದೇನು?
No, MA 6 of 2020. sir.
Correct, yes.
There's a writ petition also pending, my lord.
The suit ಯಾರ್ದು?
My lord, suit was filed by the petitioner, my lord. Respondent number 2, my lord.
Your lordship,
The-
charge sheet is in the scrutiny stage, your lordship.
ಅಲ್ಲೇ ಇಟ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಎಸ್, ಇದಕ್ಕೆಲ್ಲ ಸಿವಿಲ್ ಇದ್ರೂ ಪರವಾಗಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಕ್ರೂಟಿನಿ ಸ್ಟೇಜ್. The petitioner is before the court. Petitioners are before the court calling in question registration of a crime and crime number so and so for the offence is punishable under so and so. The second respondent institutes a suit, secures an interim injunction on an application order 39 rule 1 and 2. This is challenged by these petitioners in a miscellaneous appeal. The order is reversed. A writ petition is pending before the court. On all these facts, a criminal law is set into motion by the complainant on an issue that is purely civil in nature. In that light, there shall be an interim order civil in nature and as a counterblast to the miscellaneous appeal filed by these petitioners. In that light, there shall be an interim order. Next.
41. 14%.
The petitioner is before the court seeking the following prayer. The petitioner in person is before the court seeking the following prayer. The proceedings are of the year 2020. The petitioner in person would take this court through the documents appended to the petition to demonstrate that there is no progress in the case at all as on today and for the last 5 years What is granted is only adjournments. In the light of the said circumstance, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier, in accordance with law, ordered accordingly.
Deeply obliged.
Yes, next.
42,
My lords, for the
In the
petition.
meantime, next.
43,
Offense under 64, my lords.
Seriously, sir.
My lords,
No, no, no.
my lords, the allegation is that they met on Tinder.
Correct.
Dating site called Tinder, my lords.
Hmm.
They were, my lords, they were in a living relationship for about 6 months.
Hmm.
After 2 years, my lords, after separation of 2 years, now she is coming in filing a complaint.
Yes.
I'm placing your lordship's judgment on lords
Akash.
so far as Bumble.
Bumble Jagdal Tinder Akbaka.
Please, my lords.
The petitioner, the sole accused, is before the court, calling in question the statute ಆಗಿದೆಯಾ?
ಇಲ್ಲ, my lords.
ಇಲ್ಲ.
This is the
Calling in question registration of a crime in crime number 172 of 2026 for offense punishable under section 64 inter alia, 64(2)(n) inter alia, which is repeated rape. The petitioner and the complainant meet on Tinder in the month of March 2024. They are said to, the complaint itself narrates that they were in a live-in relationship for over 6 or 8 months, all of which happened in the year 2024. A complaint comes to be registered in the year 2026, i.e. on 15/4/2026, on the score that the petitioner is wanting to, you avoided her, huh?
Please, my lords.
The petitioner has stopped communication and is using only negative words against her, inter alia. Therefore, there shall be an interim order of stay. Next.
44,
May I request for a passover, my lords?
Huh?
May I request for a passover, my lords?
That's all.
45,
Please, my lords. Petition is accused number 6, please, my lord.
Wildlife.
Wildlife, my lords. Against allegation against this petitioner that his licensed .22 barrel gun, my lords, it has been used. Now, my lord, this is not a case for quashing, my lords. But, my lords, learned magistrate, when the evidence had commenced, my lords, he transfers commits the case to session judge on the ground that, my lord, the offense is triable by the session judge. My lord, if it's prohibited or, my lord, it's triable by session judge because punishment is up to life, my lords. In other cases, illegal use of the case is A6, though holding a licensed gun, he permitted A1 to take it to the wild forest, my lords, and used it. Now, my lord, this offense, my lords, is not punishable with the death or imprisonment for
ಈಗ
life.
ಅದು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ?
No, the committal order has request to be only the committal order.
No,
The trial had come.
Nothing will be stayed. Yes.
Your lords may kindly.
Heard the learned senior counsel PP Hegde appearing for the petitioner.
No, my
and
lords,
CGP is directed to accept
trial had
notice,
commenced.
and the SPP is directed to appear in the matter. List the matter on next Tuesday. Yes.
Please. Only on that ground, my lords.
That
Magistrate
ground
should have-
also is of no ground. We will answer it, don't worry.
As far as prohibited arms is
No
defined, my
problem.
lords.
They'll answer that also. It's an amalgam of offenses.
Please, my lord, your lords may kindly decide. The question is whether it's triable by magistrate or session judge.
No.
my lords. Trial had commenced, witness had been, I will submit.
No issues. No
Please. It's a fresh matter on the next day.
Yes.
Great.
Yes.
Is challenging summons under PMLA. Ordinarily.
Parent counsel Madhu N. Rao is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith Tuesday next, fresh matters.
Please, it's grateful.
Summons.
Plus, there's an exception carved out, my lords. There's an exception carved out.
Yes.
47,
Appearing for the petition in this case, my lords. Offense is under section 498A.
In the meantime, yes. PCR adake.
Initially, she files a complaint before the women's police station.
Sorry,
Notice have been
anyway.
issued.
Husband, one ನಿಮಿಷ.
Please, my lords.
ಕೊಡಿ ಇಲ್ಲಿ.
Page number 88 is the first complaint.
1 minute. 2, 3, 4, 5 stay. One illa. Next.
My lords, initially she files a complaint before the
ತೊಂದ್ರೆ ಇಲ್ಲ.
women's police station.
Yes,
She does
yes.
not appear for the counseling.
No
Thereafter, my lords, she files it.
Next.
48,
My lords, the complaint itself is not maintainable, my
That
lord.
will cease.
Please.
Emergency notice returnable by the 4th of August.
For the other accused persons.
Other accused stay.
Please.
2, 3, 4, 5 ಮಾತ್ರ ಅಷ್ಟೇ.
48.
I appear for the petition. My lord, for offense under Forest Act.
Rosewood. Rosewood ಇಲ್ಲೇ ಇಲ್ಲ ನೋಡಿ.
I'll take note.
It is
Current
only for
HCGP is directed to accept notice for the respondent. Again, SPP ಬರಕ್ ಹೇಳಿ. ಇದು Wildlife Forest Act, NDPS, all ask SPP to come. Next Wednesday, fresh matters.
49.
That's police inspectors issues an endorsement.
In the meantime.
50.
My lords, matrimonial dispute given a color of crime, my lords. My lords, on
Matrimonial
very,
dispute, a color of crime, page 25 to 27. Tomba
my lords, on
complaint.
very set of allegation, there's another FIR also filed, my lords,
We'll see.
before a different police station.
One HCGP, 2 emergent notice.
My lords, they,
Others yaru?
my lords, others are sisters, uncle, and then father of the petitioner, my lords.
Accused number 1 yaru?
Accused number 1 is the husband.
2, 3, 4, 5, 6. One ನಿಮಿಷ ಅದು ಬೇಡ wait.
My lords, on the very set of
No, no, no.
allegation,
Which
my
is
lords,
that?
there's another FIR.
Which is
filed,
that
my
ಕೊಡಿ?
lords. My lords, annexure L, my lords.
That is
LM
challenge?
My lords, she's a habitual complainant, my lords.
Wife
Her- Yes, my lords.
Wife habitual complainant.
Yes. My lords, there are other set of proceedings that are already closed, my lords. There was in fact a 498A case, my lords, in which the petitioner was acquitted, my lords. I'm placing that
When,
order.
when did you get married and when was this floundering?
My lords, marriage,
Marriage is 2020.
yes, my lords.
ಹಳೆ ಕಂಪ್ಲೇಂಟ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ ಮತ್ತೆ ನೀವು?
My lords, it's there, my lords. I produced
What
that
complaint is
annexure
that?
J.
85. What happened to this crime 55?
My lords, 55 is also pending, my lords. We have not challenged that.
Why?
My lords, we will challenge, my lords.
ಇದು ಸ್ಟೇ ಆದ್ಮೇಲೆ ಚಾಲೆಂಜ್ ಮಾಡೋಣ ಅಂತನಾ? ಹಂಗಾರೆ ಇದು ಕೊಡೋದೇ ಇಲ್ಲ.
My lords, in fact, there's another complaint filed by
The
accused.
petitioners are accused 1 to 6 for the very same period, on the very same allegations. Another crime in a different police station is registered in crime number 55 of 2026. The duration of the crime is 23/4/2025 to 19/3/2026. In the subject crime, again, the duration is 18/10/25 to 17/4/2026. Nothing new is stated except the new crime. Therefore, and the learned counsel submits that the said crime is pending investigation at the hands of the said police station. In that light, there shall be an interim order of stay of further investigation qua these petitioners in the subject crime. ಅದನ್ನ ತಗೊಂಬನ್ನಿ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. ಒಂದಾರ ನಡಿಬೇಕಲ್ಲ.
My lords, in fact, I was acquitted, my lords, recently.
Yes. Anyway, I've stayed this next week.
List number 2, hearing on IS, seal number 1.
Yes, sir.
I filed an impleading application.
Who are you?
Respondent number 3 sells the property through an respondent number 3 is impersonated and the property is sold to the petitioner. Property in turn sells it to me. Now a confirmation deed has been executed by respondent number 3 in my favor. So now
Who is the complainant?
Complainant is
I
respondent
made
number
the
3.
representation. I was impersonated.
You are impersonated.
I was impersonated. I made the
By whom?
by someone. I don't know who. Unknown person. And then under section 83, my lords, because it was a registered deed, I made a representation to the SRO. SRO has taken necessary steps to register the crime. Now, my lords,
Yes, sir. Adjournment ಬಿಟ್ಟು ಬೇರೆ ಅದೊಂದು ಬಿಟ್ಟು ಬೇರೆ ಏನಾರು ಹೇಳಿ. I am not going to grant a day's adjournment in this matters listed. ಬರ್ತಾ ಇಲ್ಲ ಅಂತ ಎಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ರು ಬರ್ತಾ ಇಲ್ಲ ಅಂತ. ಇನ್ಮೇಲೆ ಬೆಳಗ್ಗೆ ಹೊತ್ತು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ ತಕ್ಷಣ ಎಂಟ್ರಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇನೆ.
In this case,
No adjournment, no passover.
in this case, what transpired is confirmation deed was executed in my favor by respondent number 3. Subsequently, we have arrived at a settlement with the petitioner also.
Both of you.
Now, respondent number 3 is out of the picture because of the confirmation deed. Now, I am the only aggrieved party because I lost half of my land and
my lords, the impleading application, as far as my knowledge goes, is not allowed yet.
It is not allowed, it is pending. So since
Copy also
the,
has not been served.
since
on-
respondent number 4 is 77 years old, my lords, I could not secure his presence. Petitioner is also present. For which reason we may need.
But
some
let
time
the
to-
proceedings go on.
ಅಲ್ಲ, ನನಗೆ ಬರೀ
Then
notice.
purely civil and Allah.
I am not an accused, my lord. I
You are
also
not
a
an
victim.
accused.
I am also a victim. ನನಗೆ notice issue ಮಾಡಿದ್ದಾರೆ.
Notice challenge ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಬಂದ್ರಲ್ಲ.
Because the person
FIR.
impersonation has been ನನಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. So I myself is a
What's the
victim.
complaint ಅಂತ ಕೇಳಿದ್ದೀರಾ? ಹಂಗಾರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಡೀಲಿ.
Confirmation deed ಅಲ್ಲಿ ಅವರೇ
No,
ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ.
whatever, let the investigation go on.
Let request for a passover.
Investigation ನಡೀಲಿ. I will permit you to come after charge sheet if there is anything. The petitioner is before the court calling in question a FIR in crime number 193 of 2022 registered for an offense ಏನು? Prayer offense ಹಾಕಿಲ್ಲ.
Only
Page 25. Your third respondent?
Please, please.
The third respondent who has been impersonated in the case at hand, allegedly impersonated in the case at hand, registers a complaint before or information communicates to the second respondent sub-registrar, who in turn registers the subject crime. The learned counsel for the petitioner submits that the petitioner is also a victim of such impersonation. The learned counsel appearing for an impleading application is preferred by, who is that? What's name? Impleading application is preferred by so and so. It is the case of the impleading applicant that there is a confirmation deed executed by the third respondent in favor of the impleading applicant. Therefore, the third respondent must not have any grievance in the case at hand. Be that as it may, in the case at hand, who has impersonated whom is a matter that is required to be investigated into. The complaint is, the petitioner claims to be a victim. The third respondent claims that she has been impersonated. Therefore, the complaint is registered to the sub-registrar, who in turn has registered the complaint. In such cases, it is the investigation is imperative. Therefore, reserving liberty to the petitioner to knock at the doors of this court in the event a final report would be filed and the final report would go against the petitioner, the petition stands disposed, leaving open all the contentions. Both.
2.
Vacating stay?
Yes.
ಏನಿದು?
Not in 2018, a partnership.
No time, no adjournment, no passover.
Partnership firm is dissolved. A partnership firm is dissolved. On the cause of action that one of the partners' accounts were not settled, he invokes arbitration.
Did you have that arbitration case?
From 2018.
The other day he had appeared from his
Yes,
other case.
Yes, same. In 2018, the firm is dissolved. Arbitration is invoked. On the cause of action that his accounts are not settled, he files a claim. Now in 2021, 3 years after the arbitration has commenced and is going on, he files a criminal complaint on the same allegations that his accounts are not settled. Investigation 200 complaint is filed, 156(3) reference, investigated, B report filed. On that B report, a protest petition is filed, not against that, cognizance is taken. In his 200 complaint, he specifically says that because my accounts are not settled, I'm filing this criminal complaint. No, your lordship will get that at page 419.
Complaint, huh?
No. He's 200 complaint. Yes, ma'am.
Oh, that's what.
419. 3 years later, after the arbitration has commenced.
One moment. I'm at 419.
419, Lord. At para 41, it is submitted that admittedly civil petition is pending, that is arbitration. In the said civil litigation, accused number 1 and 2 had requested the complainant not to initiate any other legal proceedings against them, since the same would hamper the settlement. Further, accused number 1 and 2 also requested the complainant not to initiate any criminal action and that they would settle his accounts. And further, had requested the complainant to consider the relationship. However, they failed in their promise of settlement. and it appears that it was their plan to deviate from the complainant from initiating criminal legal proceedings against them. Thus, the complainant herein being induced by the words and promises of accused number 1 did not initiate any further criminal action, and hence there is delay. However, since they have continued their illegality, which has necessitated the complaint to initiate the above proceedings. So, note this complaint is filed in 2021. 2018, arbitration is invoked. 20 prayers are sought for settlement of accounts. In 2021, for the first time, this complaint is for.
Where is the arbitration proceeding? Where in the arbitration?
That arbitration proceedings has now been reserved for judgment after 8 years. That my learned friend will not dispute.
Where is the prayer?
My lord,
Arbitration.
I am sorry to interfere. Just your lordship kindly turn to page.
Wait, sir. ನಿಮ್ಮ ಅವ್ರು ಕೇಳ್ತಾ ನಿಮ್ಗೆ ಕೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
ಬೇಕಾಗೋದಿಲ್ಲ ಅದೆಲ್ಲ ಯಾಕೆ ಅಂದ್ರೆ
ಅಲೋ ಮಾಡ್ಬೋದಾಗಾರೆ?
ಅಲ್ಲ
ಅಲೋ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ತಾಳ್ಮೆ.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದೀನಿ ಅಂದ್ರೆ
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇಲ್ಲ.
ಬಿ ರಿಪೋರ್ಟ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ.
So what?
No, my B report, rather my one number submission.
So
Lordship, kindly turn to complaint. This is for only not wasting the time of the court. Otherwise, I wouldn't have interfered. What has happened? B report.
Let him finish. Wait.
Please.
Yes, ma'am. Your lordship will ask where's the amended claim petition that your lordship will find at annexure E. Sorry, annexure D, my lord, page 53 to 123 is the claim petition which is filed in the year
53 to?
Sorry?
Page?
Page 53 to 123.
ಯಾವ್ದು ಎಲ್ಲಿದೆ? No, where do I get it here?
Lord, page 53 to 123. Your lordships have criminal petition 4215, no?
No. 8419.
4215. I'm giving reference here. 4215. That is the 2021.
84. Correct.
Yes, 4215. Page 53. It begins. This is the claim statement filed by Nitin Kanji Shah.
One moment.
Lord, your lordship will find the prayers. Prayers begin at page 118. There are 21 prayers that are asked before this arbitral tribunal. Then in 2021, he files his complaint.
No. 21 prayers ಅಲ್ಲಿ identical claim ಎಲ್ಲಿದೆ?
Yella same. I have produced in my criminal petition. Whatever is his claim petition is a copy paste in the complaint, 2D complaint. The 2D complaint runs into some 30 pages. Now the 2D complaint, no cognizance is taken on that complaint. A 156(3) reference is ordered. Police investigate, file a B report. On that B report, he files a protest petition. Cognizance is taken on that. I have challenged that and come before your lordship. To say that there is a B report, therefore there is maintenance. Therefore,
you finish your submission.
Yes, Lord. Prayer your lordship will find at page 66. Watch the order dated 27/12/2023 in PCR passed by learned rejecting the B report. My prayer is at page
60.
Sorry, not that is in
66. Sir.
Alla 8419 ಅಲ್ಲಿ ಇದೆ.
ಅದರಲ್ಲಿ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಇದೆ. Both prayers not essentially are to set aside the rejection of the B report.
8419 ಇಲ್ಲಿದೆ.
8419
ಇದು
66 ಇತಾನೆ?
Correct. Page 66 correct.
Page 66 in 8419.
One moment. 66 is the prayer.
Order on B report, your lordship gets at page 74. What is impugned? May I read it not with your lordship?
Not necessary. Wait.
Complaint. Yes.
B
I'm going to show your lordship's page 75. Just please see para 2. IO registered the FIR in crime number so and so, investigated the matter, submitted B report. In the B report, IO submitted that the case is civil in nature, hence offence is not attracted. On perusal of the B report, wherein he disclosed that the accused are partners and directors of the company and father of the complainant was one of the partner, accused have removed the father of the complainant from the partnership, but whether amount of investment returned or not is not disclosed. And therefore, Lord, he has taken cognizance, rejected a full-blown police investigate, and from 5 years this has been pending and used as leverage in the arbitration, saying we will send you to jail in that criminal petition. All throughout it has been stayed. So, Lord, in
what are the I saw in the pleading?
Yes, ma'am.
In this 2025, what are these cases filed?
2025, there are.
Alla,
Yes,
then so many FIRs you have listed here in,
yes, ma'am. Each
what
one,
are these?
each one filing cases against the other. saying
Against
you
each other.
Trespass, he went and filed a complaint saying you stole this, you stole that, everything filed, joint memo filed and everything settled and withdrawn.
Oh,
Quashed.
fine.
6
Yes.
FIRs which were joint memo filed and quashed. This is the only one that remains. My
Alright.
learned senior's argument is that B report is filed, how can you challenge it?
That we'll see.
At
Let
page
him argue.
70
Why are you worried?
At page 76, B report is rejected. Against that, I've come.
Yes.
Please, Manoj. So
Yes,
let's
sir.
kindly turn to page 66 to make matters very simple.
Very simple.
Very
Yes,
simple.
Yes, sir.
Because he has no locus standi to challenge this
Ah.
before the summons is issued.
Oh. Hmm.
Your lordship, in many cases I have held,
Yes, sir.
after the completion of protest petition,
Hmm.
and then after following the procedure, once summons is issued,
Hmm.
then locus standi will be there for the accused to challenge.
Hmm.
ಇಲ್ಲಿ summons issue ಆಗಿಲ್ಲ ಇನ್ನ.
Ayyo. Hmm.
That's the only short point which this matter has to be rejected, my lord, without going to the merits of the case.
Hmm.
On technicalities, therefore, lordship, may kindly turn to page 66.
Hmm.
Prayer.
Yeah, I'm there, sir.
Please, my lord. Quash FIR bearing so and so this against petitioners by first respondent. There is no FIR is merged in the report.
Hmm.
Next, quash the order dated 27/12/23 in PCR number so and so, passed by the learned third ACMM magistrate, rejecting B report filed by first respondent.
What has happened after that?
And 24 ಇಲ್ಲ 24/9/25.
After this order, 18/4 order ಆದ್ಮೇಲೆ.
We challenge it, there's a stay pending from 21 all the time. all the time.
ಇಲ್ಲ
ಅಲ್ಲ ಇದು
24/9/25 ಅಲ್ಲಿ summons issue ಮಾಡಿದೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ
24/9/25 ಎಲ್ಲಿದೆ?
ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಅವ್ರು ಅದಕ್ಕೆ ನಾವು ಮುಂಚೆನೇ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಅದು?
ಅದು ಕೊಟ್ಟಿಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ.
There are 2 petitions.
ಸಮನ್ಸ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
ಇದಕ್ಕೆ ಬರ್ಲಿ ಈಗ.
There are 2 petitions.
Correct. One is of 21.
By the shareholders. Another is by directors.
Hmm.
So therefore, my lord, both were filed at different points of time in respect of both.
No, where is the order issuing summons?
I just ನೀವು ಕೊಟ್ಟಬೇಕಿತ್ತು ಇರ್ಲಿ. Therefore, ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಅವರು. ನಾಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ರಿಜೆಕ್ಟಿಂಗ್ ಬಿ ರಿಪೋರ್ಟ್. ರವಿಕುಮಾರ್ ತಮ್ಮದೇ ಒಂದು ಎಷ್ಟೋ ಜಜ್ಮೆಂಟ್ಸ್ ಇದೆ.
ಈಗ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ ತೊಂದ್ರೆ.
ಇಲ್ಲ ಅದು ಆನ್ ದಿಸ್ ದೇ ಕ್ಯಾನಾಟ್, ದೇ ಹ್ಯಾವ್ ಟು ಚಾಲೆಂಜ್ ದಿಸ್.
ಇದು ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ತಾರೆ ನಾಳೆಗೆ.
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ ಅದು.
ಇದು
ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಬರಲ್ಲ, ಫ್ರೆಶ್ ಹಾಕೊಂಡ್ ಬರ್ಲಿ. Then I know on merits I'm not getting to it.
You want to please get into merits also.
Well, merits will take quite some time. That's not
No
an issue.
time, sir. No merits.
No,
I will
this
answer.
also
I will answer it in 5 minutes.
So far as this is
Please do it.
concerned,
Yes.
You also may kindly see in 1963.
Allah, you can't simultaneously set the criminal law into motion at your whim and fancy.
No. That I will justify. That I will justify.
Yeah, absolutely.
Well, in 63 Supreme Court.
Code is 63. Yeah, why should we go back so much?
ಅಲ್ಲ ಹಾಗೆ ಇದೆ ಅದು.
Cody sir.
My lord, once, as your lordships have held in many cases, a protest petition is nothing in the nature of 200, my lord, a complaint. There is no doubt on that. In that view of the matter, my lord, the entire scheme of chapter 16 of the CRPC shows that an accused person does not come into picture at all till process is issued. Here, process is not issued. Therefore, on this ground, this complaint has to go.
When was the summons issued?
29/4 ಅಲ್ಲಿ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಟ್ಟು
29/4.
ಒಂದು ನಿಮಿಷ ಕೊಟ್ಟೆ. 27/12/23.
When was the interim order
24.
granted?
Interim order ಯಾವಾಗ?
Interim order ಯಾವಾಗ stay?
8419. It is before that only, according to me. Because
How did he issue summons after
That
stay?
I am not aware.
Stay.
Stay I do not aware.
No problem.
Stay ಯಾವಾಗ ಆಯ್ತು
Where
ಗೊತ್ತಿಲ್ಲ.
is
Whether it
the
is
date of the interim order?
Lordship,
whether it was informed to the honorable court also, I do not know.
No. Yes.
That I do not.
15 July 2025.
25.
ಅದರಲ್ಲಿ 21 ನಲ್ಲಿ
21 ಅಲ್ಲಿ we have not even challenged 21 petition ಅಲ್ಲಿ.
interim order. So interim order is before the summons, after this.
Yes, much before summons is in 25. I've got an interim order in 21.
That is what I'm asking. Date.
Date of interim order, not NOC, my lord, I'm sorry.
But that was by one of the
19/4/2021.
19/4.
19/4/2021, we had challenged that order before the High Court.
1 minute. So 19/4/21 interim order is granted.
19/4/2021,
B report is rejected, we challenge it. The interim order is given at some point in 21. I'll just clarify that now.
What, it is in 21 definitely.
One definitely.
No, whether is, so far as the petitioner is concerned, I'm sorry for the cross talk.
Now, if interim order is operating on the order rejecting the B report, how did the court issue summons?
That I have to clarify. I don't have detail. That I will give the detail. By noon or
From
tomorrow.
21, there is a stay.
No.
If there is a stay,
True, my lord.
how
That
did
I-
the magistrate
Could
issue
not have.
summons?
Could not have.
So it
I
is
agree.
void.
True, my lord. That I agree. But I do not know whether it is, of course, I cannot say that I don't know.
Merits,
I will look into
submit on
that.
merits.
I will look into that. No, merits, I will come to that later.
ಹೇಳಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ಆ ಗ್ರೌಂಡ್ ಹೋಯ್ತು ಈಗ.
Yeah, ಇಲ್ಲ,
ಸಮನ್ಸ್ ನ
ಇಲ್ಲ.
ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ಅಂತ.
Hard copy note
ಸಮನ್ಸ್
ಬೇಕಾದ್ರೆ.
ಇಶ್ಯೂನೇ ಮಾಡೋಗಿರ್ಲಿಲ್ಲ ಆಮೇಲೆ.
That's correct. But
Yes.
whether is it for insofar as the petitioner?
Next.
29/6/21, a detailed interim order is passed.
ಏನ್ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್?
ಇಲ್ಲ, ಸುಮ್ನೆ ನೀರು ಕುಡಿಬೇಕಿತ್ತು.
ನೀರ್ ಕೊಡಿ, ಕೊಡಿ ಮೇಡಮ್.
ಇಲ್ಲ, ಬಂತು.
ಮೇಡಮ್, ಬಾಟಲ್ ನೀರ್ ಕೊಡಿ.
ಬೆಂಗಳೂರವ್ರು ಅವ್ರು. So I've taken an antibiotic.
Antihistamine?
Antihistamine, so dryness of mouth, cold.
ಇದೆಯಾ?
ಇದೆ.
ಇದೆ.
My lord, I'm handicapped with that other order. Your lordship, with kind permission, if I have a look at that, I think I make some submissions. Because so far as one petition is concerned, it is clear that they could not have come here.
In so far as
Very clear, it is
Now,
very clear.
1 minute. You, Angad, prepare dates and events.
No, your lordship.
Tomorrow I'll take it.
4/3/2026.
ನೀವು ಅಷ್ಟೇ, whatever you want.
If it is there, it is there. I have no defense so far as that ground is concerned.
If stay is there.
Yes, I have no ground.
It is immaterial whether they have challenged summons or not, because summons could not have been issued at all.
Yes, my lord.
Even otherwise, that is only in respect of 8419. In so far as 4 to
That
15.
we'll answer it on
4 to 19
merits
means
tomorrow.
It is his petition.
Tomorrow.
8419, he could not have.
A list of dates and events tomorrow. Yes. Heard the learned counsel Angad Kamath appearing for the petitioner and the counsel S. Mahesh representing the complainant. List tomorrow in the same stage.
Whatever.
And tomorrow no time.
ಇಲ್ಲ ಇಲ್ಲ, ಇವತ್ತು ಟೈಮ್ ತಗೋತಾ ಇಲ್ಲ. ಈ
ಅಲ್ಲ,
stay
ಇವತ್ತು
ಒಂದು-
ಅದೆಲ್ಲ
stay ಒಂದು clarify
ರೆಕಾರ್ಡ್ಸ್ ಜಂಬಲ್ ಆಗಿದೆ. Let it be in line.
Yes, very well.
Lord, I am the petitioner and party in person.
Petition party in person ಮತ್ತೆ ಹೌದು ಬ್ಯಾಂಡ್.
I have another matter there. I am
Ah.
not able to change in that.
Ah. Oh. So you want to change and come or go and change?
That's why I am wearing the robes.
Then we'll take it whenever you're free.
Please, my lords.
You're getting stay ಹಾಕಿದ್ದೀರಾ?
No, my lords.
Then by special order.
These 4 IAs are filed by me, my lords. One is seeking for production of additional
No,
documents.
party in person, you can't do this. Method ಇಲ್ಲ ಆಮೇಲೆ. Oh, is there an application seeking vacation of the interim order?
No, my lords. The short
Then
question.
why is it come?
It's for consideration of IAS before.
What
the
IS? Additional documents, amendment, production of documents, stay ಇದೆಯಾ? ಇದೆಯಲ್ಲ? There is already an order granting IA 4 of 25 for stay, what stay?
My lords,
There is already an interim order operating in the case at hand. All the other applications would be considered along with the main matter. List the matter on next Tuesday, same stage. Interim order subsisting will continue till the next date of hearing. Yes.
Lord, my application for alteration of charge has been rejected by the trial court.
That stayed here, is it?
It is.
Is an interim order stay?
Yes, ma'am.
Who filed application to alter?
I filed the application. I am for the accused. Lord, the Lokayukta filed a charge sheet alleging
come ನೀವು? ಅಲ್ಲ.
I am for the ED.
ED. Lord, the Lokayukta filed the charge sheet alleging disproportionate asset to the extent of 1,79 lakhs. Different properties are listed. And after trial, my lord, the trial court concluded that the disproportionate asset is only to the extent of 42,48,188. Other properties are left out. Lord, in the main case, the petitioner is the accused, and in the PMLA, his daughter is also added as an accused. To lordship may kindly see, page 61 is the charge. in the PMLA,
Hmm.
Lord, charge is framed based on the properties. Now several properties are dropped from the charge. I filed an application for alteration of the charge
In
in
PMLA.
in PMLA.
Hmm.
Restrict the charge to the extent of the proceeds of the crime concluded in the main case.
Proceeds of crime is not concluded.
Concluded, and because I have been convicted for 42 lakhs.
Convicted.
Convicted for 42 lakhs.
Hmm.
Now my submission to the trial court is,
Hmm.
the charge has to be altered
Hmm.
because the original charge is for 179, including several properties.
Hmm.
Now the charge has to be specific and they have to restrict the charge to the properties which are convicted, because in the main case, there is some ambiguity. That is why I requested the trial court to frame the specific charge so that matter can be proceeded. Now the trial court passes an order that the smaller amount also it can convict. It is not the question of amount. Like it is, your lordship very well know, Lord, in the DA case, it is a blended asset, both legally earned and illegally earned. Finally, it is concluded that the extent of illegal earning is only 42 lakhs. Now they will have to specify the properties. Therefore, I requested for alteration of charge. But trial court refers to section 222 and subclause 2, where the section says the accused can be convicted after charging for the major offense and minor offenses. It can be the conviction is possible for minor offense. Here there is no different offense. I am only asking the trial court to clarify the charge with respect to the properties. Offense is same. Because your lordship may kindly have a look at the charge framed by the trial court. It is based on the property. Now that will have to be amended to give clarity to the charge. Page 61. 61 and 64. 64 in respect of A2 and 61 in respect of A1. Therefore, my submission is, Lord, the understanding of the trial court is wrong.
Yes, sir.
No, I don't mind confining it to. I want the trial to go on.
With the adoption, ಅದಕ್ಕೆ stay ಆಗಿದೆಯಾ?
ಅದಕ್ಕೆ ಅಷ್ಟೇ.
Lord, for them it may not be big issue. For me, because
We will permit alteration of charge. Trial will go on.
yes, Lord, trial will go.
The petitioner is before the court calling in question an order of the concerned court dated 27/2/2025 by which an application filed by the petitioner seeking alteration of charge as obtaining under section 216 of the CRPC comes to be rejected. The petitioner heard the learned counsel R. Nagendra Nayak appearing for the petitioner, learned Additional Solicitor General of India, Shri Arvind Kamath, representing the Enforcement Directorate. Facts enumerated are as follows. The petitioner gets embroiled in a crime, in crime number 16 of 2009 for offences punishable under section 13(1)(e) read with 13(2) of the Prevention of Corruption Act, hereinafter referred to as the Act for short. The police conduct investigation and file a charge sheet before the concerned court in the said offence. The issue does not relate to the offence under the offence that emanated from crime in crime number 16 of 2009. The Enforcement Directorate register an enforcement case information report and file their complaint before the concerned court. The concerned court then register special CC 357 of 2016 for offences punishable under section 3 and 4 of the Prevention of Money Laundering Act 2002, hereinafter referred to as the PMLA for short. The petitioner then gets convicted in the predicate offence, the offence that emanated from in crime number 16 of 2009, in terms of the order of the concerned court dated 8/11/2024. The pursuant to the conviction, in the said order of conviction, the disproportionate assets which the petitioner could not explain is restricted to 42,48,188.50. The petitioner then files an application before the special court in special CC 357 of 2016, which was trying the offence under the prevention of under the PMLA. for alteration of charge to restrict the charge to the said amount of disproportionate assets that was found in which he was convicted. The said application comes to be rejected, rejection of which has driven the petitioner to this court in the subject petition. The learned counsel R. Nagendra Nayak, taking this court to the order of conviction, contends that the petitioner has been convicted for being unable to satisfactorily account for assets of the said amount 42, 48, 188.50. Therefore, the PMLA now cannot proceed beyond that, and he sought alteration of the charge that ought to have been permitted. The learned additional solicitor general, though would refute the submissions, would contend that the trial must go on. The trial is now stayed or is languishing before the special court for the last 10 years. In that light, he would leave the discretion to the hands of the court. In the light of the aforesaid submission and contra submission, the only issue is whether the application filed by the petitioner did merit consideration at the hands of the concerned court, resulting in alteration of charge. The afore narrated facts, dates, link in the chain of events are all a matter of record which would not require any iteration. It would suffice to notice the order of conviction of the petitioner. The petitioner gets convicted on the following reasons, page 200 to 202. He is convicted for the reason that the petitioner has failed to satisfactorily account for his assets worth 42, 48, 188.50. And the disproportionate known source of income is projected at 97.75%. The ostensibly so, the proceeding before the special court under the PMLA traveled far beyond that, as the conviction comes about at a later point in time. In that light, the application filed by the petitioner under section 216 of the CRPC before the concerned court ought to have merited favorable consideration at its hands. The court has erred in the reason so rendered by the court while rejecting the application is on the face of it untenable. In that light, the application so filed by the petitioner to bring the charge in the special CC 357 of 2016 on par with the conviction merits acceptance. In that light, the petition stands allowed. The petition stands allowed. The order dated so and so stands quashed. The application filed by the petitioner stands allowed. The concerned court shall now alter the charge and try the petitioner for the aforesaid disproportionate asset. Since the trial is of the year, the special CC is of the year 2016, I deem it appropriate to infuse finality and direct the concerned court to conclude the proceeding.
Argument stage ಅಲ್ಲಿ.
Conclude the proceedings in outer limit of 3 months from the date of receipt of the copy of the order.
I'm ready for this.
ಸುಮ್ಮನೆ ಇನ್ನೊಂದು ವರ್ಷ ಇರುತ್ತೆ.
Number 5.
Okay,
13 7
13.
13(1)(b). Here in everything has been done in accordance with the circular.
Preliminary inquiry ಮಾಡಿದ್ದೀರಾ?
By the SP, yes, ma'am. FIR is registered by SP. Everything is done.
PE also done?
P also done.
Yes, sir.
Lords, I fall into the category, your lordship was pleased to allow Lord Sarfaraz Khan recently.
ಅದು PE ಮಾಡಿರಲಿಲ್ಲ ಅದರಲ್ಲಿ.
ಅಲ್ಲ, Lords, your lordship may kindly give a passover, Lords, my senior will.
ಅದರಲ್ಲಿ PE ಮಾಡಿರಲಿಲ್ಲ.
And request for a passover, Lords.
Pass. Yes. Yes.
Still number 6.
Objections ಹಾಕಿದ್ದೀರಾ ಆರ್ಭಟಿ ಸರ್?
Yes, ma'am. Vacating stay also.
ಸ್ಟೇನು ಇದೆಯಾ? 13 ಅಲ್ಲಿ. My order.
Yes, my lord. And subsequently, my lord, service condition also, my lords were pleased to, but in view of the service conditions, some DPC, my lord, sealed cover it was put. At about 4:30, my lord, end of the day, my lord, Learned Counsel for petitioner made submission, and your lordship protected the interest of the petitioner.
Order of application. I will see. Promotion ಕೊಟ್ಟಿದ್ದಾರಾ ಈಗ? Yes.
6.
Well, it's a complaint of fraud and misrepresentation, my lords. But the petitioners herein are the
parents of the accused number one. My lords, in the complaint, the allegations
One
against.
minute, what's your name? Kavya, la?
Kav-
Kavya madam, what is all this in a rectification?
Well, regarding the process, it has been rectified, my lords. IA number one of
Dispensation, you know,
certified copy.
dispensation for the reasons indicated allowed. Next and rectification of process fee. Learned counsel of the petitioner submits that needful has been done, office to verify. Now you tell me merits.
My lords, the complaint is for fraud and representation, misrepresentation of the sale deed of the year 2018. My vendor has filed a complaint in the year 2025 implicating the accused number one, who is the original purchaser. That is my son. Accused number 2 and 3 are parents. Accused number 4 is my wife, my lords. This current petition has been filed by accused number 2 and 3.
4 ilwala illi?
4 idralilla, ಇನ್ನೊಂದು petition ಇದೆ.
ಇನ್ನೊಂದಿದೆಯಾ? ಕೊಡಿ ಅದು ಟ್ಯಾಗ್ ಮಾಡೋಣ.
Please. My lords, criminal writ number.
Number ಕೊಡಿ. Heard the learned counsel Kavya appearing for the petitioner. The learned counsel submits that accused number 2, 3 and 4 have filed petitions calling in question the registration of a complaint. Charge sheet agilala?
Charge sheet agilala.
Registration of a complaint. The fulcrum of the list revolves around a particular sale deed executed by the petitioner's vendor in favor of accused number 1. Therefore, the allegation is between the controversy is between the complainant and the accused number 1 without any rhyme or reason. The wife and children, a wife and the parents have been drawn only because their names, name idea sale deed alli?
Please, ma'am.
Only because their names
Sale deed
figure.
alli illa, my lords. There is
Illa
no.
alva?
They have also filed a OS in the
That's
year
all right.
2020.
Only because they are the parents of parents and wife of accused number 1.
Sir.
Not apart from this, the learned counsel submits that a suit is also preferred on the same cause of action. In that light, tag this petition along with so and so. Interim order subsisting shall continue till the next date of hearing. List 4 weeks between date. Yes.
Obliged.
Notice ಆಗಿಲ್ವಾ respondent ಗೆ complainant ಗೆ ಆಗಿಲ್ವಲ್ಲ?
ಆಗಿದೆ.
Emergent notice to the second respondent complainant.
12/5. On 12/5 it is.
Vacation bench ಅಲ್ಲ?
Please.
Notice ಆದಂಗೆ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿ, ಆಗಿದ್ರೆ post after 4 weeks. Yes.
Grateful.
11th August. Memo for withdrawal.
Orders. Still number 7,
Withdrawal.
still number 8.
ಏನ್ ಪಾಟೀಲ್ ಇದು?
There is dereliction of duty, my lords.
13.
Please, 13(1)(e). Now, there is, my lords, an inquiry that is initiated saying there have been certain tampering and certain insertions in the revenue records, thereby grants have been fabricated as such. Now, the main plank of their argument, my lords, is that there has been a departmental inquiry wherein they have.
Exoneration.
I would disagree, my lords. It's not per se an exoneration. There is censuring per se. He's been censured, which means there is some form of liability attributed to him, but it doesn't deserve punishment in that magnitude as such.
If it doesn't deserve any punishment as enumerated under the KCS CCA, it does deserve a criminal proceeding.
My lords,
Disproportionate asset ಆದ್ರೆ ಹೇಳಿ ಅಥವಾ 7A ಆದ್ರೆ ಹೇಳಿ, ಅದರಲ್ಲಿ ಮಾಡಿದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ನಥಿಂಗ್. Dereliction of duty is the crime, correct?
but censuring is there, no, my lord. Of argument is that the Chandrasekhar judgment, it has been conducted by a local authority there. It is not conducted by the Lokayukta as such. So in a 482 jurisdiction.
ಅದು 13.
Please, either which ways, my lords, the departmental inquiry having any implications as such on the criminal
So
proceedings.
even
is something-
in Chandrasekhar in the peculiar facts ಅಂತ ಬರ್ದಿರೋದು, ನಾನೇ ಅದನ್ನ ಬರ್ದಿದ್ದೀನಿ ಅದರಲ್ಲಿ. ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ ಅಪಿಯರ್ ಆಗಿದ್ರಲ್ಲಿ ನಾನು ಬರ್ದಿದ್ದೀನಿ.
No, I have this judgment here, Chandrasekhar.
26.
Please, my lords, 2026. What it says
Yeah,
is,
page number. SCC online.
please, my lord, SCC online.
Page ಏನು?
Lords, 26 page number is not there.
ಅದು page number 26.
starts at 13, my lords.
Anyway, yes.
My
13 is-
apologies, my lords.
No problem. But that would not be completely applicable. Anyway, it's in orders. We'll post it in admission.
Please.
Interim order ಇದೆಯಾ?
The draft charge sheet is ready. I've already filed it as a part of my statement of objection.
Recently, my lord, the honorable court has, my lord, as per the allegation, my lord, we have created the records. As against which, my lord, the government has passed the order for cancellation of the revenue entries. The state as well as the owner have challenged that order, my lord. Ultimately, my lord, the writ petition came to be allowed, filed by the owner of the land. And the writ petition dismissed by the state, upholding the grant made by the original owners.
Lords, this is on the ground that after 5 decades you can't wrap it up or you can't open it. But that would be on the benefit of there being an undue delay in taking initiative.
The government also, my lord, withdraw the complaint against the officer. These two petitioners only case worker, my lord, all the DDLR, Tahsildar and all withdraw the government, my lord. These two people are the case workers.
Objection ಹಾಕಿರಲ್ಲ?
Detail ಆಗಿ ಹಾಕಿ.
ಮುಗಿಸ್ಬಿಡೋಣ. Yes. Orders ಅಲ್ಲಿ ಬಂದಿದೆಯಾ?
Orders ಅಲ್ಲಿ ಬಂದಿದೆ.
Office objections. List the matter. Vacating stay ಹಾಕಿದ್ದೀರಾ?
Vacating stay ಇಲ್ಲ.
List the matter on ಯಾವ ವರ್ಷದ 24. Next Wednesday in the fresh matters list. We'll dispose it.
Lords, this judgment I would say is not on the ground that there is no crime as such. It is after a lapse of about 5 decades you can't open.
ಈಗ ಯಾರು ಬಿಟ್ಟಿದ್ದಾರೆ?
Tahsildar, DDLR and surveyor.
ಅವರೆಲ್ಲರ ಮೇಲೂ ಕ್ರೈಮ್ ಹಾಕ್ತೀರಾ? ಅವರೆಲ್ಲರ ಮೇಲೂ ಕ್ರೈಮ್ ಹಾಕ್ತೀರಾ ಅಂತ? DDLR ಮೇಲೆ, ತಹಸೀಲ್ದಾರ್ ಮೇಲೆ.
We'll file the charge sheet. If there is
No.
further investigation.
ಅವೆಲ್ಲ ಇಲ್ವೇ nothing. You register separate crime against them if you want to. ತಹಸೀಲ್ದಾರ್ನ, DDLR ನ ಆಮೇಲೆ you file that saying that we will register separate crime against them, don't leave these people. If you have left the big fish, we will not permit the small fish to suffer.
It's first to find out which fish has done the mistake.
ಆಗೋಯ್ತಲ್ಲ, ಫಿಶ್ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಇದೆ, ಆರ್ಡರ್ ಇದೆ. ಬಿಗ್ ಫಿಶ್ ಯಾರು ಅಂತ ಗೊತ್ತು ಅಲ್ಲ, ಬಿಗ್ ಫಿಶ್ ಯಾರು ಅಂತ ಗೊತ್ತು. DDLR ನ ತಹಸೀಲ್ದಾರ್ನ ಬಿಟ್ರೆ ಅದು ಯಾರು ಕೇಸ್ ವರ್ಕರ್ ಬರ್ದಿರೋದನ್ನ ಇಟ್ಕೊಂಡು ಆಟ ಆಡಿಸ್ತಾ ಇದ್ದೀರಾ ಈಗ.
I will secure instructions, my lords. I'll secure instructions to what my lords have pointed
Correct. In an aquarium, if one fish stinks, every fish will begin to stink. That's a different thing. But you should catch hold of big fish. ಅವ್ರನ್ನೆಲ್ಲ ಬಿಟ್ಟು ಕೇಸ್ ವರ್ಕರ್ ಕರ್ಕೊಂಡ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ?
No, ಈಗ ಇನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿಲ್ಲ.
Generally, crime ಆದ್ರು sir, crime ಆದ್ರು, you tell me. If you have left the person who has taken a decision, you have caught hold of the person who has written the decision.
ಇಲ್ಲ, ಇವಂದು ಏನ್ ಲಯಬಿಲಿಟಿ ಇದೆ ನಾನು ಅದನ್ನ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀನಿ ಡ್ರಾಫ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. Whether that is not written the decision. My lords may please take my statement of objection. ಅದರಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ every one of them what they have done we have pointed out.
13(1)D ಅದರೆಲ್ಲ ಗಲಾಟೆ ಮಾಡಿ ತೊಂದರೆ ಇಲ್ಲ. ಇದರಲ್ಲಿ ಯಾಕೆ?
Page number 67.
And if the court has accepted the landowner's plea and held that the grant is correct, what is the allegation?
The grant is correct not on its propriety, not on saying that these are not fabricated documents, because in a writ court you couldn't have given a fact finding.
ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, 40 ವರ್ಷ ಡಿಲೇ ಆದ್ಮೇಲೆ you can't rack it up ಅಂತ ಹೇಳ್ತಾರೆ.
ಓ, ಇನ್ನೂ ವರ್ಷ ಅದ್ರ ಮೇಲೆ ಹಾಕಿದಿರಾ ಈಗ?
ಇಲ್ಲ, ಇವಾಗ ಬಂದಿದೆ ನಮ್ದು.
1960 grant.
60 ಅಲ್ಲ, 60 grant ಅಲ್ಲ.
Makes my job easy.
No, my lords, I'll just clarify. I understand my lords coming to a conclusion.
ಕೇಸ್ ವರ್ಕರ್ ನ್ಯಾಗ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ
ಅವನ ಹೆಸರನ್ನ 60s ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಬ್ಯಾಕ್ ಎಂಟ್ರಿ ಮಾಡಿ ಹಾಕ್ತಾರೆ ಅಂತ ನಮ್ಮ ಅಲಿಗೇಷನ್. ನಾಟ್ ದಟ್ ಇಟ್ ವಾಸ್ ಗ್ರಾಂಟೆಡ್ ಇನ್ 60 per se. ಅದರಲ್ಲಿ ಡಿಸ್ಕ್ರಿಪೆನ್ಸೀಸ್ ಇವೆ ಅಂತ ನಮ್ಮ ರಿಪೋರ್ಟ್ ಹೇಳುತ್ತೆ.
ಅಂಡ್ ಸೆನ್ಶ್ಯೂರ್ ಮಾಡಿದಾರಲ್ಲ.
ಅಂಡ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಂಕ್ವೈರಿ
ಅವ್ರ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಂಕ್ವೈರಿ ಮಾಡಿದ್ರ? DDLR, ತಹಸೀಲ್ದಾರ್?
ಲಾರ್ಡ್ಸ್, ಇವ್ರು ಹಾಕಿರೋ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎಂಕ್ವೈರಿ ನೋಡಿದೀನಿ ನಾನು. ನಮ್ಮಲ್ಲಿ ಲೋಕಾಯುಕ್ತದಲ್ಲಿ ಯಾರ್ದ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಅಲ್ಲ, ಕರೆಕ್ಟ್, ಅವ್ರ ಮೇಲೆ ಮಾಡಿದವರ ಇಲ್ವೋ ಯಾರಿಗೂ ಗೊತ್ತು.
One of them has passed away. ಅದನ್ನು ಹೇಳ್ತಾರೆ. I'll just read out one.
ಯಾರು passed away?
One of the, ಅದಕ್ಕೆ ಯಾರು ಬಿಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ. See 166, my lords, may please see. It says
nothing. We'll see next Wednesday. We'll close it on that. Close it ಅಷ್ಟೇ. ಯಾವ ತರ ಗೊತ್ತಿಲ್ಲ.
I understand. No, I'll leave it to my lords. My lords could close it as per their judicious decision, I would say. Please.
Interim order.
Yes. Next Wednesday, same stage ಅಲ್ಲ, in the fresh matter ಹೇಳಿದ್ನಲ್ಲ? Yes.
Deeply obliged. Deeply.
Next.
Number 9, withdrawn.
In terms of
11.
Post immediately after service of notice upon the second respondent.
My lordship, 13(1) D, my lordship, 13(1) D, my lordship.
Objections ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀರಾ? Learned counsel seeks 2 weeks time to file statement
My
of
lordship,
objections.
defer the matter, my lordship, because.
No, no, no. List the
Because
matter.
the complaint is the habit of the lodging complaint, my lordship. He has lodged the complaint of one more officers, my lordship.
Disproportionate asset ಅಲ್ಲಿ complaint ಏನ್ ಬಂತು ಸರ್?
No, Serial number 11, my lordship.
Section 7.
7. ಅಂದ್ರೆ 23rd, yes. Next.
My lordship,
Objections if any by then. Next.
defer at least, my lordship.
Yes.
Till date, my lordship.
ಯಾಕೆ ಸುಮ್ಮನೆ ಇರಿ? Yes. 7A ಅಲ್ಲಿ interference ಇಲ್ಲ, ಎಲ್ಲಿಂದ ಬಂತು defer?
At least 7 ಎಲ್ಲ, my lordship. That section 13(1) D has omitted, my lordship, 2018 amendment, my lordship.
7 ಏನೋ 13 ಸರ್?
7, my lordship. 7, 13(1), my lordship. D.
Yes, on 23rd, next. Chamber, yes.
13,
Withdrawal.
14. Await service.
Lordship, I'm appearing for petition.
Post
Date may be
immediately
given.
after service of notice upon the respondent. Next.
Date may be given.
Immediately, yes.
15,
Same order.
16.
My lords, my lords, in seal number 15, my lords, your lordship directed the police to file reports, my lords. Notice was parallelly ordered.
What is that?
In seal number 15, my lords.
No, what was the issue, sir?
My lords, your lordships had previously ordered the police to file report
ಅದು
as on
ಗೊತ್ತಾಯ್ತು.
7th.
ಅದನ್ನೇನು ಸ್ಲೋ ಮೋಷನ್ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ, ಗೊತ್ತಾಯ್ತು ಅವಾಗ್ಲೇ.
ತಾವು ಅದನ್ನು ನೋಡಿ ಆರ್ಡರ್
ಅಬೆಟ್ಮೆಂಟ್.
abatement, yes, my lords.
ನೋಡಿ ಅದನ್ನ.
Date may be fixed, my lords.
List
if
the
your
matter
lordships-
on 22nd.
Grateful.
ಅದು ಇಸ್ಕೊಳ್ಳಿ. Yes. Sixteen.
16.
I'm not taking proper steps for service of R2.
2 weeks time to do the needful.
Interim order.
Interim order. In the event the steps would not be taken in the next 2 weeks, interim order subsisting would get automatically vacated. Yes, next.
17.
Subject to the condition, interim order. For withdrawal, yes.
18.
For the petitioner, my lords, offense under 8, 12 and 61 of BNS, my lords.
8, 12 and
8, 12 of
61
PC
now.
Act, my lords.
PC Act. Man, 8, 12 BNS ಯಾವ್ದಿದೆ?
My lords, 8, 12 of PC Act, my lords.
All right.
My lords, there's no, as far as the allegation goes, my lords, the allegation is that I've tried bribing a private party, my lords. Earlier, there was a complaint filed by the very same complainant, my lords, regarding irregularities in laying of stone guard rails in Hemavati project, my lords. That complaint, my lords,
ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? BB ಪಾಟೀಲ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದೆ.
my lords, served, my lords. My lords, that complaint is now, my lords, section 17A authorization is stayed by this court, my lords. Now he tells me I've tried bribing him to withdraw the very same complaint when there is a stay.
List on 9th in the fresh matters list.
My lords, no coercive action.
Don't worry. ಏನಾಗುತ್ತೆ ಇದು?
My lords,
ಇದರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ?
on the verge of retirement, my lords.
What are you?
My lords, I'm an engineer, my lords, executive engineer.
Then you are a public servant.
My lords, no, my lords, I have tried bribing a private party, my
We'll
lords,
see.
who's not a
Yes.
public servant.
That will, yes. Next.
19.
In this matter, my lords, the predicate offense has been stayed. And my lords, I'm taking steps to.
Which is the
move-
predicate here?
My lords, the predicate offense, my lords, the order is at page 117.
Why?
My lords, by a coordinate bench of this court. my lords.
ಎಲ್ಲಿದೆ?
8117, my lords.
Oh, there's an interim order here also.
Yeah, my lords. So what's happened, my lords, pursuant to that, the predicate offences being stayed, my lords are directed that no coercive steps shall be taken. That is
It
at
is in
one.
the vacation bench.
No, my lords, at
Oh, ಇಲ್ಲ,
121.
29/4/26.
At 121, my lords directed that no coercive steps will be taken
In what?
in the
Predicate
PMLA
offense?
proceedings, my lords.
All right.
At 121, my lord's order.
All right.
My lords, pursuant to my lord's order, my lords, a provisional attachment was passed under section 5.
All right.
Then we moved the vacation bench, my lords, and not the vacation bench.
Hmm.
Then, my lords, an interim order was passed staying the further proceedings pursuant to the provisional order.
All right.
Now, my lords, my only request would be, my lords, we are taking steps to move the predicate offense, my lords, which has been stayed. If this matter.
Number in?
My lords, that is at page 117, criminal petition 8938. It may be tagged with this. my lords.
8938 of
21.
tag this petition along with tag these petitions along with criminal petition 8931,
8938, my lords.
8938 of 2028.
21.
21, sorry. Next
Lords, may I only
Wednesday.
submit for 2 minutes?
Yes, sir.
I'm sorry, my friend, is an incorrect submission. Lords, we are not talking about predicate offense. 7336, my lords may see, 7336 was a case of PMLA offense, which came before my lordship, where my lords, there was a prayer from them, summons was issued.
They will cooperate with the investigation.
My lords may finish. Summons may be issued. Summons was issued. Don't take coercive steps. Let the investigation continue. My lords, investigation continued. Thereafterwards, on 28/3/2026, we filed a provisional attachment order, OA filed, PC filed. Thereafterwards, on 24/4/2026, they filed one more petition before the vacation bench, saying that coercive steps means not to take further steps, mislead the court, obtain a stay order. My lords, it's there. Obtain a stay order.
Investigation cooperate mandilva.
My lords, I've appeared. Just 3 times I've appeared. I've cooperated.
I'm sorry, he was not the advocate. I'm sorry. Mr. Madhav was the advocate. Investigation because they did not to arrest, etc., etc. 28/3/2026, we filed PAO, provisional attachment order, and it is before adjudication authority, and they also filed PC. Thereafterwards, on 24/4/2026, they filed another writ petition before the vacation bench, misleading the court, saying that coercive steps.
Ado vacation alla regular parallel.
They misrepresented before the court to say that coercive steps means not to go further steps, and they obtained stay on that. Now, that's my only submission is that is a misleading of facts because coercive steps only arrest goskara, not to the full investigation. And now, having filed a prosecution complaint, they are at liberty to go and question it, and also in the OA. And that is nothing to do with the predicate offense.
Yes, sir.
Let me answer that.
It's on record.
My lords, may I answer that? My lords, the 30-day period was coming to an end. Before that, my lords, we immediately.
It's a different issue. That's a different issue.
I will answer it.
Yes.
Sir, this is not the conduct. This is the conduct of the petitioner.
Not the conduct, my lords.
They change the advocates and the advocates come and
May
say
may
this is
just
the issue.
explain. 1 minute. Madhu. The 30-day period was coming to an end.
Kindly read that order, my lords.
On what pretext, sir?
My lords, may I read that, my lords?
It's here. Justice R. Nataraj avardu.
Yes, my lord. That day, my lord,
This order was
was
passed
not
on.
sitting.
Despite the direction issued by the coordinate bench not to take any precipitative action, provisional order of attachment is passed by enforcement
Not the order,
directorate.
Lordship.
Where is my order?
My lords, coercive action, my lords.
1 minute, where
at
is my order?
117.
Page
Where
number
is-
16.
121.
Page number.
121, my lords. 121, my lords. No, of this petition only, 121.
No, 1 minute. I have said coercive steps. Where is
Please.
precipitative action?
This is the
My
issue.
lords, my lords,
Coercive steps is not precipitative action, sir.
My lords,
Precipitative action, Supreme Court has interpreted that everything
while
stays.
recording the order, my
No,
lords,
no,
page
sir.
121 was specifically shown. my
No,
lords. It was
no,
121 which was shown. My lords, my only request, my lords, because even otherwise, may I do this? my lords?
Otherwise is a different thing.
My lords, may I do
Now,
this?
I have directed not to take any coercive
Coercive
steps.
action, my lords.
You have told that no precipitative action should be taken ಅಂತ ಹೇಳಿದ್ದಾರೆ. That's
We showed-
recording of
we
the order,
showed the
sir.
order, my lord, and this I may say, my lord, at the bar, because I appeared in that hearing.
This was
My
filed by
lord,
another advocate.
No, no,
By
I-
him, of course, he did
No,
not
no,
know
no.
about it.
When-
Because that
when
was
I
filed by Madhav.
appeared- When I
Therefore,
appeared on
NOC
the
is given
last
now.
occasion, when Honorable Justice Nataraj passed the order, my lord's page 121 was shown.
Now, ಈಗ
And it was specifically
ಈಗ
shown-
ಏನಾಗಿದೆ?
My lord,
Yeah,
now
the
the
proceedings
provisional attachment has been done, my lord. And after
You
the-
question that.
My lords, may I only say this, my lord.
If you are on the ground that I have directed not to take coercive steps and it could not have been, a provisional attachment could not have been passed, I am not agreeing to that.
My lords, may-
Because I only directed coercive steps, not precipitative action.
my lords, may I only
The two
request-
have different connotations.
may I only request this, my lords. Next week, my lords, may the main criminal petition also be, once the predicate offense goes, and this is the reason I'm saying.
What's the predicate offense?
My lords, the predicate offense, my lords, the allegation is this, 406, 420. The allegation is this, my lords, in the complaint, I am only a director prior to even the registration of the crime. I was drawing a salary. My lords, my total salary was about 40 lakhs, 23
Now,
lakhs.
insofar as the attachment is concerned, you question it before
My lords, may I make
to
this, my
avail the
lords. My
remedy
lords,
available
kindly
in
see
law.
page 70, my lords.
No,
Kind-
sir.
My lords, kindly see page 70 for a moment, and I won't press beyond this. Kindly
Yes.
see page 70 for a moment. Page 70 for a moment.
Yes.
6.2, investigation on the PMLA revealed that the petitioner was one of the directors and was a so-and-so in the said company. She has received funds amounting to 40 lakhs and immovable property, my lords, up to 27 lakh. My lords, I'll give an undertaking that nothing would be done to the property till next week, or my lords, let the main matter be taken. Once the predicate offence goes, nothing survives.
No, let the main matter be wherever it is.
My lords, kindly have the
They
main
will answer,
matter, my
this is
lords.
not correct, sir.
My lords, because kindly see, my lords, the complaint itself. My lords, may I just justify from the complaint at page 88.
No, now the attachment order ಆಗಿದೆಯಲ್ಲ ಈಗ
My
provisional
lords, the
attachment
attachment order ಆಗಿದೆ, my lords. There's no-
provisional attachment order
ಆಗಿದೆ,
ಆಗಿದೆ
ಆಗಿದೆ.
ಅಲ್ವಾ?
There's no dispute.
ಅದಕ್ಕೆ ರೆಮಿಡಿ ಏನು?
My lords, then I'll have
The proceedings are before adjudication.
Go
adjudication.
and appear before the adjudicating authority, file your
And
objections.
the entire proceedings itself has been stayed, my lord.
No,
that I have cooperated
that
with
I
in-
will answer.
My lord, I have cooperated with investigation. My lord, may kindly take up the main matter with the
No,
criminal
no, sir.
petition, my lord.
Nothing. This is not correct.
My lord, because what was shown, my lord, was 121.
No, I'll answer it.
My lord, may kindly take up the main matter,
No,
my
sir.
lord, next week.
No,
My lord, may I request that the main matter be taken up, or my lord, may I do this?
this is
May I
not
give
correct.
an undertaking, my lord, may I give an undertaking before your lordships? I'll
The
file an affidavit.
provisional attachment order which is stayed on the strength of the earlier order should go. You go before the provisional, adjudicating authority. I'll reserve liberty to approach this
Well,
court
no.
if there is any order passed.
May I only make this one request, my lord, in the interim? I will give an undertaking, my lord. I'll file an affidavit within 1 week, my lord.
You file it there only.
My lord, may I only do this, my lord? Because the predicate offense, my lord, there is absolutely nothing, absolutely no allegation. Kindly, my lord, so that I can satisfy my lord. At page 88, my lord, kindly see the complaint.
Yes, sir.
Kindly have 88, my lord. The only statement which
No,
is,
no, I'm not on that, sir. On
my
that.
lord, I'll give an affidavit that I will not alienate or deal with the property. Today, my lord, the property which is taken by a house loan, my lord, the lady's property. which
No
is taken-
problem. We will answer it on its merit.
Well,
But
may kindly take
you,
it up with the
this
main-
conduct I will not countenance. Yes.
Well, because kindly take it up next week, my lord,
No,
with the
sir.
main matter, because if I
To
succeed.
appear before the adjudicating authority. No, when I see this, no. The petitioner
That's objections.
is subject, latest, the old petition I will retain.
No, but that is become infructuous.
Why?
There was no coercive action.
Summons answered.
Ah.
Now, my lord, they question only summons, and it is infructuous because PC filed. It's become infructuous.
Complaint is, will reserve liberty to challenge the complaint if they want.
Then the, my
Both
lord,
can be
no,
disposed
no, my
of.
lord, this would be the problem there.
No.
My lord, my other,
You have created the problem
my
yourself.
lord, the entire, the prayer there.
Past may be imposed, lordship.
Wait.
My lord,
Not on him. Not on him.
Gautam.
My lord, may I only make this statement? But my entire case is, my lord, the entire
No, we are in
initiation
the,
of
we are on
PMLA.
the conduct of the petitioner.
My lord,
Not correct.
I may make the statement at the bar. When the interim order was passed in the main matter, my lord, page 121 was shown as it is, my lord. It was not shown that no precipitative or coercive was not. My lord, the court recorded the word precipitative instead of coercive. My lord, may I say this? It 121 was shown as it is. Page 121 was shown as it. My lord, let the main matter be taken up, my lord, a week's time, my lord.
No,
then
no,
I will,
sir.
I will undertake
No,
not to do
after
anything.
seeing this, no.
My lord, a week's
Yes.
time, my
No,
lord,
sir.
and I'll file an affidavit.
No, sir. You appear before the adjudicating authority.
My lord,
The petitioner is before the court calling in, seeking the following prayer.
my lord, because prayer 2
This
and
very
2 would
prayer
survive,
to,
my
you
lord.
know, pass any other order.
No, because no, my lord, I've still sought that so far as other proceedings, my lord, the entire initiation of PMLA is bad.
There. Come to page 18.
My lord, sorry, that would be in the first matter, in the second matter.
That we'll see.
Connected
Now they
matter.
will close this first.
Wait.
The petitioner is before the court seeking the following prayer. The petitioner had preferred another petition, same petitioner, Allah,
Same petition.
had preferred another petition in WP 7336 of 2026. This court refused to grant interim order of stay of all further proceedings in the said ECIR, but passed the following order, page 121. The petitioner was directed to cooperate with the investigation with the direction that the respondent enforcement directorate shall not take any coercive steps. Not to arrest the petitioner. The context in which the order was rendered also would only lead to the unmistakable conclusion that it was only not to arrest the petitioner in the garb of investigation. The investigation, the petitioner did cooperate with the investigation. The enforcement directorate then filed their prosecution complaint before the concerned court and special CC ಆಗಿದೆಯಾ?
In one.
Prosecution complaint before the concerned court.
28/3/2026.
And then pass an order and the adjudicating authority on on the filing of the prosecution complaint initiates proceedings for attachment of the property of the petitioner and passes a provisional attachment order
28/3/2026.
on 28/3/2026. This provisional attachment order is the fulcrum of the subject petition. The matter comes up before the court on 29/4/2026. The coordinate bench passes the following order. The submission of the learned counsel for the petitioner there was that the coordinate bench, i.e. this bench, had passed the aforequoted order directed not to take any coercive steps, not to take any precipitative action. Therefore, precipitative action. Therefore, the provisional order of attachment passed by the enforcement directorate was in a overreach to the order passed by this court. Therefore, the coordinate bench grants an interim order of stay. As a matter of fact, no precipitative action to be taken was not the direction issued by this court, but it was only an order not to take any coercive steps. The two have different connotations in law. Not to take any precipitative action as held by the apex court would stall the entire proceeding, but not to take any coercive steps would only be towards the arrest of any person who is being investigated into. Therefore, what was directed was only the not to take any coercive steps and not any precipitative action. In that light, now that the provisional attachment order is filed by is passed by the adjudicating authority, the petitioner shall appear before the adjudicating authority and participate in the adjudicatory proceedings. The learned counsel for the petitioner submits that he would offer a bank guarantee.
Undertake not to do anything
Would
with the
undertake
property.
not to alienate the property or otherwise during the pendency of the adjudicatory proceedings. This can as well be projected before the concerned authority by appearing before it. Once the provisional attachment order would merit its finalization at the hands of the concerned authority, it is open to the petitioner to knock at the doors of this court all over again, urging these contentions. With the aforesaid observation, the petition stands disposed.
My lords, but so far as my lord, seven three
First
three six.
learned one ನಿಮಿಷ. Learned counsel for the petition Madhu and Rao files a copy ಕೊಟ್ಟಿದ್ದೀರಾ? Madhu and Rao files a statement of objection, same is taken on record.
My lord, so far as 7336, that
73
would survive,
guys.
my lord. The connected,
7336 ಏನು sir?
that would survive, my lords. And there my request, my lords, if the predicate offense matter is tagged.
1 minute.
That now has become infructuous.
Illa, it's not become infructuous.
Full ECIR challenge ಮಾಡಿದ್ರೆ it won't become
It is not.
Then they can amend the petition.
Illa, it's 16.
ಈಗ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದಾರಲ್ಲ 28/3/26 ಗೆ
They have to
My
amend
lords, but I'll amend this, my lord. This would survive.
ಮಾಡಿ.
This would survive.
ಇದರಲ್ಲಿ ಬಿಕಾಸ್ ಪ್ರೊಟೆಕ್ಟಿವ್ ಆರ್ಡರ್ ಇದೆ ಇದರಲ್ಲಿ. Take weeks time.
We
Well,
have
then
the-
this
we
may
have-
be
We have the fact that prosecution complaint is filed, that protective order. We won't arrest
ಇಲ್ಲ,
after
whatever.
the.
ಅದಕ್ಕೆ let him do it. Yes.
My lord, then 7336.
ಇದಕ್ಕೆ predicate connect ಮಾಡಿ.
Connect, my lord. 8938.
That conduct is not correct. You should not do that.
My lords, but I may say this at the bar, my lords.
My friend actually.
Allah,
Page
not you.
120
I'm not on you,
but
sir.
my lords, the problem is that
Petitioner.
the order would reflect as if I have said that it is not precipitative. My lords, 121 was shown as it is.
Of course, as it is.
My lords, I didn't say it is precipitative.
As was
A
told
hair
by the
splitting of
petitioner.
precipitative and coercive was not done there, my lords.
Told by the petitioner.
No, anyway, no, ಆತರ will not put it on you.
My lords,
See, now precipitative coercive will be interchanging always, but they are different. Supreme Court ಹೇಳಿದೆಯಲ್ಲ ಒಂದರಲ್ಲಿ. Coercive
bow
ಅಂದ್ರೆ
down.
only arrest, precipitative ಅಂದ್ರೆ everything ಅಂತ. Worse, precipitative is worse than a stay order.
my lords, so far as 7336, may
We'll
be
take it
tagged
next
with the
week.
Predicate, my lord.
Predicate, tag the petition along with,
8938 of 21. Correct.
list them both on 2 weeks ಬಿಟ್ಟು date ಕೊಡಿ. 22nd. Yes.
Please.
Objections ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ಮಧು? 7336 ಅಲ್ಲಿ
ಇಲ್ಲಿ ಹಾಕಿ.
ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Yes.
Grateful.
In the meantime, liberty to amend.
You always have that liberty. Learned counsel for the petition seeks time to place an amendment to the petition in the light of the enforcement directorate filing its prosecution complaint before the concerned court.
Great.
But so sort is granted. Next.
20, wait, sir.
It's under
Entry model,
498A,
yeah?
my lords. My lords, service is awaited.
Indal.
Continue with that.
Entry model will continue wherever it is, yes. The 20, post immediately after service of notice.
My lords, the last date it was posted for consideration of interim order in so for a husband, my lords. I tried to serve a copy, however, it was refused.
But, yes.
My lords.
Next, 21.
Petitioner. Fresh matter.
Fresh matter.
Please. The same crime, there's another connected matter, serial number 108, my lords, today.
That will stay, yeah.
Illa, my lords, both are fresh matters.
ಅವಾಗಲೇ ತಗೊಳ್ಳೋಣ.
My lords.
ಅದನ್ನ ಇವಾಗ ತಗೊಳ್ಳೋ ಬದಲು ಅದನ್ನ ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ. ರೀಚ್ ಆಗದ್ರೆ ಹೇಳಿ, I'll take it.
Great.
Yes.
Admission 22.
Under an apology, last date I was not there, slipped out. Sorry, last date I did not appear. It's just missed out. Shown, my lords, that none appears. I apologize.
ಯಾರು ಇಲ್ಲ ಅಂತ ಏನ್ ಮಾಡುತ್ತೆ?
Sorry, my lords.
ಏನು ಹೇಳಿ?
I may be permitted to avail
For the petition.
discharge.
We should delete this.
Please.
6/1/2026 ಆರ್ಡರ್ಗೆ ಮತ್ತೆ ಅಪ್ಲೋಡ್ ಮಾಡಿ, ಅದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ತೆಗೆದುಬಿಡಿ. ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
File memo.
Withdraw in terms of the memo. Yes. In terms of the memo. Next.
Sorry.
Twenty-three.
Stay may be granted.
For respondent
Regarding
number
stack.
2, your lordship,
Even husband.
Husband go stay ಆಗಿದೆಯಾ?
we have given NOC, my lord. This is the,
You're not on record?
please, this is a legal service matter for respondent to complaint.
Legal service go NOC ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Please.
Yes, no
We
service.
have given memo of retirement in the counter, my lord.
Legal service ಗೆ NOC ಕೊಡು. ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಹಸ್ಬೆಂಡ್ ಏನ್ ತೊಂದ್ರೆ? ನೋ ಸರ್. ಅದೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್. ಎಸ್. List the matter on 29th July. Interim order subsisting will continue till the next date of hearing. ಬೇರೆ ಯಾರು ಅಪಾಯಿಂಟ್ ಆಗೋವರೆಗೂ ಇರಿ.
Please.
This proposed date is I'm filing this. I'm filing the additional statement of objection.
Additional statement.
Please, they filed additional grounds for the petition along with the petition.
ನೀವು ಅಡಿಷನಲ್ ಗ್ರೌಂಡ್ ಹಾಕಿದ್ರಾ?
ಹಾಕಿದ್ರು.
January ಹಾಕಿದ್ವಿ, ಈಗ objection ಪರವಾಗಿಲ್ಲ ಮೇಡಮ್. Ultimately, we have to see the source report. Statement BLS, it's not one property standing in.
No P.
No, they have done one P, my lords.
ಆಗಿದೆಯಾ?
My lord, if this P is seen, absolute eyewash, not one item is changed. And only 2 pages they say what is done, this source is correct. Now on that basis, if the order passed by the SP is seen, my lord, please notice page 24, the SP's order, page 24. Need for application of mind for this order. If this is seen at page 24, 18/7/2024. Lots of get there.
1 minute.
Page 24. 18/7/2024. And in the case, colors, check period is 27 years.
Page ಹೇಳಿ.
24. 24.
17 order.
17 order.
SP's order and 17. Please
All
notice
right.
this order.
ಗಂಗಾಧರಲ್ಲಿ ಇದೆ ತಾನೇ ಬರ್ದಿದ್ದು. Then Supreme Court said no.
My lords, at least
Sudhakar
one sentence that discloses any application of mind.
Supreme Court has affirmed such thing.
My lords, Gangadhar, after that, the matters that have come back. Now, my lords.
No, come back on a different footing.
On 2 footings.
ಅದೇ P.
One is desirability of P, 2 is application of mind for an order of an SP. My lords, SP permits investigation to take place. Otherwise, my lords, that proviso would lose its meaning. If the SP is not going to be looking at it at all, and he says, go ahead.
Same thing I wrote, sir, in that.
Malot Singh, Gangadharaya.
I wrote the same thing.
Gangadharaya, my lords should recollect, the order itself was not produced. There was.
ಹೌದು ಆಮೇಲೆ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ.
Produced body, we were able to show how that seems to have been done at a subsequent point of time. But anyway, the two aspects, my lords, that are still open, my respectful submission, desirability of plea and application of mine in a 17 order. These two are still available, my lords, before investigation takes place.
We'll see. We'll take it along with others. Again, additional objections ನೋಡಿ ಏನದು.
And one more important aspect which I may point out, my lords, now this order which is.
We'll collect all these matters of 13 and wherever you are appearing, you spearhead it. We'll hear and do it.
One more aspect I wanted to bring to the notice of the court, other than these two issues, my lords should have noticed, once there's an order passed under the proviso to 17, which means application of the mind of SP to permit investigation, my lords, before warrant is issued by the court, they look into this order of the SP and only then warrant can be issued, because my lords, in the first instance.
Correct. Can we get into so much of nitty-gritty?
No, my lords, if they're not seen at all, my lords, how can warrant be issued? Because my lords, you're getting into investigation. Starting point of investigation is this order permitting investigation. And in most
This is exact argument of yours in Gangadharaya. This is exact what I had written in Gangadharaya.
in Gangadharaya, my lords,
Same argument if you see. Correct. ಆಮೇಲೆ ಏನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅದನ್ನು I had commented saying that there was no order, later it is produced and it suffers from non-application of mind. You on one ground.
Sudhakar Reddy in 17 orders retreated, Supreme Court has answered. Sudhakar Reddy in para 43.
No, in Sudhakar Reddy.
Now, paragraph number 43, so far as section
No, there it
45.
my lords, in Sardar Sarfaraz.
ಅಲ್ಲ ಅದರಲ್ಲಿ 17 ಆರ್ಡರ್ ಬಗ್ಗೆ ಹೋಗಿ I only copied, I only followed the coordinate bench.
Coordinate bench. My lords considered Nirankarnath Pandey, considered Shankare Gowda, and then considered N. Satish Babu.
That is 3. All earlier judgments I have followed.
Even the coordinate bench.
There is no independent assessment there.
So one aspect, my lords, probably my lords would consider this, before issuance of warrant, whether the court sees whether there is an order under 17.
Let's see.
Sees whether there is an order under 17. Otherwise, you can't issue warrants for search.
We'll take all this on 15th.
We collected APR, Lord. In the APR, he had disclosed 1.6 grams of this gold. We on conducting raid, we detected, found, Lord, 4 kg gold and nearly 1 kg of diamond. It's worth out more than 3 crores.
Oh, so ಇದರಲ್ಲಿ ಯಾವ ಕೇಡರ್ ನೀವು?
Legal Metrology Department.
The deputy controller of legal metrology, now he is the joint controller. But the immovable properties in statement B, not one, my lords, not one property, 6 crores is what they show there.
Objections ಹಾಕಿದ್ದೀರಾ?
We filed objection, Lord.
Where is
Some
the
of
additional objection?
additional objection.
Oh, APRs refer ಮಾಡಿದ್ದೀರಾ?
Please. And the property, there are 4 flats were staying in the name of some other third party. Wherein, Lord, the rents were transferring to the daughter's name. We collected the documents for that also. And there are 4 properties, Lord, out of which, Lord, 1 property you are still and tracing. One of the property mentioned in the, Lord, it was in the name of third party. And Lord, we collected the statement of account, Lord, for it is transferring the amount. The rents were required.
All these are in statement B. Now, if that is so, my lords, preliminary inquiry, would they not do it to see where this has come? And many of it is before the check period.
Where do I get the check period?
Note, my lords.
ಕೊಡಿ ಅದು.
Statement B, if this note is seen.
ಅಲ್ಲ ಅದು ಆ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
We answer source report alle helidi. Kindly see the item number 1 and 2. We are deducted in while calculating the total amount. 1 and 2 items are page number 13, 17. The source report, their petition. They say that item number B schedule, that item number 1 and 2 are the properties acquired prior to joining the service. These 2 items were deducted in while calculating total at page number 19 at first item. That is, total worth is 1 crore 39 lakhs. After deduction of the value of item number 1 and 2, it is 5 crores 48 lakhs 45,000.
ಅಲ್ಲಪ್ಪ
Please, madam.
ಗೋಲ್ಡ್ ಎಲ್ಲ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ?
Gold not, statement of objection I filed.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದೀನಿ, ವೇರ್ ಇಸ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ.
Page number, the APR, my lord, kindly see.
Now this they say is the course of this
Page number 58.
Now,
Not preliminary
no,
inquiry.
not prior to it, not preliminary
APR detect, disclosing, my lord, kindly see the page number 58. Para 4. Fourth item, lord.
APR,
Please.
page 58.
58.
1650 grams of gold jewelry.
Yes. And the cash, my lord, that item number 6.
That is 15,28,000.
15,000 to 15 lakhs 28,000. Now the lord, on conducting raid, my lord, we have found, kindly see their petition, my lord.
Sorry, my lord, where on the registration of the FIR.
Page number 47.
No.
47.
Let me see.
Page number 47 of their petition, my lord. The gold at 4 kg 109.
One minute. Sir.
Please.
ಅದು ಸರ್ಚ್ ಮಾಡಿದಾಗ್ಲಾ?
ಹೌದು.
ಮಾಜರ್ ಇದೆಯಾ?
ಮಾಜರ್ ಇದೆ.
Page
47, my lord.
ಡೈಮಂಡ್ ಎಷ್ಟು?
Diamond is 909 gram. That is worth about 78 lakhs. Gold is worth about 1 crores 97 lakhs. And cash, my lord, kindly page number 42, my lord, the cash 25 lakhs 13,500. 42 page number.
ಎಲ್ಲಿದೆ ಕ್ಯಾಶ್?
42 page number 42 at the bottom, last paragraph. ಮಾಸ್ಟರ್ ಬೆಡ್ರೂಮ್ ನಲ್ಲಿ 25 ಲಕ್ಷ
13,500,000
ನಗದು ಅಂಡ್ ಅರೇಬಿಯಾ ದೇಶದ 500 ರಿಯಾಲ್ಸ್
ರಿಯಲ್.
ಹೌದು.
9 ನೋಟ್ ರಿಯಲ್. ಅದೇ 4,500 ಬಿಡಿ. ಇನ್ ರಿಯಲ್
ಹೋಗಿ ಬರುವ ಉಳ್ಕೊಂಡಿದ್ದು.
19.7 is the rate they say. 21.7 is the engagement of the daughter. And also we notice paragraph 18 of the IA. Paragraph 18 and 19. And this is all now what they're pointing out is their investigation. Even that kindly notice 18 and 19. When an engagement ceremony in the house, where relatives have come to the house, that is when this raid takes place and the jewels which are there are seized. Now we are one step earlier to that. In your statement B itself, from all the assets you have shown, not one stands in the name of the public servant. Is there not a desirability for you to have a P? Now that
ಇದ್ರಲ್ಲಿ ಪಿ ಮಾಡಿದಾರಂದ್ರಲ್ಲ?
my lord, P is
where is the P proceeding?
My lord, P proceedings is at page 22. ಒಂದು ನಯ ಪೈಸಾ change ಇಲ್ಲ and they have not even extracted the tables. My lord, page 22.
ಇದೇನು? That is page 22 ಏನಿದು?
That's supposed to be P, my lords. 2 pages. 10/7/2024. No statements, nothing. What is in the source report is this. If it's an eyewash of an PE, my lords, we won't get a better case than this. This 2 pages. What are the assets? What's the income? Where's the expenditure? What have you done during PE? So if the source report, what is there, it becomes the FIR.
And
even SP doesn't look into it.
sale deeds.
Sale deeds are placed, Lord, along with the statement of objection. Lord, first item, Lord, the serial number 3, that property which was stand in the name of wife.
That is Fatima Attar.
Please. For that, Lord, statement of objection I filed.
Wife declare ಮಾಡಿದಾರಾ?
She is not declared. She is a housewife.
ಅಲ್ಲ APR ಅಲ್ಲಿ declare ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
My lords, even ಕೊಟ್ಟಿದ್ದ note ಅಲ್ಲಿ second page, the whole explanation is there, my lords.
ಇದು wife ಅಲ್ಲಿ declare ಮಾಡಿದಾರಾ?
My lords, in the first APR, if my lords should have the second page of the list of dates which we gave today, kindly notice statement B, my lords. It's pertinent to note that none of the properties in statement B of the source report is standing in the name of the public servant. The respondents have included properties standing in the name of the petitioner's wife, brother-in-law, and daughters. That firstly, the petitioner was merely a GPA holder for properties mentioned in 1, 4, and 5. Now they say, my lord, they have left out 2 properties because it was earlier. While a registered agreement executed in 1995, even the same was disclosed in the petitioner's first assets and liability statement of 1997 and 1998. The underlying properties were sold to third parties in 1995 before the check period, my lord. 97 in the check period. Then, my lords, moreover, serial number 2 and 3 are petitioner's wife's independent assets. 2 was originally acquired by the petitioner's father-in-law using independent funds transferred to petitioner's wife by gift deed in 2004. The wife subsequently sold serial number 2 for 50 lakhs, for which an advance of 40 lakhs. Property serial number 6 was a tenanted property which was occupied by the petitioner's earlier wife, my lord. She had occupied it. That is being put there. Nothing to do with me. Of all the properties in statement B, my lords, not one property. At least, my lords, would they not ascertain from the assets and liability statement, my first assets and liability which I have declared? Nothing done. And this 2-page so-called PE, which reflects nothing. And now we have an order under 17, absolute no application of mine. FIR done. At present, what is being argued is search and seizure of certain jewelry at the time of investigation.
Lord, the item number 2, the property, which is item number 3, my lord, it is the property in site number 302 of Kalandar Manzil, it's HBR layout.
ಇದ್ಯಾವುದು?
Here it is, my lord, this a gifted property was in the year 1997 at Kaval KHB layout, Mahalakshmi layout.
ಅದು ವೈಫ್ ಆಯ್ತು. ಇದು ಯಾರು ಆಂಥೋನಿ ಕ್ರೂಸ್ ಅಂತ ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ ಅದೇನು?
Lord, the next 4 apartments, my lord, for that, my lord, we collected the bank statement.
ಯಾರು ಫ್ರಾನ್ಸಿಸ್ ಬರ್ನಾರ್ಡ್, ಡೊಮಿನಿಕ್, ಆಂಥೋನಿ ಸ್ವಾಮಿ ಅವ್ರದೆಲ್ಲ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಇವ್ರಿಗೆ?
Lord, kindly see the second next. That is in the name of his mother, petitioner's mother and
ಆಂಥೋನಿ
wife.
ಸ್ವಾಮಿ.
Petitioner's mother and wife. The
ಯಾವ್ದು
joint name,
ಲತೀಫ್ ಕರೆಕ್ಟ್ ಆಗಿ ಯಾವ ಪೇಜ್ ಹೇಳಿ?
page number R2, my lord, in the statement of objection.
ಪೇಜ್ ಹೇಳಿ ಸರ್. ಪೇಜ್ 13ರಲ್ಲಿ ಒಂದು ಸೇಲ್ ಡೀಡ್ ಇದೆ.
Yes.
ಆಯ್ತಾ?
Next R2. my lord.
R2 is 30.
Please.
ಅದ್ಯಾವುದು?
That is the property, my lord, the
ಯಾರು ಡಿ ಕ್ರೂಸ್?
sixth item, my lord. House number 19, F2, Crescent Caliber, Devils Road.
But this is in somebody else's name.
Lord, the wife's name is there in the second page. Fatima Akhtar.
Sorry, it is purchased by the wife.
Please. Then what the APR disclosing some other property is not this property. That APR disclosing the gifted property by the father.
ಇನ್ನೊಂದು ಹೇಳಿದ್ರಿ, ಬೇರೆಯವ್ರ ಹೆಸರಲ್ಲಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆ, ರೆಂಟ್ ಇವ್ರಿಗೆ ಬರ್ತಾ ಇದೆ.
That is during the investigation we collected the statement.
Not in the preliminary inquiry.
Not in the preliminary. We have an information that
apartment ಯಾವುದು?
That is 4 apartments, my lord, serial number 7, 8, 9 and 10.
ಯಾವ್ದ್ರಲ್ಲಿ?
In the source report.
Source report.
Please.
Those rents are received by the public servant.
Wife
of the public
daughter,
servant.
sorry. Daughter.
I will pass. The petitioner, a public servant who was at the relevant point in time. ಇದೆ ಗೊತ್ತು. ನಾನು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ತಾ ಇಲ್ಲ. No, I am just gathering the facts. Yes. Arguments ಆಯ್ತಲ್ಲ, ಇನ್ನೇನಿದೆ? ಅಲ್ಲ, any submission you have to make?
No, it's only on these 3 aspects I wanted to bring it.
Which is already answered by the coordinate benches.
One is desirability and application of fine for this order.
We'll answer all that. Yes. The petitioner, a public servant who at the relevant point in time was working as deputy controller of legal metrology department, is now in the dragnet of crime. For offences punishable under section 13(1)(b) and 13(2) of the Prevention of Corruption Act, hereinafter referred to as the Act for short. The registration of the crime for the said offence in crime number so and so has driven the crime number 31 of 2024 has driven the petitioner to this court in the subject petition. The facts relating to the registration of the crime is generation of disproportionate assets to the known source of income. The Lokayukta is said to have drawn a preliminary inquiry report pursuant to which an order under section 17 of the Prevention of Corruption Act permitting registration of the crime, a search then conducted and the search yielding certain properties certain properties which were allegedly disproportionate to the known source of income. The learned senior counsel, Sandesh Chowta, appearing for the petitioner, submits that the issue in the list stands completely answered by the judgments rendered in the cases of so and so, Nirankarnath Pandey, Shankare Gowda, and Satish Babu. Therefore, submits that the preliminary inquiry, though conducted in the case at hand, it cannot be a preliminary inquiry in the eye of law. It is only an eyewash of a preliminary inquiry that is conducted. Therefore, this court must hold that the preliminary inquiry is not even conducted in the case at hand and would straightaway fall within the parameters of the law laid down by the coordinate bench in the case of Satish Babu or Shankare Gowda or Nirankarnath Pandey as held by the apex court. Per contra, the learned counsel B. Latif, appearing for the petitioner, submits that preliminary inquiry was conducted, or during the investigation several skeleton has come out of the cupboard. The learned counsel B. Latif submits that a perusal at the APR annual property returns which was filed before the state was perused. In the said annual property return, what was declared was 1,650 grams of gold jewelry. When the search was conducted, the search yielded not 1,650 grams of gold jewelry, but about 4 kilos. Apart from the gold of 4 kilos, it transpires that about 900 grams of diamond is also found in the house of the petitioner. All put together, the learned counsel B. Latif would submit that the value of the value of the difference between the APR and the search conducted is close to 3 crores. Insofar as the cash is concerned for the relevant year, what was declared in the APR was 15,28,000, and when the search was conducted, the cash found was 25 lakhs. 25 lakhs in the house of the petitioner. He would submit that these are matters of trial, and this court should not interdict the proceedings. Interdict the proceedings as assets that are known assets beyond the known source of income is clearly found in the case at hand. The learned senior counsel would join issue in contending that the gold or diamond that was found in the house the search was conducted at the time of the engagement ceremony of the daughter. Therefore, jewelry or gold would obviously be in the house. It need not be that the petitioners only, it could be the relatives as well. The learned counsel B. Latif submits to cap it all. There are properties registered in someone else's name, 4 apartments.
4 apartments.
There are 4 apartments found in someone else's name, which is part of the source report itself. The source report, the Lokayukta's prima facie concluded that it is Benami on the score that the rent of those 4 apartments are received by the daughters of the petitioner. With this being the case, the learned counsel B. Latif submits that the petition should not be entertained. I have given my anxious concern, so heard reserved. Yes. Other facts, Matra is taking mind.
Let's say in the note given today, 4 apartments, it's standing in the name of one Narayan.
ಅದೇ ರೆಂಟ್ ನಿಮಗೆ ಬರ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ದವರು.
No, anyway, that note is there.
Yes, ಇಲ್ಲಿದೆ, ನೋಟ್ ಇಲ್ಲಿದೆ.
I'll pass on the records also.
ಕೊಡಿ.
25.
Yes. Trap has failed. Failed, huh?
Rangaya, failed ಅಲ್ಲ ರಂಗಯ್ಯ, it is failed ಅಂದ್ರೆ demand is there, not a clear conversation is there.
ಏನ್ ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆ?
That she has demanded, the petitioner has demanded,
ಹಾ,
that we have sought for completion of investigation, we sought for sanction also received, subject to what
ಸ್ಯಾಂಕ್ಷನ್ ರಿಸೀವ್ಡ್?
received. Along with my statement of objections, I have submitted copy of sanction.
Conversation is pertaining to fees, my lord. The fees of 500 rupees, fees of 500. अब 5 ರೂಪಾಯಿ ಕೊಡ್ರಿ ಅಂತ.
ಎಷ್ಟ್ ಸಿಕ್ತು?
ಅಲ್ಲ, ಸಿಕ್ಕರ್ my lord, there is no trap. There is no demand and.
Where is the demand?
But kindly see, my page 32. ಅಲ್ಲ, ಇದು specimen. Annexure G, page 20 minutes. Conversation is recorded.
ಹಾ,
500.
500 ರೂಪಾಯ? 500 rupees? ಏನ್ ಪ್ಯೂನಾ?
ಇಲ್ಲ, she is here to my lord, ದುಡ್ಡೇ ಕೇಳಿಲ್ಲ.
500 ರೂಪಾಯಿ ತಗೊಂತಾರ ಇವರು? ಯಾವ ARTO 500 rupeesಗೆ?
ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಬೀರ್ಲಿಂಗ ಕೇಸ್.
5 ರೂಪಾಯಿ ತಗೋಬಾರ್ದು ಅಂತಾನ?
ಡಿಮಾಂಡ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್.
ಅದು ಈಗ ಸಿನಕ್ವಾನಾನ್ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ರಂಗಯ್ಯ,
ಅಲ್ಲ, ಏನು
ನೀವು ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿಲ್ವಾ? ಏನ್ ನಗ್ತದೆ, ನೋಡಿಲ್ವಾ ಅಂತ ಕೇಳಿದ್ ನಾನು. ನಾವು ನೋಡಿದ್ರೆ ಮತ್ತೆ ಆ ಟೈಮಲ್ಲಿ ಆಗಿರೋದು ಇವೆಲ್ಲ. 500 ರೂಪಾಯಿ ಸ್ವಲ್ಪ ಹೈಯರ್ ಅಮೌಂಟ್ ಯಾರು ಟ್ರ್ಯಾಪ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ARTO ಏನ್ ಮರ್ಯಾದೆ ಬೇಡವಾ?
ಅವ್ರು ಮಾತಾಡಿದ್ರೆ ಮಾಡ್ತೈತಿ.
ಏನ್ ಮಾತಾಡಿ 500 ಅಲ್ಲ, 500 ಅಂತ ಯಾರ್ಯಾರು? ವಾಟ್ ಇಸ್ ದಿಸ್ ಸರ್?
This is conversation. FSL has also confirmed.
ಆಯ್ತು, 500 rupees ರಿಕವರ್ ಮಾಡಿದ್ರೆ ಇವರಿಂದ?
ಇಲ್ಲ, ಟ್ರ್ಯಾಪ್ ಆಗಿಲ್ಲ. She got information apparently and she has escaped. That's all.
What is all this you do?
But FSL report has come.
ಏನ್ FSL report? Voice sample?
Yes, voice sample is also taken. Voice mahazar is there. That is sent to FSL.
ಡಿಮಾಂಡ್ ಇಲ್ಲ, accept 500 ರೂಪಾಯಿ ಡಿಮಾಂಡ್ ಮಾಡ್ತಾರೆ.
In this case it has happened. The work is also
2002-3 ಅಲ್ಲಿ ನಡೀತಾ ಇತ್ತು ಇದು. Not in 2026.
Investigation.
Conversation page number 20 ಇದೆ my lord. It doesn't give any
Catch hold of big fish sir. 500 ರೂಪಾಯಿ ಇದೇನ್ ಬಂತು?
It does not give any clarity my lord.
Lord,
Page number 20.
ನೀವು ವೆರಿ ಸರ್, ಸ್ವಲ್ಪ ಕ್ಲಾರಿಟಿ ನಾವು ಕೊಡುವ.
ಬಿಗ್ ಫಿಶ್ ಇದಾರೆ ಇವತ್ತಿನ ಲಿಸ್ಟ್.
ಮತ್ತೆ ಇದು 500 ರೂಪಾಯಿ
ಇವತ್ತಿನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸುಮಾರು ಬಿಗ್ ಫಿಶ್ ಇದಾರೆ.
ಹಾಗಾದ್ರೆ ನೋಡೋಣ. ಎಸ್,
ಎಲ್ಲರೂ ಇದೆ.
ಎಸ್, ರಿಸರ್ವ್ ಇವೆಲ್ಲ 7A ತೀರ್ಮಾನ ಮಾಡೋಣ. ನೆಕ್ಸ್ಟ್ ಇದು ಏನ್ 13?
7A ಮೇಲೆ 7A.
ಇದು ಫೇಲ್ ಟ್ರ್ಯಾಪ್?
Trap is successful, Miller. This is the classic case where Miller, the act itself is misused by the complainant.
ಹೌದಾ? ವೈ?
Complainant himself is a habitual offender, Miller. Plus he has given similar complaints against the other public servants.
ಅಂದ್ರೆ ಈಗ ದುಡ್ಡು ಇಸ್ಕೋಬೇಕಾದ್ರೆ ಸಿಗಾಕೊಂಡಿದ್ದು ಯಾರು?
That in this case, Miller, I am only Miller. But Miller, fact remains that Miller, the why Miller, I made this.
Why did you take?
Stay order ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ಅಂತ.
ಸ್ಟೇ ಮಾಡಿಸ್ತೀನಿ ಅಂತ.
Miller, I was working. I am working as a bench clerk in the KAT, Miller. It is a case of the complaint is that Miller, I have demanded the 60,000 rupees for
administrative tribunal.
Appellate tribunal. Plus on the day of the demand or trap, the already order was passed, Miller. I have placed the order of the
Why did you take?
I have not taken, Miller. This is a successful trap. That's why, Miller, I made a
successful trap. ಅಂದ್ರೆ ಯಾರು ತಗೊಂಡಿದ್ದು ದುಡ್ಡು?
This because that's why, Miller, I made this.
ಅಯ್ಯೋ, ಯಾರು ತಗೊಂಡಿದ್ದು ಸರ್?
I only received it, Miller.
Why did you receive it?
Miller, that I have not received, Miller. I have given an explanation in the trap mahazar itself. This is a forceful. He has kept in my packet in a forcefully, Miller.
ನಿಮ್ ಪ್ಯಾಂಟ್ ಪಾಕೆಟ್ ನ ಆಕ್ಸೆಸ್ ಮಾಡಿದ್ರ ಅವರು?
ಅಲ್ಲಿ ನನ್ನ ಕೈಲಿ ಫೋರ್ಸ್ಫುಲಿ ತಂದು ಕೊಟ್ರು ಅಂತ. ದಟ್ ಇಸ್ ದಿ ಕೇಸ್, Miller. That is my stand.
How much amount?
60,000 rupees, Miller.
60,000 ಸುಮ್ನೆ ಕೊಟ್ರ?
60,000 rupees.
60 na 60 na?
60. And Miller, the complaint.
ಆರ್ಡರ್ ಮಾಡ್ಸಕ್ಕೆ ಅಷ್ಟು ತಗೊಂತೀರಾ?
No, Miller, it is not the case at all. On the day of the demand and acceptance, demand and trap, order was already passed by the judicial officer and also the member of the tribunal.
Postpaid. Postpaid. Yes.
So the conduct of the complainant, that's why, Miller, I made the submission. This is the classic case.
Who is the complainant?
Complainant is one member, Miller. He has taken a loan from the cooperative society, Miller. He is a successful defaulter.
Successful defaulter. Successful. All right.
Successful defaulter. That's why, Miller, under the Karnataka.
ನೀವೇ ಸಕ್ಸಸ್ಫುಲ್ ಡಿಫಾಲ್ಟ್. ಎಷ್ಟು ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದೀರಾ? Hmm.
Plus, I'm placing the complaints, my lords,
Hmm.
where he and his son both, my lords, they're in the habit of making allegation against the public servants. My humble submission, my lord, this attitude is permitted, my lords, then no public servant will perform their duties. My lord, this is
What duties, sir?
See, if this is the first case, my lord, then my lords, in the cases like this,
Hmm.
and my lords, in a similar set of
Perform
facts,
what duty?
they will perform their duty in a free atmosphere.
Free
my lord.
ಆಗಿ
Otherwise, my
ತಗೊಬೋದು.
lords, this cases like this.
Free ಆಗಿ ತಗೊಂತಾರೆ.
Free act ತಗೊಳ್ಳೋದು, my lords, the misuse of the act itself, my lords, and in the similar circumstances, my lords, your lordship in Prabhu Gowda's Patil case, and wherein, my lords, your lordship in the Dharwad bench has held that in a Birlinga's case, they approached the Supreme Court, and the Honorable Supreme Court had dismissed their
ಯಾವ್ದು ಕೊಡಿ? SLP dismissed.
SLP is dismissed. In Prabhu Gowda's Patil, my lords, it has reached finality, and they have not challenged it before the Honorable Supreme Court. This is ordered at 21st February 2026. Observation of your lordship, my lords, it start from page number 13.
ಯಾವ್ದು ಎಕ್ಸೈಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ da?
No, my lords, he is a police officer. He has taken a bribe for filing a B report.
Correct.
Here in our case, my lords, we have demanded for granting. I am not the authority, my lords. I am not a judge. I am not the member. We start from 13, my lords. At page, your lordship has
ಇದು ಚಾಲೆಂಜ್
considered.
ಮಾಡಿದ್ರಾ?
No, my lords.
ಮತ್ತೆ
This
ಇನ್ನೊಂದು
order
ಯಾವ್ದು?
is not
ಸುಪ್ರೀಂ ಕೋರ್ಟ್
challenged.
ಯಾವ್ದು?
Here, my lords, kindly see page number.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಯಾವ್ದು ಸುನಿಲ್?
Supreme Court, your lordship has referred it at page number 32, para number 12.
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಅಲ್ಲಿ?
Your lordship has
SLP ದೆಲ್ಲಿದೆ?
SLP, my lords, at SLP number 6770 of 25. Ordered
Oh,
at
ಇಲ್ಲ.
4/9/2025.
ಹ್ಮ್.
And a similar set of facts, my lord, demand and acceptance.
ಅಲ್ಲಿ page 33 ಅಲ್ಲಿ ನೋಡಿ ಇಲ್ಲಿ.
33, my lords, the apex court refuses to interfere with the findings recorded by this court. In light of the judgment rendered as offers quoted, the issue in the case at hand need not detain in this court for longer or dwell deep into the matter. It is admitted that there is no trap and there is not even a prima facie
Objections
finding that-
ಹಾಕಿದ್ದೀರಾ? Objections
ಹಾಕಿದೀವಿ. ಅಲ್ಲ, this shocks the conscience. A bench clerk, he will say, I will get you the order.
Oh, that is an allegation, that's it, my lord. It is not the case.
ರೆಕಾರ್ಡಿಂಗ್ ಇದೆಯಾ?
ಇದೆ, ಎಲ್ಲ
ಅಲ್ಲ
ಇದೆ.
ರೆಕಾರ್ಡಿಂಗ್ ಇದೆಯಾ?
ಇದೆ, ಎಲ್ಲ ಇದೆ.
ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀರಾ ನೀವು?
Shocks the conscience, my lord.
In recording, my lord,
Continues,
even in-
my lord, case continues even for one day with the interim order, with the benefit of the interim order, my lord.
ಈಗ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೀರಲ್ಲಿ?
Entry order there, my lords, it is either way also, my lords, either way also. That's why, my lords, I am making
My
the.
order.
Completely demeaning, my lord. It is completely.
My
demeaning.
order.
Demand is
No, my
there,
lord.
acceptance is there. My learned friend has fairly admitted before this honorable court in this hearing today that there is demand, that there is acceptance.
Hey, not my
No,
order.
I am not admitted, my lords. There is no
The
demand.
order is
at all.
not mine.
No, not.
Yes, I am not admitting. I have not admitted for demand. My lords, the first demand on 29/11/2024.
Shocks
After
the
lapse of 2 months, he has filed the present complaint. After lapse of 2 months, and he's in the habit of making false allegations.
ಯಾವ್ದು
against the
ಬೇರೆ
public
ಕಂಪ್ಲೇಂಟ್
servant.
ಕೊಡಿ ಎಲ್ಲ.
I have given a memo, my lords. Sir.
Heard reserved. Objections ಹಾಕಿದ್ದೀರಲ್ಲ?
ಹಾಕಿದ್ವಿ.
Yes. Next.
Petitioner is the authorized officer.
ಇದೆ ಈ ಕಡೆ.
Seek for an adjournment, arguing counsel.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಲೋನ್ ಕ್ಲೋಸ್ ಆಗಿದೆ, ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿದೆ. Petitioner number 1, Lord, is the authorized officer under Surface Act.
ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರ?
ಅವ್ರ ಮೇಲ್ ಕಂಪ್ಲೇಂಟ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆ. Now the loan is closed. May I just pass on, Lord, your lordship's order also, where the NOC was granted. Lord, loan is closed. The complainant, Lord, is one of the apartment owners. ನಾವು NOC ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಅದು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಿರಾ?
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆ. ಅಲ್ಲಿ ಕವರ್ಡ್ ಮೆಲಾಟ್ ವಿತ್ ವಿರೂಪಾಕ್ಷ ಜಜ್ಮೆಂಟ್ ಆಲ್ಸೋ.
I'll close it, madam. ಸುಮ್ನೆ ಕ್ರೈಮ್ ಯಾಕೆ ಇದಕ್ಕೆಲ್ಲ? He has done his job. The petitioner, an authorized officer of Anand Rathi, na?
Anand Rathi.
Of Anand Rathi Global Finance Private Limited is before the court calling in question registration of a crime in crime number 137 of 2021. ಇಬ್ರಿದಾರೆ?
Lord, the second one is also the manager of.
The second petitioner is the office bearer of the
Anand Rathi.
Anand Rathi Global Finance Limited. The second respondent is the complainant. A complaint comes to be registered on the score that the authorized officer has not issued a no objection certificate for, he's a purchaser, is it?
He is the purchaser from the
Auction purchaser.
purchaser from the developer who was the debtor.
From the complainant, a purchaser from the hands of the developer who was in debt with Global so and so Finance Limited. The learned counsel for the petitioner submits that collateral proceedings were also initiated before the coordinate bench, before this court in writ petition 12769 of 2021, and the no objection certificate is issued to the present complainant, and the apartment is also handed over to the complainant now, and the entire loan amount is cleared. These are the order passed by this court reads as follows, a memo lide, and the closure of and the issuance of no due by Anand Rathi Global Limited reads as follows. All of these have happened in the year 2023 itself. The crime, in fact, had been registered in the year 2021, i.e. on 31/7/2021. The offence alleged are the ones punishable under section 406 and 420 of the IPC. Section 406 of the IPC can be alleged only if the 406 offence alleged bada. And since the entire issue gets triggered from the complaint, I deem it appropriate to notice the complaint, page 20, 21. The police, after investigation, appear to have filed a charge sheet even in the case at hand. The summary of the charge sheet as obtained in column number 7 reads as follows, page 34 and 33, ulta hakidare, 33 and 34. A perusal at this complaint or the summary of the charge sheet, particularly in the teeth of the subsequent events permitting further trial against this petitioner, would become an abuse of the process of the law, for the reason that the ingredients as obtaining in 405 of the IPC for it to become 406 of the IPC - criminal breach of trust is not found even to its semblance in the case at hand. Same goes with the offence under section 420, for which the ingredients as obtaining under section 415 is not found even to its remotest sense. In that light, permitting further trial would become an abuse of the process of the law and result in miscarriage of justice for the aforesaid reasons following.
My lords, kindly permit me P2 ವಕಾಲತ್. P2 ವಕಾಲತ್, NOC ವಕಾಲತ್.
ಆಯ್ತು, ಅದು ಸಪರೇಟ್ ಹಾಕ್ಬಿಡಿ.
28.
ಮೆಮೊ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. Yes.
Your Honor, this matter arose from a matrimonial dispute. This complaint arose from a matrimonial dispute between petitioner and her husband. Respondent number 2, that's a complainant, is a sister-in-law of the petitioner. Your Honor, this matrimonial dispute has been amicably settled, and the petitioner and her husband has obtained divorce by mutual
Settlement.
consent.
Where is the settlement?
I have produced with a memo. So as per the settlement agreement, the respondent number 2 agreed.
One moment, madam. Where is the memo?
Page 4, Your Honor. Para 4, it says.
Kulanama. It's a Kulanama. Page
4. Para 4.
Page 4 is the para 4 na party.
The party of the second part, sister.
So and so.
Withdrawal criminal case filed on 15/4/2025.
Where are you reading, madam? That is page 5.
Apologize.
We'll close it. We'll close it. Settlement ಮಾಡ್ಕೊಂಡಿದೆ. The petitioners are before this court calling in question the register proceedings in so and so. During the subsistence of the proceeding, the petitioners in the case at hand are not the husband, Are not, husband is here?
Respond number two is her sister-in-law, husband's sister.
No, who are the petitioners, madam?
Petitioners is her family, petitioner and her,
Who is the husband here?
he's not a party, Your Honor.
That's all I'm asking. The petitioners are other family members of the accused number one, the husband. The second respondent complainant is the wife. The two, after the registration of the crime, have executed a kulanama which depicts closure of the present proceedings. The conditions of settlement read as follows. Flag hacking. In the light of the settlement arrived at between the husband and the wife by execution of the aforesaid kulanama, further proceedings being permitted to continue would become an abuse of the process of the law. Disposed. Objections ಯಾವಾಗ ಹಾಕಿದ್ರಿ? 25 ಹಾಕಿದ್ದಾರೆ, ಇಷ್ಟೊಂದು objection, ಇನ್ನೊಂದು crime ಆಗಿದೆಯಾ?
Objections are all overruled, Your
Honor. Respondents have filed their objections. Correct?
Yes.
Have you seen?
It was not served, Your Honor.
Seriously. Anyway, 118 ಏನೇನು ಇದೆ ಇದರಲ್ಲಿ? Which is crime number 61 of 25? ಇದೆನಾ?
This is crime number 47 of 2025.
Settlement between the parties. Made clear, the subject settlement would not become applicable if any other criminal proceedings are pending between the parties. The subject petition concerns crime number 47 of 2025 only. 25 or 20? 25 only. Yes. Next.
29.
Obliged.
Petitioner has been arraigned as accused number 2 for offences punishable under 108 and 3 subclass 5 of BNS.
Abatement.
Abatement. Proceedings against A1 has been quashed by this honorable court. I stand on the same footing.
They do not stand on the same footing.
ಅಷ್ಟೇ ಬೇಕಾಗಿದೆ. ಹೇಳಿ.
The death note is reproduced.
Who is accused number, who dies? Who dies?
The respondent number 2's son, they're all students.
All right.
He borrows loan from A1.
Oh, another student.
Both, all the three are students.
Oh, sorry.
Kindly peruse page 13, my lord. Complainant averment. Last line. ನನ್ನ ಮಗ ಒಂದು ಪೇಪರ್ ನಲ್ಲಿ ಬರೆದಿಟ್ಟಿರುವಂತೆ ಕಂಡು ಬಂತು. ಆದ್ದರಿಂದ ನನ್ನ ಮಗನಾದ ಅರ್ಣವ್ ಪ್ರದೀಪಿತನು ಪಡೆದುಕೊಂಡ ಲೋನ್ ಹಣಕ್ಕೆ ಇಶಾನ್ ವಿ ಶ್ರಿಯಾನ್, A1 against whom the proceedings and Rushank, the petitioner herein ರವರು ಹೆಚ್ಚಿನ ಹಣವನ್ನು ನೀಡುವಂತೆ ಒತ್ತಡ ಹಾಕಿ ಕಿರುಕುಳ ನೀಡಿದ ಕಾರಣ ಲೋನ್ ಹಣವನ್ನು ಇಯಾನ್ ವಿ ಶ್ರಿಯಾನ್ ಈತನು ನನ್ನ ಮಗನಿಗೆ ಜೊತೆಯಾಗಿ ತೀರಿಸುತ್ತೇನೆಂದು ಹೇಳಿ ಈಚೆಗೆ ನನಗೆ ಲೋನ್ಗೆ ಯಾವುದೇ ಸಂಬಂಧವಿಲ್ಲವೆಂದು ಮಾತು ಬದಲಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನನ್ನ ಮಗ ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾನೆ. Is the averment.
My lord, may kindly peruse the order passed by this honorable court.
Coordinate bench.
Coordinate bench. Paragraph 4 nalli the death note is reproduced. I'll just read the death note. The last line, it starts from last line.
I blame my suicide fully on Ishan for betraying me and throwing me under the bus. At 18 years of age, having 36 lakhs debt. ಅಷ್ಟೊಂದು ತಗೊಂಡಿದ್ದೀರಾ?
ಅವ್ರು ಕ್ಲೈಮ್ ಡಿಮ್ಯಾಂಡ್ ಮಾಡ್ತಾ ಇದ್ದಿದ್ರು ಅಂತ. ಅದ್ರ
It's not a joke. I apologize to you.
ಅದರ ಪ್ರೀವಿಯಸ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Petitioner ಯಾರು? ರುಶಾಂಕ್.
ರುಶಾಂಕ್ ಮೇಲೆ ಡೈರೆಕ್ಟ್ ಅಲಿಗೇಷನ್ ಇದೆ. Ishan has thrown me under the bus and is solely responsible.
Rushang is threatening to torture me and my parents. I request the police to protect my parents.
There is a direct allegation against the present petitioner.
ಕ್ವಾಶ್ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
Against accused number one, al direct allegation illa anta ಆ ground ಮೇಲೆ
ಇದು ಚಾಲೆಂಜ್ ಆಗಿಲ್ವಾ?
that is challenged before the Supreme Court. SLB is pending, notice is ordered. Notice SLB number ಇದೆ.
ಅಲ್ಲ ಇದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪೇಪರ್ಸ್ ಕೊಡಿ. ವಾಟ್ ಇಸ್ ದಿಸ್? ನೀವೇ ಅಪೇರ್ ಆಗಿದ್ದು ಸರ್? ನೀವಲ್ಲ?
No, no, I appeared only for A2. Here in that case, when Mr. Sridhar Korishetty has appeared and CR Desai. You know, the ingredients of abetment are absent in the entire case, even assuming there is a death note.
ಅಲ್ಲ ಇದು 24 to 25 was the crime.
Yes.
I think immediately file ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, the incident.
This is why in 108 cases generally I don't interfere at the.
No, 25 to 25 the incident.
No, 25 to 25 is the incident.
Incident of.
ಅಲ್ಲ ನಿಮ್ದು ಹಾಕಿರೋದು ಬಿಡಿ ಲೇಟ್ 6th August ಆ ಪೆಟಿಷನ್.
7th August order has been passed.
Yes, SPP ಅವರೇ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. We'll see. Interim order ಇದೆಯಲ್ಲ ಹೆಂಗೋ?
Interim order.
We'll see. The student's life is lost.
No, no, but what happened, my lord? The deceased has lost the amount in some, what you,
Gambling.
Electronic gambling. And he has also taken gold and all from the house, he sold it. It is a genuine this thing. He has even
It's a
taken.
very sad.
No, he was
case.
taken
Very
the-
sorry state of affairs, sir.
Very
It's
No,
not-
he has taken the gold ornament.
We can't take it so lightly and close the case of a 18-year student's death. Coordinate bench has closed it, but let's see.
Even otherwise on merit, my lord, even the averments what has been done, even presuming what he has written as a death note also.
What is the reason of the coordinate bench, though it extracts the death note?
The reason.
Paragraph 14 is the reason.
No, para 14, my lord. On a careful reading of the death note, even it is contents are taken at a face value. This court finds that the allegation therein do not disclose any material that would satisfy the essential ingredients.
Conspiracy ಯಾರು ಹೇಳ್ತಾರೆ? Nobody is saying
Abetment.
conspiracy.
No conspiracy.
Abetment as defined under section 45 of the BNS. So as to attract section 108, the note does not reveal that the petitioner had any point of time instigated the deceased to commit suicide by way of direct provocation, incitement, or any act calculated to create in his mind an irresistible compulsion to take his own life.
ಇದೆಯಾ ಪೇಪರ್ಸ್ ಇದೆಯಾ? Difficult, Divakar sir.
My lord, the entire transaction is between A1 and the deceased.
No, at least investigation should have been permitted. Not nip in the bud. Not a case for nipping it in the bud.
Case would have been closed under 170.
Not in the cases of abetment or suicide of
No, let them.
child of 18. They should investigate it. What is this?
Now the situation, my lord.
Why you don't assist? ಅಂದ್ರೆ
My lord, or otherwise, my humble prayer, I concur with the views of this honorable court. Yes, investigation is a need of the hour. At least pertaining to A2, a time of investigation, let them do it. Because tomorrow.
That I will order that.
No, because of the stay order, the police might have stated that matter has been stayed.
No, I will direct and I will protect you also. It's
in a
not.
time-bound
Bail
investigation.
ಇದೆಯಲ್ಲ ಹೆಂಗೋ?
Bail is there.
Sir.
Let the report be furnished to this honorable court.
The petitioner is before the court. Petitioner accused number 2 is before the court calling in question registration of a crime in crime number 15 of 2025 registered for offences punishable under section 108 of under 3(5) of the BNS. The protagonists in the list are 3 children. all aged 18 or 19 years. The complaint averments, 18 or 19 years, on the score that the deceased had borrowed an amount of rupees 36 lakhs, allegedly borrowed an amount of rupees 36 lakhs from the accused number 1 and 2 at the age of 18 years and was unable to repay the same, is said to have scribed a death note and died. The death note, this results in a complaint being registered by the father, the complainant, before the jurisdictional police, and the which becomes a crime in crime number 15 of 2025. The crime results in, the registration of the crime results in a petition being filed in criminal petition 6426 of 2025, even before the ink on the crime could dry, not by the present petitioner, but by the accused number 1. The accused number 1, who was aged 18 years, is said to have lent 36 lakhs along with the petitioner. The coordinate bench quashes the proceedings against accused number 1. Therefore, the learned senior counsel, accused number 1, the present petition, the order of the coordinate bench reads as follows. The petitioner is accused number 2. The learned senior counsel appearing for the petitioner, Shri Divakar, would submit that the issues squarely answer, the issue projected in the case at hand is squarely covered by what the coordinate bench has held as aforequoted. The learned counsel for the complainant would, however, dispute the position, as there are direct allegations against the petitioner, accused number 1, and there were direct allegations against accused number 1 as well, and he has challenged the said order before the apex court, and notice is issued. Obviously, stay agala avella, because notice is issued. Be that as it may, the complaint, as observed herein above, deals with 3 children. It reads as follows, page 13. The complaint narrates that the son of the complainant, now deceased, had borrowed 36 lakhs for manifold reasons, and that was pestering to be returned by the accused. Therefore, they unable to bear the alleged torture, it transpires that the son of the complainant scribes a death note and dies. The death note reads as follows. Will extract agide order. Order madidivalla beda bidi. The death note is already extracted in the said order. If a perusal at the death note and the complaint is done, the unmistakable inference is investigation in the least must be permitted in the case at hand. Though the coordinate bench has nipped the case in its bud, the case at hand, this court is of the opinion that investigation in the least is necessary. Therefore, the petitioner, therefore the investigation shall ensue against the petitioner only. Inyar accused? Ibrena? Against the petitioner only, in the light of the quashment of the proceedings, the accused number 1, and the report of the investigation be placed before this court. Placed before this court in the next 3 months. And in the garb of investigation, the student should not be harassed.
2 months is sufficient, my lord.
2 months, 3 months ಏನ್ ಮಾಡ್ತೀರಾ? 2 months.
Postmortem ಆಗಿದೆ, autopsy ಇದೆ, ಏನು?
ಅದ್ರಲ್ಲಿ ಏನ್ ಇರೋದಿಲ್ಲ, ಅಬೆಟ್ಮೆಂಟ್ ಇದೆಯೋ ಇಲ್ಲ ಒಂದು ಜಸ್ಟ್
2 months, 3 months is 2 months.
2 months ಸಾಕು. Within 8 weeks from today. Date ಕೊಡಿ ಒಂದು 2 months ಆದ್ಮೇಲೆ for further hearing on so on. So it's made clear, you should not be, student harass ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, ಏನಿದೆ ತಗೊಳ್ಳಿ.
Loan obtained is
already an
1.5.
anticipatory bill.
ಗೊತ್ತಾಯ್ತು, ಅಲ್ಲ ಆದ್ರೂ ಇವರು ಸುಮ್ಮನೆ ಬೇಲ್ ಇದ್ರು ಪರವಾಗಿಲ್ಲ, ಸುಮ್ಮನೆ ಇರಲ್ವಲ್ಲ ಅದಕ್ಕೆ.
Loan obtained is 1.5 lakhs, demanded 30.
Loan obtained is 1.5, demanded
1.5 lakh. ಅದು ಕರೆಕ್ಷನ್ ಮಾಡ್ತೀನಿ. ಅಲ್ಲ 1.5 ಲಕ್ಷಕ್ಕೆ 36 ಲಕ್ಷ ಡಿಮಾಂಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
In the complaint there is no averment about the quantum of amount.
ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
Death note ಅಲ್ಲಿ ಇದೆ, death note I am not.
ಅಲ್ಲ, you don't know, but whatever it is, he is Investigation ಬೇಡ್ವೇ?
All the three are engineering students. That's the most
No, correct.
unfortunate.
ದಿವಾಕರ್ ಸರ್ ನೀವು ಹೇಳಿ, ಇದ್ರಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್
No,
ಬೇಕೋ ಬೇಡ?
I'm not on the
Absolute.
way. Investigation has to take
Has
place.
to take
I
place.
concur with the view. But however.
No, we have protected you, bail ಇದೆ, harassment. Let investigation, let the truth come out. We'll see.
I'm for the investigation.
Yes.
Even if the stay order is vacated also, I concur, but he should not be harassed or arrested.
No, not ಮಾಡಿದ್ದಲ್ಲ. You will not be harassed. Yes.
Please.
Because I am not, in this case particularly, we will not nip it in the bud at all. ಒಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ, ಗೊತ್ತಾಗ್ಲಿ ಏನಾಗಿದೆ ಅಂತ.
No, I came because of the parity. I knocked the doors of state court.
Parity, of course. Parity, I am not agreeable with this.
Much obliged.
8 September, at 2:30 PM for the hearing. SPP will replace it before the court.
8th of
September 8th.
please.
30.
ತೊಗೊಳ್ಳಿ ಆರ್ಡರ್ ನೋಡಿದ್ರಾ?
The petitioner in this case, my lord, filing the withdraw memo, my lord.
Thank you, madam. Yes.
My lord, respondent number 1 have filed a charge sheet against the petitioner.
ಆಯ್ತು, madam.
I'm seeking liberty to.
Yes, madam. Whatever is in the memo. Yes, next.
31.
My lord, I appear for the petitioners. The petitioner is headed as accused number 2. It's a company wherein the allegations are for the offense under section 3 and 7 of Essential Commodities Act.
Commodities Act ಅಲ್ವಾ? List the matter. Company party ಮಾಡಿಲ್ವಾ?
Company, I am a supplier. Company is made as a party, but I am a supplier.
15th in the freshman, in the same stage. Yes. Fresh matter ಬೇಕಾಗಿಲ್ಲ, ಇದು ಮೇಲೆ ಬರುತ್ತೆ.
32.
Kindly see the 11-3 order. Lordship has directed to produce the investigation paper.
ಏನಿದು?
Lordship, this is the case. He is accused number 18.
Offense?
The motivated case has been registered against him. He made a party in NDPS matter. He's a jailer. Jailer. An allegation against him is that he coordinated 11-3 Lordship.
I'm seeing. Participate in the investigation, not filing. Place the investigation material.
I'll place it.
15th, same stage.
Lordship, Lordship, he is got suspended and from past 3 years he's struggling, Lordship. Not just
3 years in the suspend ಆಗಿದಾರಾ?
No, Lordship, he got suspended earlier, then he is stored in a head office. No duty has been assigned to him.
We'll see.
Lordship, only 11 and 12 in voluntary statement has stated. There is no material at all.
Investigate parley.
Bank transactions, I'll place it.
List the matter on 15th in the same stage. The learned SPP to comply with the order dated 11/3/2026, failing which this court would be constrained to pass necessary orders in accordance.
May I request for the time, specific time, 2:30?
ಅದೇ ಯಾಕೆ ಬಂದೇ ಬರುತ್ತೆ ಅಡ್ಮಿಷನ್ಗೆ. Admission is in the top now. ಸ್ವಲ್ಪ system change. Yes.
33.
I have to give the NOC in this matter. If it is not disposed immediately.
ನೀವು ಸಿರಾಜುದ್ದೀನ್ ಇದ್ದಾರಾ?
He has given NOC to me. The client has put me a notice. This is not, I have to give.
He can't help it, sir. We'll see.
Case, my lord, of suicidal. There was a 138 proceedings was pending, my lord. The matter has almost come to the conclusion.
Almost come.
Allah, 138. Almost come to conclusion. He borrowed 20 lakhs and escaped to Tamil Nadu. Ultimately, later he was secured.
108. Just suicide.
House. Allinda then he committed.
Charge sheet ಆಗಿದೆಯಾ?
Sorry?
Charge sheet ಆಗಿದೆಯಾ?
Yeah. The stay has been granted by this on court. 7 months.
But there is a direct suicide note in this matter. On the last date, HCG was ordered the suicide. Investigation reports.
ಏನ್ ಡೇಟ್ಸ್ ಹೇಳಿ? Recorded a video on his phone and is now construed a death note. Complainant son.
Mother has lodged report.
That's page 13 minutes, death note.
Oh, but no proximity here, madam.
Page 13.
Yes, who is the complainant?
Mother of the
Deceased.
male.
1 month after the cross examination, records the video and dies. ಕಷ್ಟ, ಇದರಲ್ಲಿ ಕಷ್ಟ. Difficult. 138 ಪ್ರೊಸೀಡಿಂಗ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ, that can't be abatement. ಅವ್ರ ಲೀಗಲ್ ರೈಟ್ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ.
Continued harassment ಇತ್ತು from 2019. Mental
ಅಲ್ಲ ಆಯ್ತು, ಕೇಸ್ ಹಾಕೋದು cannot become harassment. That cannot be the ground. not, so
Father and
there,
son.
there was a ground for permitting investigation, not in this. We'll close this.
Father and son.
ನೀವೆಲ್ಲ
both are-
ಹೋಗ್ತಾರೆ ಏರಿ
I mean, father
ಕ್ಲೋಸ್
and
ದಿಸ್ ಅಂದ್ರೆ ನೀವು ಹೋಗ್ಬೇಕು ಅಂತಲ್ಲ.
father and son both are being implicated.
ಫಾದರ್ ಅಂಡ್ ಸನ್.
How son? Son is a person who has advanced money.
ಅಲ್ಲ, who instituted 138?
Son,
That is second petitioner.
second petition.
The petitioners accused 1 and 2, SPP ಅವರು ಇದರಲ್ಲಿ ಏನಿಲ್ಲ. 1 and 2 are before the court calling in question registration of a crime in crime number 474 of 2025 registered for offense punishable under section 108, 3 and 5 of the BNS. Heard so and so. Facts enumerated are as follows. The complainant's son and the second petitioner, accused number 2, have had a transaction. The transaction goes wrong. The second petitioner is said to have instituted certain proceedings for offences punishable under section 138 of the Negotiable Instruments Act in in CC? In CC 738 of 2019.
Yes.
The cross-examination of the complainant's son happens on a particular day, that in the year 2025. After the said 1 month after the said cross-examination, it transpires that the complainant's son records a video of harassment on account of repeated filing of cases by the accused and commits suicide. The acts of abetment falls on the petitioners, the father and the son. This court, in terms of its order dated so and so, had interdicted the proceedings. The said interim order is subsisting even today. The learned senior counsel MT Nanaya, appearing for the petitioner, would vehemently contend that there is neither goading, abetment or instigation for commission of suicide. Mere filing of a case under section 138 of the Negotiable Instruments Act against the son of the complainant for the check that he had issued, which had been dishonored, would not mean that it would become abetment to suicide. The learned senior counsel submits that the ingredients as necessary to prove abetment is not present even to its remotest sense. The learned counsel for the complainant, however, would vehemently refute this submission in contending that the matter is still at the stage of investigation. It is a case of abetment to suicide, and this court must not nip it and must not obliterate the proceedings at this stage. Investigation in the case at hand is a must. The learned HCGP would also toe the lines of the counsel appearing for the complainant in seeking dismissal of the petition. I have given my source, therefore narrated. The transaction between the two, i.e. the son of the complainant and the second accused, is a matter of record. The proceedings instituted by the second accused number 2 against the complainant's son in CC 738 of 2019 for offense punishable under section 138 of the Negotiable Instruments Act is again a matter of record. The proceedings are instituted in the year 2019. The proceedings go on till the year 2025, and on a particular day, the cross-examination of the complainant complainant's son gets concluded. 1 month thereafter, the complainant records a video and dies. The recording, according to the learned HCGP, is with regard to continuous harassment for filing the 138 proceedings against the complainant's son. Filing of a case excising the rights available under the statute by the accused can by no stretch of imagination become abetment, goading or instigation that is necessary to prove the case under section 108 of the BNS. The petitioners have the accused number 2, the son of the accused number 1, has instituted proceedings for the offense punishable under section 138 on the score that the check that was issued by the complainant's son had been dishonored. This the father of the petitioner has been, father of the accused number 2, the accused number 1 has been dragged into these proceedings without any rhyme or reason, merely because he is the father of the accused number 2. There is no transaction, there is no conversation between the father and the complainant's son. For an offense to become punishable under section 306, under 108 of the BNS, the ingredients as obtaining under section 45 of the BNS is necessarily to be present. The section 45 and section 108 read as follows. Section 45 of the BNS deals with abetment. The abetment deals with abetment, and if the abetment is proved under section 45, it could become an offense under section 108 of the BNS. In the case at hand, the interpretation of the earlier regime, the IPC, for an offense under 306 and the abetment as obtaining under 107, the apex court in plethora, ಹಿಂಗ್ ಮಾಡಿ.
108.
Eh?
ಅಲ್ಲ 108 7
ಗೊತ್ತಾಯ್ತು, ಎಸ್.
ಸಾರಿ.
ಹಿಂಗ್ ಮಾಡಿ ಸೊ ಅಂಡ್ ಸೊ ಕೋಟ್ ಮಾಡಿದ್ರಲ್ಲ, jurisprudence is replete with the apex court delineating what would become the ingredients of abetment as obtaining under 107 of the IPC for it to become an offense under section 306. The apex court in the case of Yadvinder Singh Yadav, 2025 SEC Online SC page 2332, has, considering the entire spectrum of the law, has held as follows. In the light of the judgment of the if the elucidation of law by the apex court is pitted on, is considered the facts obtaining in the case at hand, the unmistakable inference would be the crime cannot be permitted to be investigated into, as the ingredients necessary under section 45 are completely lacking in the case at hand, as there is neither instigation nor goading, nor instigation, goading, or proximity to the commission of suicide by the complainant's son. Mere filing of a case against a person cannot mean it would be abetment, it could become abetment to suicide. It is no doubt, it is no doubt true that a life is lost by an unfortunate event. That would unfortunate event, the complainant's son breathes last. That would not mean that the petitioners would be held liable for abetment to suicide on the death of the son, as it is trite that human mind is an enigma, can sway any way like a pendulum. Yes. For the aforesaid reasons, the following God. Quashed, allowed, quashed.
Yesterday's matter.
ಏನದು?
That lawyers, your lordship has said.
ಏನು? Accused, ಕೊಡಿ. ಏನು ಕೊಡಿ? ನಾಳೆಗೆ ಹಾಕೋಣ. ಟುಮಾರೋ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
This matter, my lord, was supposed to get listed on first. Your lordships had fixed a date also, but nonetheless, it is not come.
What do you?
Doctor, any date may kindly be, I'll leave it to your lordship.
This matter was allowed yesterday, Lordship. I just have
Allowed
to give-
yesterday?
Yeah, Lordship, I spoke.
What
to-
was allowed?
Lordship, this posting of case for 4
Pending
weeks.
matter. I never allowed it. Yesterday evening?
Yesterday evening.
No,
Lordship, you told me to give the form today.
no,
Lordship.
it will
Lordship,
come according to its turn. There is an interim order. There is an interim order.
There is an interim order 4 months back, Your Lordship. And
4
I
months
served
back.
4 months.
What's the problem now?
No, I'm just
For
wanting.
disposal? No, madam.
No.
Yes. There are many
Lordship.
waiting in the line. Yes.
Then there is no next date of hearing, Your Lordship.
No problem, madam. There is an interim order. Enjoy. Yes.
So the mat, when will the? case be
Seriously,
listed?
how do I convince you? And I need not. Yes.
Petition was enlarged on bail, my lords. In the meantime, the surety has been discharged without giving a.
Tomorrow.
My lords, there's an
Taken to
urgency,
custody.
my lord.
Tomorrow, sir.
My lords, there's an urgency. The petitioner is
Yes,
a
madam. What's the
national level
urgency?
athlete, my lords.
What's the urgency?
My lords, the petitioner is a national level athlete. The pendency of a criminal case is not letting him travel abroad, my lords, for
Tomorrow.
competitions. Please, my lords.
Yes. What sport? Athlete. Okay, fine, please.
List number 3, pronouncement of order. Seal number 1.
For all the aforesaid reasons, the petitions being devoid of merit stand dismissed. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the issue in the list and would not bind or influence the investigation of further proceedings. Having regard to the fact that the complaint dates back to 2016 and the crime to 2017, this court deems it appropriate to direct the investigating agency to conclude the investigation with utmost expedition and in any event within an outer limit of 6 months from the date of receipt of the copy of this order.
Seal number 2.
For the petitioner.
Armor security. Dismissed.
Number 3.
The writ petition is allowed. Mandamus issues to so and so to dispose the application in IA3 dated 3/9/2025 filed by the petitioner within 1 week from the date of receipt of the copy of the order. Obliged. Yes. Madam, ಅದೆರಡು sign ಮಾಡಿ.
Fresh matters at 2:30 PM. Seal number 66, list number 2.
I appear for respondent number 2, my lord.
Let's.
My lord.
14%.
Either is.
2023 ಇದು.
A week's time may be granted, my lords. I have to file some more documents, my lord.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
Just 3 days, my lord.
Interim order ಇದೆಯಾ?
This one.
ಮತ್ತೆ?
Lord, the respondents are under the mercy of their parents, my lord. And also she is single-handedly taking care of the.
Wait. Don't step into the shoes of the client. Wait. You are Surya Dev.
Indeed.
For R2. R1 is the complainant, is it? Yes, sir.
That's just 2 days.
Maintenance award ಮಾಡಿದಾರಾ?
8,000.
ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಕೊಡ್ತಾ ಇದೀನಿ, but
Arrears ಇದೆಯಾ?
6 lakhs. Arrears ಇದೆ.
ಎಷ್ಟಿದೆ?
ಅವರು they claim it's 25 lakhs.
But ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
7 lakhs ಏನೋ ಇದೆ.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ಒಂದ್ ನಿಮಿಷ.
51 lakhs 76.
ಒಂದ್ ನಿಮಿಷ. ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
Let's. The facts are like this, my lords.
No, facts ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅಂತ?
There are some properties with me. I am ready to give that.
ಏನು ಎಲ್ಲ ಪ್ರಾಪರ್ಟೀಸ್ which are already encumbered to something else?
No, my lords. No, my lords. My lords, there are 3.
My lord, may I make a submission? There was a compromise petition entered between and 10 of the scheduled properties are already been relinquished, my lord. Relinquish ಮಾಡ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಒಂದ್ ಮಾತ್ರ ಅವ್ರು ಏನು ನಾವು ಸೆಟಲ್ಮೆಂಟ್ ಬರ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಪ್ರಾಪರ್ಟಿ ಇಟ್ ಇಸ್ ನಾಟ್ ಫಿಟ್ ಫಾರ್ ಇರಿಗೇಷನ್ ಅಟ್ ಆಲ್, ಮೈ ಲಾರ್ಡ್. ಬರಡು ಭೂಮಿ ಅದು.
Still the husband will so not so easily tell I will give property. Alva sir.
True, my lords.
Hmm.
My lords, the thing is, my lords,
He's having sufficient amount of income, my lord. He's running a provision store and he's getting 1 to 1.5 lakh monthly income.
But there is no provision for money. Wait, sir. Yes.
he's an uneducated person, he's an agriculturist.
ಈಗ ಇಲ್ಲಿ ಬಂದಿರೋದೇನು DB Act proceedings ಏನು?
ಅಲ್ಲ, maintenance, my lords, 8,000 each ಅಂತ. See, the son is now, he's already a major and she's an advocate by profession.
When was the order passed?
My lords,
22.
3 to 22.
Awaga he was 17 years.
Yes, my lords. The only thing is, my lords, now is 23 years, he's already
He's still
working
studying,
somewhere.
Wait, sir. We are in a hurry. Wait.
But she's an advocate by profession, is working.
Hmm.
She's earning more than the husband and she has.
When advocates
lot of
earn so,
properties.
advocates earn so much, is it? ಅವ್ರನ್ನ ಈ ಕಡೆ ನೋಡೇ ಇಲ್ಲ ನಾನು. ಇವರೇ ಅಲ್ವಾ?
Yes, my lord. No, she's practicing in Mysore, my lords, not here.
Who is this part in person then?
She was party in person, again she has changed many advocates, now he's representing her.
ಮಾಡ್ತಾ ಇಲ್ವಾ? ಸ್ವಲ್ಪ ಮೈಕ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್.
ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿಲ್ಲ ಇವ್ರ ಆನರ್. ನನ್ಗೆ ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ನಾನು ಎಲ್ಲಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದೀನಿ ಕೋರ್ಟ್ಗೆ. ನನ್ಗೆ ಇಡದ ಕಡೆ ಮುಖ ಊದ್ಕೊಡುತ್ತೆ ಇವ್ರ ಆನರ್. ನಾನು ಸ್ಕ್ಯಾನ್ ಎಲ್ಲಾ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ನಾನು ಕೋರ್ಟ್ಗೆ.
She has been enrolled, but she is not right now practicing, my
I
lord.
will present whatever the.
Also,
No
she
present
studies-
sir.
No, my lords.
Today ಇವತ್ತು ಹಾಕಿದ್ದೆ ಅದಕ್ಕೆ.
ಹೌದು, ಅಲ್ಲ ನನ್ನ ಹತ್ರ
Nothing
ಇರೋ
else,
ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಇದೆ. I'm at the mercy of this court, my lords.
We will discharge the mercy. Don't worry.
Lords, the only thing is, my lords, I'm ready to give the settlement. 4 sides kodak ready, 3 sides, so settlement, it was referred to the mediation. She agreed for the first day, she'll agree again, the next day she'll come and disagree for the
ಅದಕ್ಕೆ
same.
ಯಾಕೆ ಸುಮ್ಮನೆ ಮೀಡಿಯೇಷನ್ ಎಲ್ಲ ತೀರ್ಮಾನ ಮಾಡಿ.
Innondu, my lords, the trial court has not looked into the
I looked into what, sir?
assets and liabilities they have not taken into consideration at all. They have not followed that Rajneesh versus Neha's case, my lords.
Yes, sir. The petitioner, husband, stands at the doors of this court, calling in question an order dated 22/11/2022, rejecting the criminal revision petition in CRLP RP 5012 of 2022, affirming the order of the learned magistrate dated 3/2/2022, by which the learned magistrate had granted maintenance of rupees 15,000, 8,000 to the wife and the child. Each 8,000. 8,000 each to the wife and the child. The petitioner and the second respondent get married. First respondent, second? Second respondent.
Second respondent is the child.
First respondent get married on 16/6. ಯಾವತ್ತಾಗಿದ್ ಮದುವೆ?
16/6/2003, my lords.
16/6/2003. The relationship of the husband and wife appears to have floundered, and on floundering of the relationship, several proceedings are instituted by the wife against the husband and others, and the present proceeding concerns criminal miscellaneous 221 of 2011, which is filed under section 125 of the CRPC. The 125 of the CRPC. The petitioner, the concerned court, by its order dated 3/2/2022, orders maintenance at rupees 8,000 each to the son, to the wife and the child. The petitioner challenges it before the court of session, only to be dismissed. The twin orders are called in question before this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that petitioner is not in a position to fulfill the order of maintenance at rupees 16,000 from the date of the application as he is today without any work. He would further contend that the complainant herself is an advocate who is enrolled as an advocate and earns more than the husband. Therefore, the order of maintenance, which is passed without even looking into the judgment of the apex court, should be obliterated. Per contra, the counsel appearing for the second respondent would submit that the conduct of the petitioner will have to be looked into, as the order that is passed on 3/2/2022 even is even today not implemented, not complied with by the petitioner. Arrears are mounted to the tune of 21 lakhs according to the petitioner, 21 lakhs to which the entire account is placed. The learned counsel submits that the petition must be dismissed and the law to take its course. The respondent wife who appears in person also would seek dismissal of the petition and submit that she is suffering from ill health which has not permitted her to practice even for a day, and therefore the maintenance that is awarded by the concerned court must not be interfered with. I have given my assurance. Therefore, narrated facts lie in a narrow compass, as the issue that drives the petitioner husband to this court is with regard to the payment of maintenance. The concerned court, in terms of its order dated 3rd February 2022, awards maintenance by a detailed order considering the financial position of both the petitioner and the respondent. The order reads as follows, page 40. This is challenged before the revisional court. The revisional court rejects the revision petition again by a detailed order. The reason rendered by the revisional court is as follows, page 26 to 28. The issue now would be whether to accept the submission of the counsel for the petitioner that the petitioner has no avocation today, and therefore the maintenance that is awarded 4 years ago, which is not complied with even to its semblance, should be permitted to be obliterated. The reference being made to the judgment of the apex court in the case of Anju Garg versus Deepak Kumar Garg, 2022 SEC online essay, page 1136, it becomes apposite in the present circumstance. The apex court holds that if the husband has no job, it is for him to search for a job. He has a job that pays less salary, it is for him to search for a job that pays higher salary and take care of the wife and the child. The child and the wife cannot be left in the lurch. The submission of the learned counsel for the petitioner that the son is today 23 years would have merited acceptance, and the order of the concerned court would have been tweaked only if the petitioner had complied with the orders by paying maintenance, not an amount that is now not the aforesaid amount that is now pending to be paid to the hands of the respondent. In the light of the said circumstance, solely on the conduct of the petition does not deserve any merit. The petition stands rejected.
One submission, Lords, but the trial court has not followed the Supreme Court judgment.
No,
That asserts and liabilities.
The submission of the learned counsel for the petitioner that the judgment in the case of Rajneesh versus Neha has not been followed by the concerned court is noted only to be rejected, except quoting the judgment of the apex court in the case of Rajneesh versus Neha. A perusal at the original order would indicate that it has undertaken a scrutiny even beyond what the apex court has directed in Rajneesh versus Neha. Even otherwise, the conduct of the petitioner does not entitle any indulgence at the hands of this court. Yes.
The respondent number 2, even though he's a major, shall be till he's able to earn a substantial amount of income.
Yes.
Obliged.
Yes.
Obliged, my lord.
Yes, sir.
Victor Appiah for the petitioner in this matter, my lord. The PCR comes to be registered against me and cognizance has been taken against 406, 420 and 468, my lord. Breach of trust, cheating and forgery, my lord. The issue in this is this, my lord, a agreement of sale dated 3/5/2016, which has been entered into the respondent number 2 along with the accused here in my lord. Has been questioned by the respondent number 2 before the jurisdictional police in the year 2019.
B report is filed,
stating that there has been a forgery of the said document. Subsequent to the B report, my lord, they file a protest petition that comes to be accepted, my lord. Subsequent to that, cognizance has been taken. I have challenged the same before the revisional jurisdictional court, my lord, stating that it is not as per the procedure that has been laid down. That comes to be set aside. Similarly, once again, my lord, for fresh consideration, without even issuing notice to me, once again cognizance has been taken. My lord, two aspects. First is, my lord, in the entire order while taking cognizance, my lord. Petitioner number 2 is my wife. I am neither the signatory to.
Number 2 is?
My wife. It is petitioner number 1's wife.
Ah.
She is neither the signatory to the alleged document in list, my lord.
So everything happens between the husband and
Yes,
the complainant.
and that is the purport of the order also.
Who is the complainant?
Complainant is the respondent number 2.
Any relation between?
No, there is no relationship, is separate. Now, that apart, my lord.
Hmm.
The brief facts are like this, my lord. My contention before this court is as far back as in 3/5/2016.
No, everything springs from a sale deed.
Initially, it was a sale deed, my lord, but I stand
Is
on
the
a
second petitioner signatory to the sale deed?
No, my lord. Not at all.
Not a party to the sale
Not a
deed.
party to anything. Even in the order, it is clearly mentioned that the allegation is against 1, 3, and 5. Now, that apart, my lord, kindly come
1,
to.
3 and 5. ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
ಇಲ್ಲಿ ನಾನು ಬರೀ petitioner 1 and 2 ಮಾತ್ರ challenge ಮಾಡಿ.
Hmm.
But the case has a checkered history, my lord. I would like to take a lordship. 3/5/2016, this agreement comes to be entered into. At least I'm alleging so. After that, my lord, what happens is that as far back as in 8/12/2017, my lord, I file one original suit seeking for partition of the 33% according to this particular document. From 2017, my lord, the respondent number 2 is having the knowledge of this agreement of sale, which now he has come before this honorable court. Like Rip Van Winkle, my lord, for 3 years he keeps quiet.
3 years Rip Van Winkle
20 years
ಬರಲ್ಲ.
ago. 20 years ago.
Rip Van Winkle slept for 20
20
years.
years. ಅಲ್ಲ, ಗೊತ್ತು sir. But here, my lord, in as regards the criminal prosecution which has now been castigated against me, 3 years he keeps quiet, my lord. In OS
ಅದಕ್ಕೆ
470
slumber ಮಾತ್ರ.
slumber.
Yes.
Now, from 2017 till 2019, my lord, for a period of 3 years he keeps quiet. He files a written statement in the very same original suit 477 of 2017, stating that this document is forged and fabricated. He has taken up that contention. There, my lord, before the jurisdictional civil court, he does not file any application under Order 26, Rule 10A, asking for referring the matter to an expert by way of an handwriting expert. Neither does he take through the lodge.
The stage of the civil suit now.
Now, civil suit is posted for evidence. If really so, my lord, if this document had been forged, he would have gone before the jurisdictional civil court there and he would have filed this application that, look, this is a forged signature. As per the procedure of law, my lord, he would have got it referred. At least, my lord, even while he has now filed a PCR before the jurisdictional magistrate, the magistrate ought to have, under section 73 of the Evidence Act, my lord, he should have compared the signatures. Without comparing the signatures, without even issuing notice to the accused, my lord. This was the very reason initially I preferred a revision petition, it was set aside. So he has not even satisfied
Now
section
2
70.
civil suits are pending.
After this, my lord, I'll take your lordship. After this, my lord, he files a separate suit, OS 48 of 488 of 2019. In that, my lord, he has not whispered anything about this earlier suit where he has filed the written statement. Neither has he stated that this agreement of sale dated 3/5/2016 is
Now,
in
the
existence.
entire thing is agreement of sale.
Agreement of sale. So for that, my lord, I've also produced the Truth Labs report. I know it might not be the magnus opus before this honorable court that it is not. But still, my lord, perusal under section 73 of the Evidence Act, my lord, comparison of the signatures.
All right, we'll see. Yes, madam.
Please, let's, brief, just of facts. 2/5/2016, I registered
You
a
should be a
sale.
little.
Please, yes. 2/5/2016, lots, I registered a sale deed for 2 portions of land lots on the same sale deed in a village called Belgumba. The petitioner, one and other accused, act as brokers to that. The entire sale consideration under that sale deed, about 1,28 lakhs is paid by me through checks. There is no whisper about any contribution from their end on 2/5/2016. What happens then is, in December of 2016, after about 6 months, they come to me asking for some investment in some project, other project in another village called Honnenahalli in Tumkur. I lend all of the accused, about in total 1,44 lakhs. 44 lakhs. Now, what happens is, when I went and asked them that return that money, because the relationship becomes sour for some reasons, when I asked them to return, then comes about this agreement on the immediate next day of the first sale in 2/5/2016. The agreement in question, which I say is forged, is on dated 3/5/2016.
Forged?
Yes. Now, if you may request your lordships to peruse the agreement for a minute. It is titled as agreement to sale.
Is that the issue before the civil court?
Yes.
The issue is framed with regard to forgery?
No, I will just make,
No.
I will just make a submission. Now, basis that agreement, my lords, they file a suit for partition. They are agreement holders.
Partition ಯಾಕೆ?
Adರಲ್ಲಿ, in that agreement, though it is in the nomenclature of agreement of sale, my lord, ಒಕ್ಕಣಗಳಲ್ಲಿ 33.3% sharing ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. But rightly or wrongly, I've challenged it, my lord, before the
All right.
jurisdictional
Ah.
civil.
They say, my lords, agreement to sale and the market, no sale considerations, nothing. Not even a whisper as to how they paid amount under that second. They say this is partition suit.
All
They
right,
file it.
this, why this wife is necessary?
It's wife, my lords, because when proceedings start, my lords, wife is A2, accused number 2, along with accused number 5, Rajanna anta heli.
All right.
They come, my lords, go to my aunt's house and threaten that if I don't withdraw my civil suit, and I file a police complaint to that effect, my lords, that if I don't withdraw and settle it for 1 crore rupees, which her husband will give it to me, my lords, that
That's why wife is in.
yes, my lords,
We
that's
will
why
let the
it is.
wife out now.
So there is
Yes.
specific complaint to that
Oh.
effect, my lords. Now, my lords, what happens is he files a suit along with accused number 3 called Lakshmi Narayana. My lords, that's Lakshmi Narayana withdraws himself, files order 1 rule 10 saying
ಅದು
now I have
civil suit ಅಲ್ಲಿ
realized.
ಮಾಡ್ಕೊಳ್ಳಿ.
Now I have realized
Sadanand,
the forgery.
The first petitioner will face. The second petitioner I will quash.
One submission, my lord. Magistrate, my lord, he has to, my lord, kindly. I'll
Where
take
is the order rejecting the bail
Rejecting,
report?
kindly, page number 89, it starts, my
Page.
lord. He only says that because he has perused the documents in the civil court.
Page
89, my lord.
Yes.
So the reasoning,
77 is the order rejecting the P report, my lords.
All right, yes. The second petitioner ಬೇಕಾ ಬೇಡವಾ?
Lords, according to me, my lords, for the actions that they have done and the police complaint lodged, lords, threatening me, my lords, to settle the civil suit for 1 crore to be given by husband, lords. If I may take your lordships to annexure X, my lords, along with my statement of objections. And in fact, my lords, police issue an endorsement that we have advised them, annexure X, my lords.
B report is in accordance with law.
Yes, my lords.
that,
I'll take it.
cognizance ತೊಳ್ತಾರೆ ಸ್ವಾಮಿ. That comes to be once again set aside.
162 of my statement of objections, my lords. The complaint against petition number 2, who is accused number 2, as well as accused
ಬರಲ್ಲ,
number 5.
ಅದರ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. Wife I'm going to quash, others I'm not.
Two submissions. 73 ಕೆಳಗಡೆ, my lord, the magistrate has to satisfy himself comparing the signatures. No signatures has been compared. That can
We'll
be
see
seen,
that
Alla,
point.
that can be seen at
That
running.
point you can urge later.
Alla,
He has to
page
prove that in
number
trial.
108
Trial has to go on for that.
page number 108 ಅಲ್ಲಿ, the PCR is annexed along with only the civil suit papers. ಈ civil suit papers ಅಲ್ಲಿ, all that the judge, the jurisdictional magistrate was able to see is that certain signatures may have been there, but this document is also not produced along with the private complaint report. So this is the reasoning, my lord, at running page number 108, paragraph number 9.
B report, ಏನಕ್ಕೆ?
B report ಅಲ್ಲ ಸ್ವಾಮಿ. This is the cognizance that has been taken against me, which is hurting me.
Which is the order of cognizance?
Plus the
Running page number 108, madam.
co-plaintiff comes out of the suit saying this petition number 1 is a.
Wait, madam, where is the order of taking of cognizance?
Page number 108, my lord, paragraph number 9.
89.
Where does it
starts.
begin?
89.
This is the latest order of cognizance?
Latest order.
Yes.
And it is against section 223(1) of the BNS, my lord. BNSS. ಅದರಲ್ಲಿ the duty is cast upon the magistrate, my lord, to hear the accused before passing any kind of cognizance order. I take your lordship to 223 subclause 1.
Oh. Seriously? 531, sir. Anything else, sir? You want to urge that point?
My lord, the PCR is of the year 2019. However, the order of cognizance is of November
No
2024.
problem, sir. I have just now answered it 2 days back, sir.
Lord, the reasoning while taking cognizance is this, my lord. 1, against petitioner number 2, no absolute materials has been produced. As regards petitioner number 1, my lord, all that they say is that I have perused all the documents of the original suit. Hence, I am taking cognizance. That could not have been done, my lord. So at least he has to compare the signatures. All right, there is prima facie.
ಮಾಡ್ತಾರೆ ಬಿಡಿ
ಅಲ್ಲ,
ಆಮೇಲೆ.
prima facie.
Prima facie ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ, forgery ಗೆ ಏನಾದ್ರು ಒಂದು ದಾಖಲಾತಿ ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. No
forgery-
document is produced.
ಈಗ್ಲೇ ಏನ್ ಬೇಡ.
ಅಲ್ಲ, now it is
Trial
like
ಅಲ್ಲಿ
this, my
ಮಾಡಿ.
lord. I go before the magistrate and only make an allegation that certain persons have fabricated a document. He has to subjectively, at least initially, satisfy himself that certain documents are
He will
produced.
finally satisfy, don't worry. Initially he has not done, finally he will do it.
The
Alva.
sections of 468. Now, my lord, if I am able to overcome the theory of section 468, my lord, 420, 406, 191, 192.
Lord, wife will caution.
Now, my lord, Achin Gupta, my lord, there are 3 civil suits that are pending.
Achin Gupta?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಸಿವಿಲ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್
ಅಲ್ಲ,
ಇದೆ.
Achin Gupta?
ಹೌದು ಸ್ವಾಮಿ.
ಅಚಿನ್ ಗುಪ್ತಾ?
Yes. I'll produce it.
ಹೌದಾ, ಸರಿ.
But civil suits are pending. Previously, there has been several transactions between the accused and the complainant.
Achin Gupta is 85, sir. 498A.
Counter blast.
Huh?
Counter blast.
Counter blast ಅಲ್ಲ. ಅಚಿನ್ ಗುಪ್ತಾ ಕೇಸ್ ಇದಕ್ಕೆ ಸಿವಿಲ್ ಸೂಟ್ಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
These 7-8 sections have been invoked against me, even without looking into the documents that have been produced by the respondent number 2 complainant. Now, 2 civil suits are pending. He has not challenged it.
That is Lalit Chaturvedi. Yes.
Sorry. Now, civil suits that are pending, he does not whisper about the civil suits. In the second civil suit, there is no whisper about the first civil suit. Only he comes across with this private complaint now, my lord, because a B report is filed. That was thrown out by the jurisdictional district and sessions judge. Once again, cognizance has been taken.
Cognizance order ಏನು ತಪ್ಪಿಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿದೆ. Finding no material against petition number 2 except that frivolous threatening, we will quash it.
Like even against petitioner number 1, my lord, some document has to be produced. He has to at least give his
ಮಾಡ್ತಾರೆ ಬಿಡಿ ಸರ್.
ಅಲ್ಲ, he has to give his signatures.
ಟ್ರಯಲ್ ನಡಿಲಿ.
ಅಲ್ಲ, signatures ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ.
Anything
else?
else?
Only allegation is there, my lord.
Anything else, sir? ಅಷ್ಟೇ ಅಲ್ಲ.
And 223 is not followed, my lord.
So you seriously want to urge that point? ಮೊನ್ನೆ ಓಪನ್ ಕೋರ್ಟ್ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಒಂದು. Proceedings have sprang in 2019. 531 clearly protects it. No question of 231 now.
The order is dated
If the proceedings had commenced yesterday, then it's a different thing.
Prospective, my lord. Now, order was passed subsequent to BNS, my lord.
Maybe order may be passed after 10 years. Proceedings began. That is why 531 comes. 531 ನೋಡಿದ್ದೀರಾ?
ಅಲ್ಲ, though proceedings began, my lord, no positive order was there.
No problem, sir.
The B report was
No,
taken out.
there is a judgment. Pavinder Singh Supreme Court.
Fresh proceedings start again.
Correct. Pavinder Singh Supreme Court says a ministerial act cannot be equated with a judicial order. So it said 223(1) ought to have been followed, though PMLA proceedings began a little earlier. ಇದೇನು ಮೂರ್ ಸರಿ ಹೋಗ್ ಬಂದಿದೆ ಆಗ್ಲೇ.
ಅಲ್ಲ, but fresh proceedings started subsequent to that.
I think all of you should stop this absurd submission without looking into 531 or the law that is laid down. Every time this is being done. Not correct. You should look into the law and make submissions. Not correct. 531 ನೋಡಿದ್ದೀರಾ? 531(1)(2)(a) ನೋಡಿ. What is protected? Proceedings that have already begun and pending. Is it not a pending proceeding?
True, my lord, but what happens here is fresh proceedings.
See, these submissions unnecessarily take away the precious judicial time when the law is completely settled. You should not do that, and you should not do that. All right. Yes, wife, we will set it aside. ನೋಡ್ತಾ ಇದೆ.
I'm just
No.
trying to understand.
Try to understand.
What the court says.
The order will be there, you can understand. Yes. The petitioner, accused number 1 and 2, are at the doors of this court calling in question the proceeding in CC 5564 of 2023, registered for offences punishable under so and so. Heard so and so facts adumbrated are as follows. The petitioner and the first petitioner and the second respondent complainant allegedly enter into an agreement of sale on 2/5/2016. Synopsis 1 ನಲ್ಲಿ details ಇದೆ madam.
3/5. 3/5/2016.
3/5. 3/5. All right. On a dispute that arose with regard to the agreement of sale that was entered into, civil suits are filed. 2 civil suits are pending before the jurisdictional competent civil courts. This is an admitted fact. On the same set of facts, it appears that the complainant set the criminal law into motion by registering a complaint in private complaint invoking section 200 of the CRPC on 25/4/2019 in PCR 216 of 2019, alleging several offences. The matter was referred for investigation under 156(3) of the CRPC, and the concerned jurisdictional police file a B report. B report tane first. File a B report, and the B report and the protest petition was preferred by the complainant. The protest petition comes to be rejected and the B report comes to be accepted. The petitioner challenges the same before the revisional court. The revisional court sets the order aside and remits the matter back to the concerned court for hearing afresh. The concerned court again rejects the B report and takes cognizance of the offence in terms of the order impugned. Therefore, the petitioners accused 1 and 2 are at the doors of this court calling in question the said order of taking of cognizance. The learned counsel Sadan Shastri, appearing for the petitioner, would vehemently contend that the issue that is purely civil in nature is projected to become a crime by the impugned private complaint so registered, in the year 2019. The learned counsel would submit that twice over the matters were twice over the B report. On the first occasion, the B report is accepted in the proceedings closed, which is set aside by the revisional court, and again the B report is rejected and cognizance is taken at cognizance first ತಗೊಂಡಿದ್ರಲ್ಲ.
Actually,
B
what
report
happens,
was
my
not
lord?
accepted.
B
B report was rejected even the first time.
The B report was rejected and cognizance was taken. The petitioners prefer revision petition before the revisional court challenging the said order of taking of cognizance on rejection of the B report. The concerned court upturns the said order and upturns the said order and remits the matter back to the hands of the concerned court. The learned counsel for the respondent would now respond to petitioner. Madam, petitioner respondent. The counsel for the petitioner submits that the concerned court has erred in again taking cognizance on the offences which are purely civil in nature. Insofar as the reference to the alleged forged signatures, the learned counsel submits the truth labs new kotrada. The FSL report by the truth labs is not even given any credence by the concerned court.
We were not even allowed to submit. They have not heard me at all in the court.
ಯಾವ್ದಕ್ಕೆ sir?
For taking cognizance, ನನಗೆ notice ಬರುತ್ತೆ. Summons has been issued to me, but I have not been given an opportunity to make my submissions before.
What opportunity to make submissions while rejecting the B report?
B report alla. Subsequent to the B report, my lord, what happens is that
summons issue ಮಾಡಿದ್ದಾರೆ.
while taking cognizance,
no necessity
I was not heard.
You need not be heard, sir. Law does not require you to be heard. Earlier law does not require you to be heard. Therefore, the learned counsel submits that insofar as the accused number 2 is concerned, the learned counsel submits there is not even a whisper about any allegations accused number 2, and therefore the accused number 2 proceedings against the accused number 2 also must be quashed. Per contra, the counsel appearing for the respondent Poonam Patil submits that there is a clear case of forgery by the petitioner accused number 1, the petition number 1, 3.
Everybody else was 3 to 7.
3 to 7. And insofar as the second petitioner is concerned, the learned counsel submits that the second petition, the wife of the accused number 1, threatened the complainant to withdraw the suit, and therefore the said allegation is also necessary to be tried. I have given my anxious considerations on. The aforenarrated facts lie in a narrow compass. What drives the petitioner to this court in the subject petition is the order passed by the concerned court taking cognizance of the offence. The first of the orders passed on rejecting the B report was tossed before the revisional court, and the revisional court had remitted the matter back for a fresh consideration, directing the concerned court to follow the dictum of the coordinate bench in the case of Ravi Kumar and pass necessary orders. The second order is as follows. Page 101 in the submission of the 101. Therefore, the concerned court has now taken cognizance under section 204 of the CRPC and issued summons to the accused 1 to 7. The submission of the learned counsel for the petitioner that the order of rejection of the B report and taking of cognizance does not bear any application of mind is noted only to be rejected, as the order is in great detail and reasons out as to why as to why the B report is rejected and the order of cognizance and the rejected and cognizance is taken. That would be insofar as the petitioner number 1 is concerned. Insofar as the second petitioner is concerned, it is an admitted fact that the second petitioner is no way involved in any transaction with the complainant. She was neither the signatory nor a party to the agreement to sell with the complainant. This is an admitted fact. Without there being any rhyme or reason, the second petitioner is drawn into the web of proceedings only on a plea of on a plea of the complainant that she, along with the other accused, came to the house of the complainant and threatened her and threatened the complainant to withdraw the suit. The complaint itself suffers from inherent improbability insofar as the threatening is concerned by the wife of the accused number 1, the second petitioner. Therefore, finding no warrant to permit any continuance of the trial, qua accused number 2, the wife of accused number 1, I deem it appropriate to obliterate those proceedings, qua accused number 2 only. For the aforesaid reasons, the following order. Petition is allowed in part. The proceedings in CC so and so, insofar as accused number 1 is concerned, stands sustained. Insofar as accused number 2 is concerned, stands obliterated.
It's just one indulgence I would seek, my lords. Your lordships in the first paragraph observed that both the suits arise of the agreement dated 3/5/2016. The second suit does not relate to that. It's just the first suit.
Second suit is partition.
No, first suit is partition. Second suit is filed by me for recovery of money and totally different.
Yes.
So the reliance is not there on that 3/5/2016.
Recovery of money case ಹಾಕಿ ಆಟ ಆಡಿಸ್ತಾ ಇದ್ದೀರಾ ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ
ಇಲ್ಲ.
ನೋಡ
Totally different transaction.
Anyway,
Yes.
come back. Yes.
Liberty may be given.
ಏನು
PCR cognizance ಆಗಿ ಅದಾದ್ಮೇಲೆ
ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ಮತ್ತೇನ್ ಲಿಬರ್ಟಿ ಇಲ್ಲಿ ಅಲ್ಲಿ ಯಾವ್ದಾರ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರೆ ಬನ್ನಿ ನೋಡಿ 1 crore 44 lakhs ಕೊಡ್ಬೇಕು ಅಂದ್ಬಿಟ್ಟು ಯು ಡ್ರ್ಯಾಗ್ ದ ವೈಫ್ ಆಲ್ಸೋ.
They are not giving. I've paid in the checks to them.
ಗೊತ್ತಾಯ್ತು.
Two of the accused have made payments.
138
It's A3 and A4 have made
138
payments.
ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, they have not issued
You are
checks.
using this to
No,
settle
A3
the scores.
and A4 have made payments, my lords, pursuant to me filing the suit.
Anyway, there is some semblance of forgery, so I permitted it. Otherwise,
Great.
yes.
68.
Lord, the PMLA trial was stayed on the ground that it
Double
constitutes-
jeopardy.
jeopardy.
Triple jeopardy ಆಗೋಯ್ತು. ಕೊಡಿ. Yes, sir.
A complete misunderstanding of
The law.
the law.
Yes, ಯಾವುದು ಫಸ್ಟ್ ಯಾವುದು? ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 748 ಯಾರ್ದು? Yes, sir. ಕೃಷ್ಣಪುರ ನಿಮ್ದಾ? Yes, start.
There was a demonetization in the year 2016.
Demonetization drive.
Demonetization by the central government,
November 8, 2016. Yes, sir.
banning old notes of 1,000 rupees
Hmm.
and introducing 2,000 rupees pink notes. It's a case of the prosecution. Petitioners who are residents of Ennarpura Taluk, T. Narsipur Taluk, Mysore, and Malwadi Taluk flashed a message in Malwadi Taluk.
ಏನ್ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಕ್ ಹೋದ್ರೆ 2,000 ರೂಪಾಯಿ ನೋಟು?
Exchange ಮಾಡಕ್ಕೆ ಅವರು 1,00,000 ಹೊಸ ನೋಟ್ ತಗೊಂಡ್ ಬಂದ್ರೆ 1,20,000 ನಾವು ಕೊಡ್ತೀವಿ. ಅದ್ರ ಪ್ರಕಾರ ಒಬ್ರು ಪೋಸ್ಟ್ ಮ್ಯಾನ್ 5 ಲಕ್ಷ ಅವ್ರ ಮಗಳಿಗೆ ಮದುವೆ ಮಾಡ್ಬೇಕಂತ ಇಟ್ಕೊಂಡಿದ್ರು. ಅವರು ಇನ್ನೂ 5-6 ಜನ ಕೇಳಿದ್ರು. ಒಟ್ಟು 67 ಲಕ್ಷ.
ಪೋಸ್ಟ್ ಮ್ಯಾನ್ ಬಿಡ್ಲಿಲ್ವಾ? ಅಯ್ಯೋ.
ಅಲ್ಲ, ಅವ್ರನ್ನ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಲ್ಲ ಇವರು.
ಸರಿ, ಆಮೇಲೆ
ತಗೊಂಡ್ ಬಂದವ್ರನ್ನ. Incident has taken place at VC canal between Ramadurga, Korallikoppalu, Ramadurga, Ramanduru, Kirgavalu.
ಆಯ್ತು.
ಅವರು ಹೊಸ ನೋಟುಗಳು ತಗೊಂಡ್ ಬಂದ್ರು. ನಾವು ಹಳೆ ನೋಟುಗಳು ತಗೊಂಡ್ ಬಂದಿದ್ದೀವಿ ನೋಡಿ, ಮೇಲೆ ಬಾಕ್ಸ್ಗಳೆಲ್ಲ ಇಟ್ಟಿದೀವಿ.
ಈಗ ಅದು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು?
ಅಲ್ಲ,
ನೀವು ಪ್ರಿಡಿಕೇಟ್ ಒಫೆನ್ಸ್ ಏನ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ?
ರಿಕವರಿ ಈಸ್ ದಿ
ಅಲ್ಲ, ಪ್ರಿಡಿಕೇಟ್ ಒಫೆನ್ಸ್ ಏನ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇಲ್ವಲ್ಲ? ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಿರೋದು PMLA.
ಅಲ್ಲ,
ಪ್ರಿಡಿಕೇಟ್ ಅಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಆಗೋಗಿದೆ.
ರಿಕವರಿ ಈಸ್ ದಿ ಓನ್ಲಿ ಬೇಸಿಸ್ ಫಾರ್ ಕನ್ವಿಕ್ಷನ್. ನಾವು ಅಲ್ಲಿಗೆ ಹೋಗಿ
I am not hearing an appeal on conviction.
Please.
So restrict yourself to the legal position that you have taken.
Section 3.
Proceeds of crime.
Yes. Offense of money laundering. Whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or actively connected with the proceeds of crime and projecting it as untainted property shall be guilty of offense of money laundering.
ಅದು ಇಶ್ಯೂ ಅಲ್ಲ ಈಗ. ವೆದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಶುಡ್ ಬಿ ಪರ್ಮಿಟೆಡ್ ಟು ಬಿ ಕಂಟಿನ್ಯೂಡ್ ಆರ್ ನಾಟ್ ಅಷ್ಟೇ.
ಅಕ್ಯೂಸ್ಡ್ ನಂಬರ್ 1 ಹತ್ರ ಬೇರೆ ಅಕ್ಯೂಸ್ಡ್ಗಳು 10,000 30,000 ಇಸ್ಕೊಂಡ್ರು ಅಂತ. I was not aware.
ಹೊಸ ನೋಟ್ ಎಲ್ಲಿ ಸಿಕ್ತು ನಿಮ್ಗೆ? ಯಾರಿಗೂ ಸಿಗ್ತಾ ಇರಲಿಲ್ಲ.
ಹೊಸ ನೋಟ್ ಅವ್ರು ತಂದಿದ್ದು ಕಂಪ್ಲೇಂಟ್ ವಿಟ್ನೆಸಸ್.
ಅವ್ರು ತಂದು ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದು.
ಹೊಸ ನೋಟ್ ಅವ್ರು ತಗೊಂಡ್ ಬರೋದು, ಹಳೆ ನೋಟ್ ನಾವು
ಹಳೆ ನೋಟ್ ನೀವು ಕೊಡೋದು.
ನಾವು ಕೊಡೋದು. ಹಳೆ ನೋಟ್ ನಾವು ತಗೊಂಡು ಹೋಗ್ಲಿಲ್ಲ. ಹೊಸ ನೋಟ್ ಅವ್ರು ತಗೊಂಡ್ ಬಂದು ನಾವು.
Where is the order of conviction?
Note page 204 and 5. The operative part is at 2045.
Must be 489 ABC.
Oh.
489 ABC of the IPC.
295.
295B conviction.
295.
395.
395 IPC.
Dacoity 120B.
Dacoity ಎಲ್ಲ ಆಯ್ತು.
Read with 395.
Selling notes is 489. Anyway, convict ಆಗಿದೆ. ನಾವೇ ಕನ್ವಿಕ್ಷನ್ ಆನ್ಸರ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಅಪೀಲ್ ಹಾಕಿದ್ವಿ. This Honorable Court has suspended the sentence.
Sentence suspension is automatic. Conviction stay ಆಗಿದ್ರೆ ಹೇಳಿ, ಅವಾಗ ಏನಾದ್ರು ಹೇಳ್ಬೋದು. ಇಲ್ಲಲ್ಲ? ನಿಮ್ಗೆ ಆಮೇಲೆ ಬರ್ತೀನಿ. The petitioner is before the court seeking the following prayer.
We are reviewing citations.
ಕೊಡಿ ಸರ್.
ನಮಗೂ ಕೊಡಿ.
ಡಬಲ್ ಜಿಯೋ ಪರ್ಡಿ ಮೇಲೆ.
ಹೌದೌದು, ಒಂದೇ ಒಂದು ಸೈಟೇಷನ್. ಫಸ್ಟ್ ಸೈಟೇಷನ್
ಹೇಮಂತ್ ಸರ್
ಕ್ಲಿಯರ್ಲಿ ಅಪ್ಲಿಕಲ್. ಹೌದು ಹೌದು, ಸೇಮ್ ಗೌರ್ಮೆಂಟ್ ಅಡಿಷನಲ್ ಸಾಲಿಸಿಟರ್ ಅಪಿಯರ್ ಆಗಿರೋದು.
ಯಾವ್ದಿದೆ ರಿಸರ್ವ್ ಇದರಲ್ಲೇ ಇಲ್ಲ.
ಯಾವ ಪ್ಯಾರಾ ಸರ್?
ಪ್ಲೀಸ್ ಪ್ಯಾರಾ ಫಸ್ಟ್ ಪ್ಯಾರಾ ನಂಬರ್.
ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ, ನೋಡಿಲ್ವಾ ನೀವು?
Citation is in our favor. Respondent said relayed Vijay Madan Lal Chaudhary case that is not accepted by the Honorable Court in this case.
ಹೇಳಿ ಸರ್.
505, para number 7. First citation. The allegations against the accused number 7 is that without verification of the credibility of an entity, namely so and so, allowed the transactions in the name of accused number 5 without due diligence. Therefore, in the absence of any allegation or material that the petitioner was actually involved in the concealment of the proceeds of the crime or knowingly assisted in such concealment of the proceeds of the crime, which must have arisen from the predicate offense, and in the absence of any predicate offense against the petitioner, the cognizance taken of the offences alleged against the petitioner is without any substance. Here, the case of the respondent, petitioners number 2 to 10, petitioner number 1 given amount to the petitioner number 2 to 10, which was snatched by him. Therefore, they want to prosecute us, all the petitioners, under PMLR. ಒಬ್ರು ಹತ್ರ 10,000 ರೂಪಾಯಿ ಇತ್ತಂತೆ ಮನೆಯಲ್ಲಿ ಪೊಲೀಸ್ ತರೋದಾಗ. 10,000 ರೂಪಾಯಿ.
ಅದು ಕನ್ವಿಕ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದಿರಲ್ಲ, ಆದ್ಮೇಲೆ ಕಷ್ಟ. ಕನ್ವಿಕ್ಟ್ ಆಗಕ್ ಮುಂಚೆ ಏನಾರು ಇದ್ದಿದ್ರೆ ಬೇರೆ. ಏನು ಮದನ್ ಲಾಲ್ ಇದೆಯಾ?
Doesn't dispute the fact that PMLA is an independent standalone offense. So where is the question of?
I am not asking about that. ನೀವು ವಿಜಯ್ ಮದನ್ ಲಾಲ್ ತಂದಿದ್ದೀರಾ ಅಂತ ಕೇಳಿ.
ಅಲ್ಲ, ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ 43 ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ. ವಿಜಯ್ ಮದನ್ ಲಾಲ್ ಕೇಸಲ್ಲಿ
Section 43 is very clear, my lords, PMLA Act.
ಏನು?
Let's, section 43, special courts. The central government in consultation with the Chief Justice of the High Court shall, for trial of offence punishable under section 4.
ಆಯ್ತು, ಅದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಸರ್ ಅದು.
Let's, subsection 2, while trying an offence under this act, a special court shall also try an offence other than an offence referred to in subsection 1, with which the accused may, under the Code of Criminal Procedure, be charged at the same trial. At the same trial, my lords. And section 44.
Then they should withdraw.
Look, section 44 is also very clear that the CRPC should be followed at the time of trial.
ಒಂದು ಅದ್ರಲ್ಲಿ ಕನ್ವಿಕ್ಟ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಟ್ರೈ ಮಾಡಂಗಿಲ್ಲ PMLA ಅಲ್ಲಿ.
ಅಲ್ಲ, ಜಾಯಿಂಟ್ ಆಗಿ ಮಾಡ್ಬೇಕಿತ್ತು. ಮಾಡಿದ್ದಾರೆ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ, ವಿಟ್ನೆಸಸ್ ಎಲ್ಲ ಎಕ್ಸಾಮಿನ್. Now again, after conviction of the accused, second trial, again summoning.
It's not second trial, sir.
They are calling for the witnesses now, again afresh, and conducting a second trial, which is not permissible under law. When once they are convicted, they are into the matter, they cannot, on the same set of facts. That's what section 300. I'll read out section 210, please. CRPC 210. That's procedure to be followed when there is a complaint case and police investigation in respect of the same offence. Let's hear PMLA Act. It's a private complaint filed by the officer in charge. And there is a offence under the IPC also.
ಇದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ತಗೋಬೇಕಾರೆ.
ಅಲ್ಲ, CRPC ಅಲ್ಲಿ ಇರೋದು. Let's 210 subsection 2. If a report is made by the investigating police officer under section 173, and on such report, cognizance of any offence is taken by the magistrate against any person who is an accused in the complaint case, the magistrate shall inquire into or try together the complaint case and the case arising out of the police report, as if both the cases were instituted on the police report.
If I hear for some more time, I may go into the oblivion.
So which is the lordship may proceed to pass orders.
Yes, sir.
Now after conviction, please.
Absolutely, sir. The petitioners in both these cases, first to Krishnapatwar Muksana. The petitioner is before the court calling, it is 748, madam. Before the court calling in question the proceedings in special case 233 of 2018, registered for offense punishable under section 4 of the Prevention of Money Laundering Act 2002, hereinafter referred to as the PMLA for short. The petitioners stood as accused in a predicate offense which was tried as special CC 123 of 2020. The offense alleged against these petitioners sprang in the aftermath of the demonetization, i.e. on November the 8th, 2016, when the petitioners are said to have exchanged the 2000 rupee notes, they exchanged the old notes to the new notes for a premium. The facts led to registration of a crime against these petitioners, and the crime resulted in a trial, and the trial resulted in their conviction. The petitioners have preferred an appeal against the conviction. The same is pending adjudication before the concerned court. They learn simultaneously on the predicate offense in 148 of 2016 being registered. The Enforcement Directorate had registered an enforcement case information report - the ECIR. For offences punishable under section 3 and 4 of the Money Laundering Act of the PMLA. The petitioners after conviction, the petitioners after getting convicted challenged the said continuance of proceedings in special CC 233 of 2018 filed for offence punishable under section 4 of the PMLA before this court on the ground that it amounts to double jeopardy. Therefore, the coordinate bench accepting the submission of the counsel appearing for the petitioner that it does amount to double jeopardy grants an interim order of stay by the following order. The said order is in subsistence even today. The learned additional Solicitor General of India appearing for the Enforcement Directorate submits that moved the matter on the score that once the petitioner gets convicted of the offence, there cannot be an interim order interdicting the proceedings under the PMLA. Therefore, the matter is taken up. The learned counsel Krishnappa appearing for the petitioner submits that the proceedings by under the PMLA after the conviction amounts to double jeopardy, relying upon section 300 of the CRPC, which prohibits second trial on the same offences. Second trial on the same offense. He would seek to place reliance upon the following judgments. Per contra, the learned additional Solicitor General would submit that same trial for the same offence would mean under the same act, same penal code. It would not mean that under a different statute for a different offence. He would submit that if this submission is accepted, no person can be tried under different statutes if they are once tried under the penal statute, i.e. the IPC. Therefore, would seek a dismissal of the petition. I have given my source. Therefore, narrated facts are not in dispute. They lie in a narrow compass as to whether the trial of the petitioners that is now on in Special C 233 of 2018 would be a trial twice over. What the conviction, twice over the conviction that is already suffered by the petitioners. The submission that it amounts to double jeopardy is, it is to say the least preposterous, as section 300 of the CRPC reads as follows. Section 300 deals with a conviction, a trial that is already ended in conviction under the IPC cannot be tried again for offences under the IPC arising out of the same facts. Therefore, the submission would merit acceptance. Submission qua 300 would merit acceptance only if there are two FIRs registered on the same crime and two FIRs are separately tried and separately convicted, or one following the other is convicted. Therefore, the submission that it should be paraphrased to the proceedings under the PMLA cannot be accepted. In the light of the conviction of these petitioners, there cannot be any interdiction of the proceedings before the special court arising out of the PMLA. The submission that it does not amount to proceeds of crime is a matter of trial for the petitioners to come out clean in its full-blown form in Special CC 233 of 2018. Insofar as the judgments relied on by the counsel Krishnappa is concerned, relied on to the judgment in the case of Razor Pay Private Limited, that was not a case of conviction. That was only at the stage of at a preliminary stage where it was quashed in the light of the predicate offence not making out any offence, or section 3 of the act, section 3 of the PMLA section 3 of the PMLA not becoming applicable to a payment aggregator or a payment gateway the Razor Pay. Insofar as the other judgments relied on are concerned, they are distinguishable without much ado. The apex court was considering two proceedings in common under the IPC, where two crimes were registered and two trials were being conducted. It is in that circumstance the apex court relied on section 300 and obliterated the proceedings on the score that it would be in violation of article 22 of the Constitution of India.
My submission that PMLA is an independent standalone.
So and so. The said judgments on the face of it would not be applicable, as the apex court in a three-judge bench of the apex court considering all these submissions in Vijay Madanlal Chowdhury versus so and so 2022 SEC online SC page 929 has steered clear the controversy as to whether it would amount to double jeopardy or whether once convicted the proceedings should be continued or otherwise. The court para 465. Yes. In the light of the issue standing completely answered by Vijay Madanlal Chowdhury and the submission of the concept of double jeopardy not becoming applicable to the case at hand, the petition stands rejected. Nimdu adainnenu?
Small correction in the cast title.
Cast title alla. ಈಗ
Number 10, accused number 14 ಅಂತ ಮಾಡಿದ್ದೀವಿ. It should be 13.
ಆಯ್ತು ಮಾಡ್ಕೊಡಿ. ನಿಮ್ದು ಅಷ್ಟೇ ಇನ್ನೇನು ಅಷ್ಟೇ ಸೇಮ್ ಮಾಡ್ರಿ. ಎಸ್
Correction. Permitted to correct.
ಆಯ್ತು ಮಾಡಿ. ಎಸ್ 2 years entry ಮಾಡಿರ್ತಾ ಇದಕ್ಕೆ.
We had even filed a IFR vacating stay. Expeditious trial.
ತ್ರಿಬಲ್ ಜಿಯೋಪಾರ್ಡಿ ಯಾಕೆ ಬಿಡಿ, ಮಾಡ್ಲಿ ಟ್ರಯಲ್ ಆರಾಮಾಗಿ. ಎಸ್
69. Waiting for the petitioners, my lord.
16 offense 69
Illa, serial number
16. Yes.
My lord, the petitioners, my lord, are accused number 3 to 6 before my lord.
Buds Act, sir.
Please, my lord. My lord, for a moment, the case of the prosecution is that accused number 1 and 2, my lord, who are the parents of petition number 1 and 2, were running, my lord, chit business, my lord. The case is that, my lord, my lord, the complaint, my lord, had subscribed to the said chits, my lord, and in for a tune of 3 lakhs and had paid 20 installments, my lord. Case is that they have misappropriated the fund, my lord. May I take my lordship to the charge sheet allegations, which is in page number 39.
ಸ್ಟೇ ಇದೆ ಇದರಲ್ಲಿ.
Stay there. My lord, charge sheet allegations.
Buds Act ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ?
My lord, may I take my lordship to the charge sheet allegations? I'll just read one paragraph, my lord, to show my lordship. Page number 40.
ಎಲ್ಲ
my lord,
ಇವ್ರಿಗೆ ಬರಕ್ಕೆ ಹೇಳಿ. Where is SPP?
respondent is served. They've remained.
ಅವ್ರು ಬೇಡ, SPP ಸಾಕು. ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ಅವ್ರೇನ್ ಬೇಕಾಗಿಲ್ಲ. ನೀವೇನ್ ಚಿಲ್ಡ್ರನ್?
Children and relative, my lord, to show that there are prima facie material against the petitioner, there's absolutely nothing, my lord. In so far as the petition number 1, that is accused number 3, my lord, there is transfer of money to his account. In so far as accused number 4 to 6 are concerned, there is absolutely no materials. For a moment, if I can take my lordship to the charge sheet, Dinanka
ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ.
Entry
So enjoy it for some more time.
All right.
Buds Act I will not interfere.
Oblige me.
List on 15th. Ask SPP to come in this.
Oblige me.
Yes, next. Entry model stand section.
70.
Your lordship, here, there are so many G&WC two child custody petitions.
ಒಂದು
by-
ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ ಅಲ್ವಾ?
Yes,
Yes.
WP has
ಇದೇನ್ ಪೋಕ್ಸೋ
already-
ಕೇಸಾ?
This is POCSO, and one more is there, organized crime.
Organized crime, I asked, SPP ಅವರೇ, organized crime I had asked the investigating officer. 111 ಹೆಂಗ್ ಹಾಕಿದ್ರಿ? No, that's a grave offense that you have added in a matrimonial dispute. No, oversight ಏನ್ ಬಂತು? ಎಷ್ಟು ದಿನ? When was it added?
It was on 16.
ಯಾಕೆ ಇವರೆಲ್ಲ ಬೇಲ್ ತಗೋಬೇಕಾರೆಲ್ಲ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಐವೋಗೆ? No, sir, you can't protect this IO like this.
It was very much intentional, your lordship.
Absolutely intentional.
Because
In a
just to
matrimonial dispute, how can you invoke COCA, sir?
It is to make section 88 cognizable to file an FIR. They are invoking 111.
How did he invoke 111? No, this man should not be spared. This can't be the case at all. Where is he? Is he present? No, we will direct initiation departmental inquiry against him. How can he invoke organized crime in a matrimonial dispute? Seriously? No, whatever it is, how can you invoke intent by oversight 3 ವರ್ಷ? ಯಾಕೆ ಐವೋ ಅಪಿಯರ್ ಆಗಿಲ್ವಾ ಎಲ್ಲ ಕಡೆ? It is intentional.
Your lordship, in POCSO also it is intentional only.
POCSO will consider. First will organized crime will, POCSO will have to answer it.
Yes.
How did he invoke? It's misuse of power. Absolute misuse of power. What's his name?
Krishna.
Is he not present? Ask him to be present tomorrow.
Krishna Kumar.
Tomorrow at 2:30 PM, ask him to be present. Yes. Tomorrow, ask him to be present at 4:30. List this matter tomorrow at 4:30 PM.
POXO, your lordship.
Other, Poxole trial ಆಗ್ಬೇಕು.
Your lordship, here, only for 15-1, they are doing the charge sheet, only for 15-1 and 21, wherein they are arresting her immediately after filing a charge sheet and
Those bygones, let it be bygones. What is present, we will take it. And Poxo, I am not going to interfere.
your lordship, in POXO, I have certain submissions
You
in that
make
matter.
us, I'm going to hear you. I'm not saying I'm not going to hear you. I'll hear you.
Yes,
But
because
Poxo prima facie, I am going to permit further proceedings. This organized crime, I
But in
will.
POXO, there are certain things which I want to bring to the knowledge of this court, wherein husband actually has committed that under section 21 here. He has concealed those photographs for 1 month, and I have the proof. He is filing it in the family
Now,
court.
1 minute. Poxo, you are the wife, is it?
I'm the wife.
What
He's
is the,
filing it on
1
me.
minute. What is the allegation for Poxo against her?
The daughter of CW 15. He's the nude films of the child, female child of who is the daughter of CW 15 was taken by A1. That is
Who is A1?
A1 Jagannath.
ಅಯ್ಯೋ ಯಾರದು ನನ್ನ ಹೆಸರಲ್ಲ A1 ಯಾರು?
He is the brother-in-law of father of child, and he shared the photo to Diksha.
Your
A2.
Who is Diksha?
The second A2, who is the husband of
Your lordship, I'll give
ನೀವು
clarity.
ಅಕ್ಯೂಸ್ ನಂಬರ್ ಅಂತ ಹೇಳಿ ಸರ್, ನೇಮ್ ಹೇಳಿದೆ.
Diksha is the wife of the complainant. So the brother-in-law of the father of the child took the nude photos of the child.
ಆಯ್ತು, ಒಂದ್ಸರಿ ಹೇಳಿ, ಎಷ್ಟು ಸರಿ ಹೇಳ್ತಾ ಇದೀರ ಅದನ್ನ? ಸಾಕು.
Yes, and my lord, there are voluntary statements. Voluntary statements of both the accused have been recorded. There's 161 statement of the complainant, father of the child has been recorded. And as your lordship knows, we are at the.
I don't know anything, sir.
As your lordship is well aware.
ಅಯ್ಯೋ, ಎರಡು ಒಂದೇನೆ.
No, my lord, my lord, my submission is that we are at the pre-trial stage. At this stage, my lord, the voluntary statement of the accused has to be considered. And what portion has to be considered, what portion has to be eschewed, that needs to be considered only at the time of trial. We are at the pre-stage. So voluntary statements of the both accused are there, and they divulge the fact that what they have done, they have admitted.
ಸತ್ಯವಚನ್.
So that needs trial.
Your lordship, only one.
No, tomorrow we'll take it. Poxo.
But let me make my submissions.
Yes,
with
you
respect
make
to
your
POXO,
submissions.
Because I want to bring forth the illegality the husband has committed over this, and the 1 month time he kept those photos are not pornographic photos, your lordship.
You have registered a complaint.
I thought first I will represent it in front of this honorable court. In fact, I informed this to the sessions court, and the sessions court asked me to lodge a PCR with respect to that.
Did you? You
No,
did
your
not.
lordship. No, your lordship, because now I got the proof that he had the documents with him on 28/4, and he's
You have-
lying in the
You have
FIR.
you have not registered a complaint, right?
I got it now.
No,
from
it's
the
all right.
court.
Till now you have not registered.
I have not.
Then it is what it is. You
I
can't.
want to
Yes.
make that submission in front of, because it's there in his complaint, your lordship.
Hmm.
It is there in his complaint that he's saying only on 22nd May 2025, he is coming across those pictures after he took the printout on 17/4.
Alright.
He was not even curious to know what was in the picture.
Naale 4:30 ask him to be present. Yes.
And it is the same IO is doing it, and I have the proof that he had the details with him.
Tomorrow.
Which you blessed.
71.
ಅದು ಅವ್ರದೇ. Same.
72.
Siddharth.
A short passover, sir.
This
just
is that
12 to-
certificate has been issued by the doctors to obtain seats from institutions.
Medical
Take
college.
Medical. Fitness certificate.
My lords, kindly pass it over, sure.
Tomorrow fresh matters.
My lords, kindly pass it over.
Tomorrow fresh matters.
My lords, on 17/4.
Tomorrow fresh matters. Yes. Next.
73.
Yes, Samir.
Your lordship's order dated 25/4/2026. In the event no submissions are made, this court would be constrained to grant an interim order of stay. Now, this is that matter, this is the DV Act proceedings, which is before the Mysore court, wherein the wife is filing multiple separate proceedings in different locations seeking the same relief. Now, with regard to demonstrate that, I filed a memo on 3/7/2026 to show before lordship that she is asking for the same reliefs in Tirur and in another proceeding in Mysore.
What same relief, sir?
If your lordship were to please come,
You are for the husband.
I am for the husband.
What relief? What same relief?
if your lordships were to please see.
No, first tell me what same relief before taking me to the document.
Yes, say monetary relief of maintenance.
ಅಷ್ಟೇ
Now
ತಾನೆ?
per month, I can in fact state on affidavit, my submission before lordships today
Affidavit
is,
ಏನ್ ಬೇಡ, statement ಹೇಳಿ ಸಾಕು.
yes, my submission is per month I am paying a cumulative sum of 37,750.
Only for the wife or child?
Wife and children. In addition to
How many
that,
children?
there are 3 children.
Ah.
2 of them are 18 years old, 1 is 17.
All right.
In addition to that, all their educational and health related expenses also I'm undertaking, I've produced before your lordships.
All right.
Bank account statements, all educational bills, everything.
All right.
Now, her only grows insofar as DV is concerned, if lordships were to see her petition before the subordinate court, she is only aggrieved.
Seeking what?
No, she is alleging domestic violence.
Correct.
Now,
Now why are you here?
I am here because
Challenging the entire proceedings?
Entire proceedings. My respectful submission is, insofar as domestic violence is concerned,
Anything else?
permit me to make my submission.
Will permit you. List after 2 weeks.
There is no interim order.
There is no interim
My
order.
only
Aditya,
respectful, in
list
fact,
after 2 weeks.
if your lordships were to please see, lordships took
List the
cognizance
matter
of all of-
on 28th in the fresh matter.
Can I suggest one thing before lordships? I will file an affidavit before this honorable court,
Saying what?
stating that I will continue those payments which I'm making from 2021. There was separation from 2021. There was a second marriage in January 2024. Those payments I'm continued to make. There is no difficulty insofar as that is concerned. But there are in fact 3 Damocles sword hanging over me in 3 separate proceedings. That is my respectful submission.
Yes, Ranjan.
No, that is not the.
Payment is made or not?
Right. My lord, 25,000 towards the, my lord, to the wife is paying, and rest, my lord, education things is being looked after by him.
He is paid.
Yes.
Then what's the acts that you have to grind against him?
My lord, I'm saying, my lord, that there is an allegation from 2016 to 2024.
Allegation?
Throughout that time, my lord, he has an illicit relationship, which eventually, my lord, led to his marriage with the second one. Now that there is allegation of harassment by him, my lord.
Anyway, we'll hear it on 22nd. Yes.
Can I be protected in some manner?
28th.
Because I'll file my affidavit.
What protection you want, sir?
My respectful submission is I'll file an affidavit here. Let the proceedings before the Mysore court be stayed.
No.
I'm going to continue making payments to her. I'm not shying
Yes.
away from that fact at all.
No problem. You continue to pay. Not a problem.
Because there is
We'll see. List on 20.
there is double
ಏನ್
enrichment.
ಅದ್ರಲ್ಲೇನ್ ಅರೆಸ್ಟ್ ಆಗಲ್ಲ ಬನ್ನಿ ನೀವು.
Arrest ಆಗಲ್ಲ. But my
ಮತ್ತೆ?
only respectful submission, ನಾನು ಕೊಡೋದು ಕೊಡ್ತಾ ಇದೀನಿ, ಅವರು ಪ್ರೊಸೀಡ್ ಮಾಡೋದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಇದು ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಅದು ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಮೇಂಟೆನೆನ್ಸ್ ಅಲ್ವಾ?
She has asked for the same relief there, and in fact, I just
That I will tell.
In fact,
If that relief is sought, I will state.
she's asked for the same relief. I'll show it to
Don't take double, triple payments.
No, my lord. What is happened is one at Tirur, my lord, is filed for recovery of the valuation of the amount, my lord, which
Please
is
see
sold
that
by him.
memo. I'll just show that memo.
Nothing.
No, my lord,
Yes.
it's a different
I have filed the
See,
memo on
list on
3/7.
28th in the
May I
fresh
just
matter.
show the memo?
Next.
Can I at least have it in fresh matters? Please?
Fresh matters, 28th, yes. Next. 28th, on 28th, yes.
74, objection is ready, my lord.
Objections? Counsel for the petitioner, respondent files his objections. List the matter on 22nd. Yes, next. Barshram?
75.
This is the matter regarding, my lord, explosives, which in fact.
Night.
ಇಲ್ಲ
Night ಅಲ್ವಾ?
ಎರಡು ಗೋಟ್ ಸತ್ತೋಗಿದ್ದು.
Oh, goat ಸತ್ತೋಗಿದ್ದು, correct.
In fact, the net effect of the loss, even according to the complaint, is about 15,000 rupees. While granting the interim order, my lord, the lordships has said, my lord, some amount, my lord, the lordships will indicate, my lord, we will pay the amount. Our notice ಹೋಗಿಲ್ಲ, respond to complainant. Lordships may should notice, my lord, let them come before your lordships.
ಅವರು ಕೇಳಿದ್ ಕೊಡ್ತೀರಾ?
15,000 rupees the loss they've incurred.
ಏನು ಗೋಟ್ಗೆ?
ಎರಡಕ್ಕೆ.
ನೀವು ಎಲ್ಲಾದ್ರೂ ಗೋಟ್ಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು 15,000 ಅಂತ ಫಿಕ್ಸ್ ಮಾಡಿ ನೋಡೋಣ.
ಅಲ್ಲ, that is their
10 times ಕೊಟ್ಟು ಬರ್ಬೇಕಾಗತ್ತೆ.
They valued their, in the complaint, they valued it at 15,000 rupees.
Anyway, lest the matter, emergent notice to the respondent. Further proceedings where the petitioner shall remain state subject to the condition that the petitioner would make good the loss of the goats that the complainant has suffered. ಮತ್ತೆ ಗೋಟ್ ಕೊಡ್ಬೇಕು ಅಲ್ಲ ವ್ಯಾಲ್ಯೂ.
ಮತ್ತೆ ಹಿಡಿಯಕ್ಕೆ ಹೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ.
ಹಾ?
ಮತ್ತೆ ಎಕ್ಸ್ಪ್ಲೋಸಿವ್ಸ್ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಕಷ್ಟ.
Next. Here for the petitioner. 713.
Let's 13E.
Misconduct.
ಅಲ್ಲ.
Disproportionate.
ಅಲ್ಲ ಅಲ್ಲಿ
13D ಅಂತ.
My charge sheet puts it at 19%. The discharge order puts it at 17.4%.
17.4.
Disproportionate quantum.
Quantum.
And now the discharge order says that if it is less than 10%, we can just put it out. If not.
7% ಆ ಕಡೆ ಈ ಕಡೆ.
Our pleadings ಅಲ್ಲಿ 12% ಏನೋ ಒಂದು calculation ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ 10 ಮಾಡ್ಬಿಡೋಣ.
My only respectful submission is, this is not the forum where this has to be done.
ಅಲ್ಲೇ 10 ಮಾಡಿಸ್ಕೊಂಬಿಡಿ.
ಹೋಗಿ ಅದೇನ್ 12% ಅಂದಿದ್ದಾರೆ, ಅದನ್ನ 10% ಅಂತ ಒಂದ್ 2 ಪ್ರಾಪರ್ಟಿ ಡಿಲೀಟ್ ಆಗ್ಬಿಟ್ರೆ ಮುಗಿದು ಹೋಗ್ಬಿಡುತ್ತೆ ಕತೆ.
8 weeks ಅಲ್ಲಿ ಮುಗ್ಸಕ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ಟ್ರಯಲ್ ನ.
ಅಷ್ಟೇ
8 weeks ಅಲ್ಲಿ ಟ್ರಯಲ್ ಮುಗ್ಸಕ್ ಹೇಳ್ಬಿಡ್ತೀನಿ. I'll record all this and say 12% ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ, if it comes into 10 ಮುಗಿಸ್ಬಿಡಿ ಅಂತ.
ಪ್ಲೀಸ್ ಅಷ್ಟೇ.
ಬೆಸ್ಟ್ ಕೆಲಸ ಅದು.
ಅವರು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಹೇಳ್ತಾರೆ ಟ್ರಯಲ್ ನಡೆಸಿದ್ರು ಗೊತ್ತಾಗತ್ತೆ ಟ್ರಯಲ್ ಅಲ್ಲಿ ಹೇಗಿರುತ್ತೆ.
ಅಲ್ಲ ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತು.
ಅದು ಸಿಸ್ಟಮ್ ಅನ್ನೇ ಬ್ಲೇಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು. ನಾನೇನ್ ಹೇಳಿ ಅದಕ್ಕೆ.
It's not a.
So my lords, my learned friend here is agreeing that this is a shorter route for him, not the right route
ಈಗ
necessarily.
ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆಯಾ?
ನಡೀತಾ ಇದೆ. ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಅಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಟ್ರಯಲ್ ನಡೀತಾ ಇದ್ರಿ, ಈಗ ಎಲ್ಲ ಇಂಟರ್ಫಿಯರ್ ಆಗ್ಲಿಲ್ಲ.
ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಷನ್ ಆಗಿ ಜಸ್ಟ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ, ಇನ್ನು ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಆಗಿಲ್ಲ.
ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ನಾನು ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತೀನಾ? ಆಗ್ತೀನಾ ಹೇಳಿ.
ಡೆಫಿನೆಟ್ಲಿ.
ಹೌದಾ? ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
If my lords accepts my contention, only 2 points. ಒಂದು ಎರಡೇ ಇನ್ಕಮ್ ಪಾರ್ಟ್ ಅನ್ನ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. Only 2.
Can I do it in 482 sir? Yes, what is all this? Can I delete the assets in 482? Hey, ಇದು ಸರಿ ಇಲ್ಲ, ಇದು ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳಕ.
I'm not seeking for the deletion. I'm seeking for the inclusion of the income. What is on the face of the
record? Can that also be done under 482 sir?
The trial court having seen, they have cited, may kindly 2 minutes. They claims that, I have not received a particular income from my brother-in-law. He has been cited as a witness. His statement recorded under section 161 has been made as a part and parcel. Under section 173(6), they are citing him to prove the case of the prosecution. One hand they says yes.
Adike, I will direct the court to consider it and close it. I will not either add income or subtract income here.
Only two
or say
components.
these 2 properties illa idu nange I don't like, so remove it.
Only 2 components. Only 2 components. I am not disputing other aspects.
No sir.
Only 2 components. It will not take more than 5 minutes because.
No, that's a different thing, but I will not do it.
It is declared under the income tax.
You show me one judgment.
Yes, please.
Of this court, apex court.
Yes.
That under 482, I can remove income, add income, all that.
Please, my lords, in the recent judgment of the apex court, my lords, the apex court has done that exercise, my lords.
Apex court yen bekar madbodu.
The apex court is in the Nirankar Nath Pandey. The apex court has exercised and he said it is a limited exercise. We are doing it and my lords, that is what happened, my lords. It is only because I am not asking the entire, my lords, the assets expenditure income has to be decided.
List on 20, ಯಾವ್ದು ಹಾಕಿದ್ವಿ madam ಇಂದ?
Lords, I need to file my counter in that case.
Counter ಹಾಕಿಲ್ವಾ?
ಹಾಕಿಲ್ಲ. 26 matter ಮೊನ್ನೆ notice.
ಅಷ್ಟೇನಾ? List the matter on 29th July. Objections if any by the respondent by then.
Please. Oblige.
Next.
77.
Post immediately after service of notice upon the respondent.
78.
Next. The interim order ಇದೆಯಾ? ಇಲ್ಲ. Yes. Next.
78.
78.
Yes, I am filing a memo. R2 is not a necessary party.
R2 complainant alva?
R2 complainant.
Why not necessary party?
Because I filed for lifting of the lien, my lords. And
lien lifting.
Lien lifting.
ಅದಕ್ಕೂ ಸರಿ ಕೊಡಿ. ನೀವೇ complainant ಆ?
I am not the complainant, but I am also one of the victim and complainant in Chennai, my lords, not in.
Files a memo that R2 is not a necessary party. The memo is taken. R2 is no notice is issued to R2 at the risk of the petitioner. Yes,
Lords, he's a 60-year-old, my lords.
I
bank
will
manager.
list the matter on 16th July. Next.
My lord, serial number 77, date may be given, my lord.
No, yes, next.
79.
Petition. It's a cancellation of bail. That because of whatever all these things happened, now things have been changed. I think that caste certificate we could not get it about the complainant. Otherwise, B report is ready.
Lord, Tahsildar is intentionally harassing the petitioner.
Again, stay madbeka.
Stay alla. The Tahsildar is the one who is not giving the caste certificate of the petitioner.
ಈಗ ಕೊಡ್ತೆ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
Even repeatedly the petitioner visited the Tahsildar and even the police visited the Tahsildar. They are simply writing that the petitioner is not in the station. My lord, actually
who is the complainant?
The complainant is a private party, madam.
Correct. ಈಗ ನಿಮ್ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ವಿಷಯವಾಗಿ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ?
ತಹಶೀಲ್ದಾರ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ ಈಗ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನು?
Cancellation of bail is challenged.
Cancellation. And one more petition is pending, that is in
ಅವ್ರ ಬಿ ರಿಪೋರ್ಟ್ ಆಕ್ಟ್ ತಹಶೀಲ್ದಾರ್ಗೂ ಇದಕ್ಕೆ ಏನಪ್ಪ ಸಂಬಂಧ?
B report.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ ಅಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ ಏನ್ ನಿಮ್ಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂದ್ರೆ ಏನರ್ಥ?
CGP submits that they are going to file a B report.
ಸ್ವಲ್ಪ ಏನ್ ಇಶ್ಯೂ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದೆ.
This is a case where mob lynching happened. It was extensively submitted.
ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತಾ ಇದಾರೆ?
There is a technical glitch. I was supposed to explain that. Iga, to close that, Tashildar needs to give the B report. And if it doesn't give the B report, the Tashildar needs to give the caste certificate to file a B report. If he, in the government record.
ಯಾವಾಗ ಕೊಡ್ತಾರೆ?
ಅಂತ ಏನು ಹೇಳಿದ್ದಾರೆ.
The learned SPP on instructions and verification of the records would submit that a B report would be filed in due course. B report is not being filed for the reason that the Tahsildar is not rendering the caste certificate that he has to give. Therefore, if the Tahsildar's lackadaisical attitude in not rendering the caste certificate leads to delay in filing the B report, this court would view the action of the Tahsildar seriously. List the matter on 16th July.
One more petition is pending, that may be tagged along.
23rd, all right.
1 to 8 may be tagged along.
ಅಷ್ಟು ಹೇಳಕ್ ಪ್ರಶ್ನೆ ಆಗಿದೆ.
One submission.
Yes.
One submission. Tahsildar B report ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ ಗವರ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ if I am not in station ಅಂತ ಬರೆದ್ರೆ that is a reason for cancellation of bail.
B report ಹಾಕ್ತಾರೆ.
Yes.
80.
Petitioner in this case.
For number 2, Lordships.
Last occasion.
Lordship, we were been instructed by the clients yesterday night, 9
Night.
How's this?
Don't take instructions in the night. Yes. Tell me what's the matter.
The last occasion is directed the state manager to secure the instructions. Whether the charges are framed.
No, your
charges
Lordship.
Not framed. Yes.
Lordship,
Learned
we file
counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so as appearing for the respondent, list the matter on 6th of August, objections if any, by then further proceedings shall remain stayed till the next date.
Both cases.
Both cases, yes. ಅದಾಗಿದೆಯಾ ಅಂತ ನೋಡಕ್ಕಷ್ಟು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
81.
Appearing for petitioner, accused 7. A7.
So what?
The offense is against me is 399 and 402, my lord. All the accused got acquitted.
Split charge.
Split of charge.
22nd, fresh matters. Yes.
So on
Next date
submission, allow
Come
the
this side.
IA3.
Come to the mic.
Kindly allow the IA3, my lord.
What is IA3?
Stay. For
What is the
interim
next
stay.
date?
August 12th, sir.
ಅಷ್ಟ್ರಲ್ಲಿ ಮುಗಿಸೇ ಬಿಡೋಣ ಬಿಡಿ ಪ್ರೊಸೀಡಿಂಗ್. ಲಿಸ್ಟ್ ಆನ್ 22nd. Yes.
Great.
82.
For the petitioner.
Post immediately after service notice upon the respondent.
The contention is the company is not made as a party. In fact,
ಯಾವ Buds Act?
should have been KPID should have been invoked, but they have not invoked KPID, and I have instructed the officer to seek permission and continue further investigation, include all those things.
ಮಾಡಿ. Yes. List the matter.
Or by judgment.
For what? Company not made a party. I will direct them to make party.
Yes. Dispose ಮಾಡ್ಬೋದು.
ಮಾಡೇ ಬಿಡ್ತೀನಿ ಬಿಡಿ, ತೊಂದರೆನೇ ಇಲ್ಲ. ಏನು offense ಏನು?
Section 4 of Chit Fund Act and 420 of IPC.
ನೀವು ಚಿಟ್ ಫಂಡ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ ಯಾವಾಗ ನೀವು
Like, this is the classic case. KPID should have invoked because the 50,
whatever
90 plus people have invested money and their money has not been returned.
ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
So I have to get their instruction.
ಮತ್ತೆ
ತಮ್ಮದೇ
ಅಮಾಯಕರ ದುಡ್ಡೆಲ್ಲ
ತಮ್ಮದೇ ಪೇಜ್ 80 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಏನಂತ?
ಅದು ಕಂಪನಿ
ನಾಟ್ ಮೇಡ್ ಎ ಪಾರ್ಟಿ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿರೋದು ಗೊತ್ತು. ಇಲ್ಲಿದೆ 80. ಅಲ್ಲ ಅಲ್ಲಿ ರಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಕೊನೆಯಲ್ಲಿ.
ಅದೇ ಮಾಡಿ
ರಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಟು ಇನ್ವೋಕ್ ಕಂಪನಿ.
ಅಲ್ಲಲ್ಲ, only issue with the company. This is
correct. Similar case. ಅದು Chit Fund Act.
Liberty is reserved to cure the alleged defect in their charge sheet in accordance with law.
Yes.
Simple. Same page 80, madam, covered. Same order.
88.
80 and
87 and 88.
Okay, 80 alva.
Adalla 87 ಅಲ್ಲ 80 is the order copy. Yes. Order portion ಇರೋದು it is an
ಅದು ಗೊತ್ತು. ಆರ್ಡರ್ ಪೋರ್ಷನ್ ಮಾತ್ರ ಕೋಟ್ ಮಾಡ್ಬೇಕಾ? ಏನ್ ಬೇಡ.
Your lordship may say, my lord, that.
ಅಲ್ಲೇ ಇದೆ ಸೇಮ್.
Your lordship may also say that we'll explore the KPID Act, one statement.
No, it is open to cure the defect and it is open. ಅಲ್ಲಿ ಬರೀರಿ.
Not in my petition, my lord.
ಅಲ್ಲ, it is open to ಅದು ತೊಂದರೆ ಆಗುತ್ತೆ ಬೇಡ. ನೀವು ಮಾಡಿ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಲಿ ತೊಂದರೆ. ಬಟ್ ಅಲ್ಲಿ ಲಿಬರ್ಟಿ ಎಲ್ಲದಕ್ಕೂ ಕೊಟ್ಟಿದೆ. ಅಲ್ಲ ಅಲ್ಲಿ ಏನಿದೆ ಅದು.
Company only are ಕೊಟ್ಟರು.
That was the defect.
Yes, that was.
Yes, dispose next.
83.
My lord, Senior Counsel M.S. Shamsundar sir has been engaged in this matter.
ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ವಾ ಇವತ್ತು?
In another court, my lords. ನಮ್ದೇ
ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದು?
Kindly have it on tomorrow, my lords.
ಓ ಇದಕ್ಕೆ we'll dismiss it.
I'll rely on various some judgments, my lord.
Yes, nothing doing. Transit bail, transit warrant.
Senior will convince my lords regarding the case.
ಬರ್ಲಿ pass over.
Grateful, my lords.
ಇರಿ.
Some judgments.
Next.
84.
After.
Please.
ಇದಿರಲ್ಲ ಹೆಂಗೋ.
ಇದೀನಿದೆ.
85.
ಪ್ರವೀಣ್ ಗೌಡ್ರೆ.
Sir, the phone what has to be given by one of the accused has been handed over. What is that they have requested for the investigation purpose?
ಅದೇ ಇತ್ತಾನೆ ಕೇರಳ ಟೆಂಪಲ್.
Temple matter.
Your lordship has directed them to give, they gave a mobile phone which does not belong to it. IMEA doesn't support the.
Let them give what which is that IMEA.
ಅಲ್ಲ IMEA ಯಾವುದು ಕೊಡಿ ಅದೇ ಕೊಡ್ತಾರೆ.
ನಾನು ಕೊಡಬಹುದು. Now what is that they sought from me that I have given? Then other phone which was supposed.
Then I will hold it, I will dismiss it saying you are not cooperating with the investigation.
My lords, in fact, ಈಗ ನನ್ನ ಹತ್ರ ಯಾವ ಫೋನ್ ಇತ್ತು ನಿಮ್ಗೆ ಯಾವ್ದು ಬೇಕು ನಾನು ಬರ್ಕೊಟ್ರೆ ನಾನು ಕೊಡ್ಬೋದು. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ದಟ್ ಫೋನ್ ವಾಟ್ ದೇ ವಾಸ್ಟ್. ಈಗ ಬೇರೆ ಯಾವ AMA ನಂಬರ್ ಹೇಳ್ತಾರೆ.
ಯಾವ್ದು ವೆಜಿಟೇಬಲ್ ವೆಂಡರ್ ಫೋನ್ ಕೊಟ್ಟಂಗಿದೆ.
Now my notice to them has the IMEA number. ಅದರಲ್ಲಿ ಇದೆ. Just giving same. They can't say that.
With respect to A9, my lord.
Prosecution communicates the phone to be handed over for the purpose of forensic examination. The model of the phone is indicated along with its IMEI number. It reads as follows. It was iPhone 13 Pro Max. What the accused have done is that handed over a iPhone 13 Pro Max, no doubt, but 679 with a different IMEI number. Therefore, the petitioner shall. ಇದು ಇದೆ ಅಂತ ಅವ್ರ ಹತ್ರ ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ?
That is the my mobile
All
phone
records.
use. Yes.
The learned SPP submits that the said IMEI was sought on the score that the call record details were available from that the phone that had that IMEI number. Therefore, the petitioner shall forthwith hand over the phone with the same IMEI number now that they are aware of it. Yes.
Lords, may I make one submission?
Yes, sir.
In fact, with respect to A9, my lord, that's petitioner number 1, my lord. In fact, that phone when they sought with him during the course of investigation in the earlier stage, before filing charge sheet, in the remand application also they have mentioned that this phone has not been handed over by me, and that's the reason where they said that they want for the police custody. And subsequent to that, I have not even handed over. I didn't even have that phone.
ಈಗ ನೀವು ಫೋನ್ ಕೊಡದೆ ಹೋದ್ರೆ I will say not cooperating with the investigation and close.
May I
it.
make one submission?
Yes, sir.
With respect to one petitioner, I am making this submission. Another petition, whatever this IMA number with whom it belongs to.
ಅದೆಲ್ಲ ಇದೆ ನೋಟಿಸ್ ಅಲ್ಲೇ ಇದೆ ಎಲ್ಲ.
I will if that is so, if the phone what has not been handed over is totally different from what they have given is, I will hand it over, my lord.
Yes,
if that
sir.
is so.
Yes.
Now, my lords, in fact, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ in fact your lordship is very well aware of that. ಮೊನ್ನೆ ಹೇಳ್ಬೇಕಾದ್ರೂ your lordship expressed that your lordship has heard for many number of times with respect to this matter. Yes. ಇದರಲ್ಲಿ ಫೋನ್ ಬಗ್ಗೆ ಕೇಳ್ತಕ್ಕಂಥದ್ದು ಹೋಯ್ತು ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ, they have sought in the earlier occasion itself. It's not that I'm not denying that I'm not going to give the phone. Even otherwise, my lord.
The offenses alleged are horrible. It is grave. So this has to be taken to its. ನೀವು ನೋಡಿಲ್ವಾ?
I have argued this matter in the trial court. Tam gamnak ತರ ಸ್ವಾಮಿ phone ಅಲ್ಲಿ ಬರ್ತಕ್ಕಂಥದ್ದು my account transaction they want or the messages or phone records what they want. They can always get it. If that is so, they can always get it collected. They've already collected the phones of another accused to whom they say that I have discussed. They can also extract from that particular
ಈಗ
phones.
ಇದು ಕೊಟ್ಬಿಟ್ರೆ ನೀವು ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. Yes. List the matter on 15th in the fresh matters list. ಈಗ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೊಟ್ಬಿಡಿ. Yes, Jag 80 Chandrasekhar.
Number 2, Your Lords, may I produce a document, Your Lords?
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
Your Lords, the blank document which was signature which was affixed, that was created by the accused number 1 petitioners and accused number 3. Your Lords, 52,85,000 respondent number 2 obtained loan by way of account. Your Lords, by obtaining loan from Friar Bank, 55 lakh is handed transferred to petitioner number 1 and accused number 3.
It is admitted.
Your Lords, in the kindly
ಕೊಡಿ ಅವ್ರಿಗೆ ಅದೇನು?
that the document which they themselves have.
What's the document?
Your Lords,
What's the document?
Your Lords,
During pendency of proceedings under 138 of NAC Malad, the accused in 138 NAC matter Malad, after 3 years of after 3 years of filing of the PCR complaint, almost at the verge of argument on merit Malad. He filed a complaint under section 420 and read with 34 against this petitioners.
Lords, on 6th, I got loan.
138 ಆಯ್ತಾ ಈಗ?
138 pending ಇದೆ. ಅದರಲ್ಲಿ
That
ಕ್ರಾಸ್
is there for
ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
cross-examination. On 6th,
ಅದ್ ಮುಗಿಸ್ಕೊಳ್ಳಿ.
on 6th, I have transferred the amount. Your Lords, the property which is standing in my name.
ಯಾರು 138 ಹಾಕಿರೋದು?
ನಾವು ಹಾಕಿದೀವಿ. ನಮ್ಮ ಮೇಲೆ ಅವರು 3 ವರ್ಷ ಆದ್ಮೇಲೆ 420 ಹಾಕ್ತಾರೆ.
Your Lords, the amount.
ಈಗ the best thing is sit and settle the issue. ಎರಡು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ.
ಅವ್ರು ಕಾಂಪ್ರಮೈಸ್ ಮೆಮೋನು ಕೂಡ ಹಾಕ್ತಾರೆ ಅದರಲ್ಲಿ.
Sit and settle the issue.
Please, Your Lords.
Yes.
My submission.
List the matter on 16th, otherwise I'll quash this. Sit and settle it.
Your Lords, own submission, Lords. On 6th, I
ಮತ್ತೆ
transferred the
ಅದನ್ನ
amount.
you tell that 6th on 16th.
7th, on 7th, they, without my knowledge, on the blank paper which I affix signature, they transfer the create sale agreement.
ನಮ್ಗೆ 55 ಲಕ್ಷ
Sale agreement.
ಕೊಂಡಿರ್ತೀವಿ, 13 ಲಕ್ಷ ಬರ್ಬೇಕಷ್ಟೇ.
ಆಯ್ತು.
Whatever amount, 52
Fine,
lakhs.
sit and settle it, sir. Yes. Next.
Entry matter to
We'll continue.
87.
Okay.
List of 2 weeks and 21. Yes,
Split up charge sheet.
22nd. Yes.
17th August,
Fresh
next date of
matters.
hearing is there.
The further proceedings before the concerned court where the petitioner shall remain state. Next.
88.
138 proceedings. The check amount is involved in 70 lakhs. It was
Post
paid by
immediately after.
cash.
Serve ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ತಗೊಂತ ಇಲ್ಲ ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಆಲ್ರೆಡಿ ಸರ್ವಿಸ್ ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು ನೋಡಿ.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
Next date ಏನು? 16th fresh matters. Next. Post immediately after service notice ಇದೆಯಲ್ಲ. Police report ಯಾಕೆ 138?
ಇಲ್ಲ ಹೌಸ್.
Yes.
ಕೈಂಡ್ಲಿ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಮೇಲೆ.
Emergent notice to the respondent. Yes, next.
88.1 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡರ್ ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್.
Entry ಮಾಡ್ರಿ ಯಾವ್ದ್ರಲ್ಲ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಮೇಡಮ್. Next.
89.
ಇಲ್ಲ ಅಂದ್ರೆ next week ಹಾಕ್ತಾರೆ ಮೇಡಮ್. After 2 weeks, yes.
90.
Character matter ಇದೆ ಸ್ವಾಮಿ, ಅದು ಬಂದಿಲ್ಲ.
Tag along with so and so, rest after 2 weeks. Next.
Thank you, Mr.
91.
Petitioner, my lord, I'm seeking time because they have already filed charge sheet ಅಂತ ಹೇಳ್ತಾರೆ. I will.
Challenge the charge sheet. Yes. Charge sheet format. Next.
Both matter.
Both.
92.
91 ನಲ್ಲಿ ನಂಬುದ್ರಲ್ಲಿ ಚಾರ್ಜ್
91 charge sheet ಆಗಿಲ್ವಾ ನಿಮ್ದ್ರಲ್ಲಿ?
91.1 ಅಲ್ಲಿ ಆಗಿಲ್ಲ.
91 ಅಲ್ಲಿ ಆಗಿದೆಯಾ?
91.1 ಅಲ್ಲಿ ಅವ್ರದ್ರಲ್ಲಿ ಆಗಿದೆ, ನಂಬುದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ.
91.1 D-link post next week interim post of 2 weeks interim order continues. 91 ಅಲ್ಲಿ charge sheet format. Next.
Petitioner in this case.
92.
Regard to 112 clarification whether the counter case has been filed.
After 2 weeks IO. Next.
Entry ಮಾಡಿ.
Continues.
93,
Purely civil dispute.
Interim order ಇದೆಯಾ?
No, fresh matter. Purely civil dispute. Parties are before an arbitral tribunal of 3 retired Supreme Court judges. Entire dispute emanates out of an investment agreement of the year 2022. The respondent number 2 is the claimant before
One
the.
HCGP 2 emergent notice. The petitioners are before the court calling in question the proceedings in crime, in registration of crime in crime number 157 of 2026. The parties to the list are before the arbitrator. NCLT, you know,
Operation mismanagement is also pending.
and
between them.
and proceedings before the National Company Law Tribunal. On the same set of facts brings the crime, on the same set of facts, the criminal law is set into motion by the second respondent complainant in an issue which arises out of a financial transaction. In that light, there shall be an interim order of stay of further proceedings, square the petitioner to the next date of hearing. Next.
On the day when it is registered for this kind of an allegation, LOC is taken out against me. Lordship may
ಈಗ
just
ಸ್ಟೇ
protect
ಮಾಡಿದ್ದೀನಿ,
me.
ಅಪ್ಲಿಕೇಶನ್ ಒಂದು ಹಾಕಿ ಅದಕ್ಕೆ. ಎಸ್,
I'm good.
ನೆಕ್ಸ್ಟ್.
94,
So the petition. This is that Melkote temple matter, my lords. The last occasion, my lords had asked.
ಟೆಂಪಲ್ ಫಂಡ್ಸ್ ಹುಂಡಿ
Hundi.
ಅದರಿಂದ ಕದ್ದು ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತ.
No, my lords. At last time, like 3 contentions raised, my lords. One is with regarding to the delayed complaint, and on the same day, FIR has been registered.
and secure record.
Another thing,
I asked the CCTV footage and other things. ಮೇಲ್ಕೋಟೆ ಟೆಂಪಲ್ ಹುಂಡಿಯಿಂದ ದುಡ್ಡು ಕದ್ದಿದ್ದಾರೆ ಅಂತ. Day after tomorrow. List day after tomorrow in the fresh matter.
my lords, some protection, my lords.
No, ಏನು ಹುಂಡಿ ಪ್ರೊಟೆಕ್ಷನ್ ನಾ?
My lords, there is no,
ಮತ್ತೆ?
my lords,
ಪ್ರೊಟೆಕ್ಟೆಡ್ ಹುಂಡಿನೇ ಕದ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಇನ್ ಪ್ರೊಟೆಕ್ಷನ್ ಏನು ಬೇಕು?
ಇಲ್ಲ, my lords, allegation ಇರೋದು incident happened in the month of January. FIR is in the month of July.
So what?
June.
ನೋಡೋಣ.
Please. Until then, the protection might
CCTV
be given.
footage ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, just check. Day after tomorrow, fresh
That
matters.
might be, my lords, but not with respect to accused number 6, my lords.
Noted.
Simply implicated because he is Indo servant. That is the only
Wait,
reason.
sir. One ನಿಮಿಷ. Yes. Next.
Fresh matters, my lords.
ಹೌದು
Next.
sir.
55,
2 weeks. ಇಲ್ಲ ಅಂದ್ರೆ 2 weeks ಆಗ್ತಾ ಇದೆ ಮೇಡಮ್.
6,
In this matter, I'm appearing for respondent. I'm filing my wakalat today for respondent number 3.
ಬಿನು
6, I appear for the
96.
ಮಯೂರಿಟಿ ಬಾನು ಅದು 97 ಮೇಡಮ್.
Trespass case.
ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ 97 or 96?
I'm for 96.
ಮಯೂರಿಟಿ ಬಾನುಗೆ ಅಪಿಯರ್ ಆಗ್ತಿರೋದಾ? ಆಗಾರ 97.
For trespass case registered against original owner. my lord. So my father purchased this property in the year 1968. my lord. Thereafter, all.
Who is in possession, sir?
Lord, I am in possession of the property. Some third party.
You are in possession.
I'm in possession. my
Suit
lord.
ಹಾಕಿದ್ದೀರಾ?
Lord, I filed a suit.
Who has filed a suit?
I have filed a suit.
For what?
For bare injunction, my lords.
Bare injunction.
Oh, kindly see that. My lords may kindly have it.
Injunction
after
is
a week I filed
granted?
my- Yes, my lords. Expert injunction is granted.
Maybe file
My lord,
application.
kindly wait, my lords, they were served. Kindly see that documents, my lord. Annexer.
447 is the allegation.
Annexer A, my lord.
Trespass is the
Yes,
allegation.
that's trespass, my lords. Already trespass, Wrongful my lord. restraint, mischief. Page number.
Learned
21,
counsel
my
so and
side.
so undertakes to enter appearance for the respondent complainant. Registry to print the name of so and so is appearing for the complainant 21st in the fresh matters list. Objections, if any, by then.
One grateful, my lord. My property is under different property. 21st.
Yes.
97,
One more grievance, my lord. Based on this FIR, my lord, they issued 107 notice, 126 PNSS notice to appear before the deputy commissioner.
Why deputy commissioner? ಅದು separate challenge ಮಾಡಿ. Yes.
Permission ಕೊಟ್ರೆ I will convert into WP, my lord.
ಇದನ್ನೇನು ಕನ್ವರ್ಟ್ ಮಾಡ್ತೀರಾ?
I will ಮಾಡ್ತೀವಿ, sir. Both prayer I sought for in this petition.
ಎರಡಿದೆಯಾ ಇದರಲ್ಲಿ? The petitioner is at liberty to seek the second prayer by way of a separate petition. Yes, next.
97,
I apologize, my lord. 95, I appear 95.
95 ಆ?
Please, my lord.
ಏನಾಯ್ತು 95?
Matter, my lord.
fresh matter.
Husband's not before the court, my lord.
Nobody was there.
I apologize, my lord. I got confused with 96.
85 of BNS.
ಕೊಡಿ ಮೇಡಮ್.
85 of BNS, my lord. Husband's not before the court.
ಓ ಮತ್ತೇನ್?
The in-laws, my lord, and the sister and the brother-in-law are before this court, my lord. The husband is not before this court.
2, 3. ಏನ್ ಎಲ್ಲಾರನ್ನು ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ? 7
72.
the main time.
Yes.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಾ?
It's there, my lord.
Just check. Yes.
I apologize, my lord.
I thought you are appearing for him. Yes.
Lords, this is that NDPS matter which is covered, my lords, by lordship's order.
ಯಾವ್ದು?
But when it is ganja, qualitative and
ಹೈಡ್ರೋ ಗಾಂಜಾನ ಇದು?
no, my lords, it's normal ganja. Lord, two issues, my lords. One, qualitative analysis illa. Ernedu, during the time of weighing itself, my lord, they have weighed it with a cover, and that is admitted even in the 52A certificate issued by the magistrate.
52A ಅಲ್ಲ. ಇದು weighing it together is contrary ಅಲ್ಲ.
My lord, simple
That's what
point.
Supreme Court says.
Simple point, my lords. Hira Singh says neutral substances are to be considered, but not packaging substances.
No, the thing is, we will have to wait, my lord, because otherwise.
No,
if we
Supreme
open
Court says. I have also followed it.
Yes, my lords. Your lordship's judgment, I've already placed it on record, my lords. I've already served a copy on them as well.
That's settled principle.
No,
Nodi.
The matter where
not me, but NDPSL.
No, if they weighed it along with the packaged material, it goes.
Otherwise, my lord, if you
issue
remove
becomes this, my lords. 22B is intermediary quantity. 22A is small quantity. 22C is again commercial quantity. My lord, the imprisonment is very high for commercial quantity or intermediary. Idರಲ್ಲಿ package ಏನ್ ಹಾಕಿರ್ತಾರೆ cover, it is 166 grams ಅಂತ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ. But there is nothing to prove otherwise. Not that becomes small quantity.
ಅಲ್ಲಲ್ಲ, ಕವರ್ ಮಾತ್ರ 166 grams. Then ಒಳಗಿರೋದು ಸೇರುತ್ತೆ ಅದ್ರ ಜೊತೆಗೆ.
Then we will
That will become 1
according-
kg 166 grams. my lord. That becomes intermediary quantity.
we will prosecute for intermediary. Let him. if
ಅದ್ರ
that is
intermediary
admissible,
quantity
we'll
ಗೆ
take it,
ನಾನು
my lord,
prosecute ಮಾಡ್ತಾ ಇರೋದು, which is bad law.
We'll prosecute for intermediary quantity, not for commercial.
ಅದೇ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದವರು. 1160 ಆದ್ರೆ it becomes intermediary.
And that is my problem. Otherwise, I'll fall under small quantity, I'll pay a fine.
Small quantity 1000 correct.
Then you let him, we'll prosecute him for small quantity. Something has
Lords,
to be done.
even
my lord.
otherwise,
Ah,
even
now
otherwise,
otherwise.
quantitative analysis ಮಾಡಿಲ್ಲ. Charge sheet will not serve.
Right, we'll see, we'll hear it.
But your lordship's order, which has already reached finality, my lords, the matter where Jai Simha Rao had argued.
ಜಯಶ್ಯಾಮ್
Is that,
Yes, ma'am.
ಜಯಶ್ಯಾಮ್ದು SLP ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ?
ಇಲ್ಲ ಚಾಲೆಂಜ್ ಆಗಿಲ್ಲ ಸುಮ್ಮನೆ ಅದನ್ನ. It has reached finality. In that, the point which was considered was whether the bark or the seeds and the leaves can be considered along with the fruiting crops. And they've not done it here.
No, my lord, that judgment, your lordship has followed Justice Anand Reddy's judgment.
My lord,
ಹೌದಾ?
Yes, yes, my lord.
my lord, even otherwise, there is another coordinate bench judgment of Justice Krishna Kumar,
No,
where he also says that
I'll argue
quantitative
the matter.
analysis is
ಆಯ್ತು
a
ಸರಿ,
mandate.
ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿ ಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ.
My lord,
List
this
the
is the
matter
matter.
on 22nd.
This is the matter where he is a student who is about to be admitted into a college abroad, my lords.
Then we'll finish it fast.
ಆಗ್ಬೋದು.
As a last chance on 21st.
Fresh matters.
Fresh
my lords.
matters, yes.
Obliged.
ಅವತ್ ಮುಗಿಸ್ಬಿಡೋಣ.
98.
My lord,
Seeking
as
mandamus
per the
where,
direction of this honorable court, no, deleted the names.
Delete
respondents,
ಮಾಡಿದ್ರಾ?
deleted notes. File an memo, my lord.
ಚೀಫ್ ಮಿನಿಸ್ಟರ್, ಹೋಮ್ ಮಿನಿಸ್ಟರ್ ಎಲ್ಲ ಡಿಲೀಟ್ ಮಾಡಿದ್ರ?
Please, my lord, deleted notes. Only direction, my lordship, to the respondent number 1, my lord.
Learned HCGP is directed to accept notice for. ಎಲ್ಲಿ ಡಿಲೀಟ್ ಮಾಡಿದೀರಾ?
So I filed the memo, my lordship.
ಮೆಮೋ ಅಲ್ಲ, ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಡಿಲೀಟ್
First
ಮಾಡಿ ಅಲ್ಲ.
item ಮಾಡಿದ್ದು, my lordship.
ಫ್ರೆಶ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿ.
Please, my lordship.
Yes.
I've given notes.
Learned HCGP is directed to accept notice for the sole respondent.
Please, my lordship.
Yes.
Please.
List on 22nd. Next. ನೋಡಿ ಮೇಡಮ್, ಮೆಮೋ ಹಾಕಿದಾರ? Yes.
99.
appeal against rejection of IA under 311, your lordship, for recalling of further cross-examination of the complainant. Whereas your lordship, the said IA was rejected. My lords may.
Have I issued notice?
Yes, your lordship. Been issued. Last date of hearing, we have said.
Registry to print the name of so and so as appearing for the respondent. ಎಷ್ಟನೇ opportunity?
My lord, 26 times they've taken
ಕೊಡಿ
adjournments,
madam.
4 times they filed an
Give
application
it,
seeking
yes.
recall.
ಕೊಡಿ.
Your lordship may kindly may refer their objections.
Very
at
good,
annexure
madam.
E.
Thank you.
At annexure E, your lordship, their
Yes.
objections.
The petitioner is before the court calling in question an order and order of rejection of an application under section 311 of the CRPC seeking recall of PW1 for further cross examination. The facts heard, so and so facts in brief germane are as follows.
Your lordship, one submission. May kindly may refer.
I will impose costs and dismiss it.
ಇಲ್ಲ ದಯವಿಟ್ಟು ಇದರಲ್ಲಿ they have said 26 times, your lordship, whereas your lordship may kindly may refer their own objection, my lord, on 3.
Where is the order of the court, madam, rejecting it?
At annexure A, your lordship.
Annexure?
A.
Page.
Page 13.
Page-
Lords.
30?
13, 1-3 is the relevant page.
10, Your Lordship.
ಅದು ಅಲ್ಲ
Page
madam.
10, Your Lordship.
Page 30 ಲಿ ಏನಿದೆ?
Page 13, my lords, the honorable
1-3.
1-3, yes.
Ah.
Even on this day, when the case is posted for others, neither the accused nor a
One minute,
counsel
1
are present.
Your Lordship, I agree, Your Lordship. On that day, there was no representation by the council. Whereas Your Lordship,
No, madam.
my submission, my lord.
This
Kindly.
cannot be used as ruse to drag the
Understand, my
proceedings to
lord, it is
this
not abuse
nature.
of process of
The
law. They
petitioner,
shouldn't have done it, my lord.
no, the
Few-
petitioner is before the court. No, madam. Calling in question
I would
an
like to
order
draw
of the
the atten-
concerned court. I'm dismissing it with costs now.
Kindly. Only once.
How many times should the matter be listed to wait?
I understand, my lord.
If you understand, then keep quiet.
But
Yes.
whereas Your Lordship, one submission, my lord, their case is based on the invoices, Your Lordship, it is a fertilizers company. Whereas Your Lordship, in the fertilizers company, my lord, may kindly may refer the exhibits which they have marked, my lord. In that, none of the, Your Lordship,
You mark it there, madam. I'm not here to receive documents like
and it
this.
is their
Yes.
own document, my lord.
Yes.
Under such circumstances, for the just decision of the case, my lord, it is just unnecessary,
Very
my
good,
lord.
madam. Perfect.
My lord, 3/9/24, he was fully cross-examined as per their
Very good.
own statement of objections they have admitted.
Hmm.
My lord, within 1 month, we make application for recalling, Your Lordship. Thereafter, my lord, I do agree, my lord, there is a mistake committed by the trial counsel. I don't want to blame anyone over there. But Your Lordship, in the interest of we have a good case on the merits, Your Lord, in the interest of the justice, my lord, to meet the ends of justice, cost may be imposed. Only
All right.
one opportunity, not even one hearing, adjournment will be taken.
All right. Yes. The petitioner is before the court calling in question an order dated 3/9/2025 rejecting an application under section 311 of the CRPC. The heard so and so. The facts in brief germane are as follows. A complaint comes to be filed by the respondent on 15/9/2020 for offense punishable under section 138 of the Negotiable Instruments Act. The issue in the case is not with regard to the merit of the matter. The petitioners, the accused files an application under section 311 of the CRPC, which comes to be allowed not once but twice on 2 dates, and 2 dates were fixed for cross-examination, 13/3/24 and 3/9/24. The petitioner was not, the accused did not avail the opportunity of cross-examination on the said date. On 27 and 24/7/2025, the matter was at the stage of further cross-examination. Another application comes to be filed on 30/7/2025 seeking recall of PW1. The said application comes to be rejected. It is not once but twice, not once, twice, more than 3 occasions opportunity was granted to the petitioners who did not avail of the opportunity of further cross-examination. The order of the concerned court rejecting the application reads as follows, page 11 to 13. The concerned court has clearly held that repeated opportunity was granted to the petitioners to cross-examine PW1. They have failed to cross-examine the said witnesses, and therefore there was no warrant of repeatedly giving opportunity to the petitioner to further cross-examine PW1. The law in this regard is too well settled that mere change of counsel will not inure to the benefit of the accused to seek further cross-examination every time when the counsel gets changed. The repeated opportunities being not availed of by the petitioner would not mean that this court would lend its hands to the petitioner to even for one opportunity. Petition lacking in merit stands dismissed. Next.
My lord, cost
Next,
may
next.
be imposed, Your Lordship.
Next.
One opportunity.
Dismiss ಮಾಡ cost impose ಮಾಡುವ. Next, yes.
100.
For the petitioner matters.
List the matter.
119% to fill objection.
List the matter on 22nd. Objections, if any.
Till then, stay may be granted.
No, sir. Yes.
Well, it's covered by the latest judgment.
No problem. Yes. 230 ಮೂಡ್ ಮಾಡಿದಿಲ್ಲ.
230 mood matters.
ಒಂದು ನಿಮಿಷ ತಳಿ ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ, ಮುಗಿಸ್ಬಿಟ್ಟು ಇನ್ನು ಸ್ವಲ್ಪ ಇದೆಯಲ್ಲ.
101, sorry. 101.
PMLA matter, my lords, no pre-cognizance hearing, cognizance taken.
We'll send it back.
Only one submission, lords.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ
ಹೇಳಿ.
ಅದನ್ನ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಮಾಡಿದಾರಂತೆ ಅವ್ರು ಆರ್ಡರ್ ಬರ್ತಲ್ಲ, ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಸೇಯಬಲ್ ಇನ್ ದಿ ಇಂಟರ್ನೆಟ್, ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ರಿಟರ್ನ್ ಆರ್ಡರ್. ಆ ECIR ನಮ್ಗೆ ಅಪ್ಲೋಡ್ ಆಗಲ್ಲ. I only submit this much. I understand that there is some issue in that. My lords, it may be taken up next week. Till then, the proceedings may be deferred. That's all. Next by this
List
time.
Learned Counsel Madhu N. Rao seeks 2 weeks time to secure instructions with regard to the proceedings, regard to the procedure followed under 223(1) of the CRPC or otherwise. Till such time, further proceedings shall remain stayed. List the matter on 23rd.
102.
Heard the learned senior counsel Sandesh Chotan Thakur.
But 102 objection is ready, my lord. I've served a copy on my lord, friend.
22nd objections. Learned counsel for the respondent seeks 2 weeks time to file objections. List the matter 22nd. Next.
There's an interim
order. Interim order idre continue.
Please.
Appearing for petitioner. 138.
Also 311 CRPC, my lords, application in 138 proceedings after several years, more than
Anything
total
else, sir?
40 adjournments taken, my lord.
The petitioner is before the court calling in question.
Let's one.
ನಾಲ್ಕು ಸರಿ ಕೇಳಿದ್ದೀನಿ. Calling in question ಇದೆ please jurisdiction.
ಅಲ್ಲ ಇದು ಕಾಸ್ಟ್ ಬೇಕಾದ್ರೆ
ಅದೇ please jurisdiction.
ಕಾಸ್ಟ್ ಮೇಲೆ
No sir, yes. The petitioner is before the court calling in question the order dated 12/11/2025 by which the concerned court rejects the application filed under section 311 of the CRPC. The petitioner challenges the same before the revisional court only to be rejected. The order of the concerned court reads as follows. Page. Yes, Secretary sir.
43.
45.
40?
43 ಅನ್ನೋದ್ರಲ್ಲಿ
43 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
43 ಇಂದ 45 ವರೆಗೆ.
45.
Page 43, please.
43 to 45. The learned senior counsel for the petitioner taking this court, for the respondent taking this court through the documents appended to the petition, would prima facie demonstrate that the petitioner has sought adjournments for cross-examining not once but
13 dates.
On 13 dates, and the order quoted herein above captures all the said adjournments being sought. Therefore, there is no warrant of interference with the order of rejection of the application 311 and the order of the revisional court affirming the said rejection.
Matter is up to the 19, my lords.
Since the issues of the year 2019, I deem it appropriate to infuse finality into the proceedings. Our against our order lena. Beda, yes.
Because, my lords,
Sak.
under the Supreme Court has guidelines, my lords.
ಈಗ ಅದಕ್ಕೆಲ್ಲ ಟೈಮ್ ಇಲ್ಲ.
Defense evidence. Yes.
Next.
Please. Great.
The lifting of attachment.
ಏನ್ ಮಾಡಿದೆ?
My only submission in lords. Once, my lords, because point number 1, section 50 statements are admissible in evidence. Point number.
ಅಲ್ಲ ಈಗೇನು ಅದು ಇದ್ರದಲ್ವಾ ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ಅಲ್ವಾ?
Yes, ma'am.
That's what my submission, lords, we may have to sit down along, my lords. The reason is, my lords, once it is derived as proceeds of crime and up
Supreme Court ಹೇಳಿ.
No, my lords, that, my lords, is that on the with respect to the FD which is to be given, my lords, the facts are different in that. In this matter, my lords, once the POC is determined, my lords, the only authority to decide whether it is from a proceeds of crime or not, it is only with the adjudicating authority. My lords are aware of it. At the most, my lords, it may have to go to the PMLA tribunal. My lords, my only submission, my lord, says under 226 petition, where there being section 50 statements which are admissible in evidence, and he having accepted, yes, this property is having been bought from the very proceeds of crime, my lords, and
where is he accepted ಅಂದ್ರೆ conviction ಆಗ್ಬೇಕಷ್ಟೇ.
Section 50 is admissible in evidence as of today because they are not controverted, they are not retracted. Section 50 as of now stands.
Property purchase in 2008.
Okay, I admit all those things. I admit all those things. I am not on the merits. I am not on these facts. My only submission is, my lords, when section 50 is admissible, my lords, my section
admissible in evidence is not admission of guilt.
No, my lords, that needs to be proved before a trial. Point number 1. Point number 2, that having been accepted, they are not retracted, they are not controverted, they are not contradicted it. Now, this being the fact, And there being adjudication authority mechanism where, my lords, that has to be decided, they have to decide whether there is a proceeds of crime, whether the property is brought from the proceeds of crime, my lords. Then, my lords, now to take it off and say FD will be given, my lords, I have to leave it to this. That's the only, my lords, once it is determined as proceeds of crime is the only.
But Supreme Court judgment is
My lords, if I may, my lords, I did
Last
read
time
that, my lords.
also I had
No, I
passed
did
out.
read that, my lords. There is a, my lords, my lords, just about 1 week, my lords, I will distinguish it, my lords, on facts. I just saw the facts, my lords.
Tuesday.
Then, my lords, my lords will
Finally
decide.
Tuesday.
Finally.
Yes.
Fresh matters.
Fresh.
Please.
Yes.
Lords, once decided, my lords, I don't know on what basis they again, but then once it is POC determined, my lords, it is.
I don't know. Supreme Court ಬರ್ದಿಯಲ್ಲ ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
But subject to the final outcome. the FD has
Correct.
to be deposed.
Supreme Court judgment.
The value of the property will increase.
You
Suppose after
you
2
want to distinguish Supreme Court judgment, you distinguish. We'll see. Yes. Next.
CA cases. In fact, this matter we have argued and we have also
Objection
given.
ಹಾಕಿದ್ದೀರಾ?
Objection ಹಾಕಿದ್ದೀನಿ. If my lord senior has completed, not I will submit.
ಯಾವ ಶುರುನೇ ಮಾಡಿಲ್ಲ ಅವ್ರು ಕಂಪ್ಲೀಟ್ ಎಲ್ಲಿ ಬಂತು?
In that case, not may I request this, not accommodation. There is an interim order. Your lordship has observed that they will not give any. Allah interim order illa, but your lordship has
There is
observed orally
condition.
instructed.
ಆಯ್ತು.
they
List on 22nd. Objections if any by then.
Allah objection
ಹಾಕಿದ್ದೀರಾ? Yes. Then
22nd.
ಬೇರೆ ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಅವತ್ತೇ ಮುಗಿಸೋಣ.
Yes, but schedule, my lords, we have not yet filed the schedule, my lords, subject to this, because if it's going to be covered by the decision, no question of filing schedule, my lords.
ಓ ಇದ್ರಲ್ಲೇನಾ ಶೆಡ್ಯೂಲ್ ಹಾಕ್ತಾ ಇಲ್ಲ?
ಹೌದು.
ಆಯ್ತು.
Because the desirability of
22nd.
PE, my lords.
Don't
And,
precipitate.
and another aspect is Gangadhar Ayya's matter, my lords, which is remitted back, it may be noticed 17. I don't think, my lords, court had interfered on.
I had interfered on 17.
Yes, my lords, it's been sent back for reconsideration on the basis of Sudhakar Reddy. So, my lords, it is.
Independent finding and
Illa. So that it's still open, my lords, and we will be taking up that contention in Gangadhar Reddy again, my lords, on 17. In fact, according to us, there was no order under 17. That's all right. Yes. Because my lords always felt Gangadhar Reddy is a case, just a
No, that is
simple
what I
remand
had
back.
held.
That's all, my lords. No finding at all.
106.
Also, appeal for the respondent, Lords. The TA case. 13(1)B.
22nd. Stay there.
Interim order.
We'll continue. List on 22nd. IO. Next.
107.
7 objection is ready, my lord. I've served the copy on my lord.
ಏನು?
Objection ready ಇದೆ. 13.
22nd. Yes.
Interim order.
Interim order ಇದ್ರೆ continue.
Please.
Like interim order ಇದೆ. But the officer is saying, ಅದ್ರಲ್ಲಿ interim order ಅಂತ ಪದ ಇಲ್ಲ, stay ಅಂತ ಪದ
No,
ಇಲ್ಲ.
my lord. I have already informed the officer, my lord, the further direction also. My lord, yesterday I told my lord.
ಕೊಟ್ಬಿಡ್ಲಾ?
ಅವ್ರು ಹೇಳಿದ್ರು ನಿನ್ನೆ.
108.
Please.
Lord, serial number 21, my lords told will be taken along with this matter.
Oh, yes.
My lords, fresh matters, my lords.
What's the matter, madam?
My lords, civil disputes pending between the parties.
Assault,
Please, my lords.
Madam.
My lords,
307.
my lords, for this, this is not the first complaint, my lords, that's been filed, my lords, by the complainant's mother herself, my lords, has filed, my lords, a crime which has been stayed by, that's a coordinate bench.
Between the same parties?
Between the same parties, my lords, the complainant therein was the
ಈಗ
mother of the
serial number
complainant.
21 in the first list, 108 ಇದು, plus that tag all the three, list them on 29th. In the light of the interim order subsisting in the companion petitions, there shall be an interim order in the case at hand as well. List on, set 1 CGP to emergent notice. Next.
Great.
109.
Also, the petitioner challenging the conditional deposit of 20% while suspending sentence, my lords, covered by your lordship's judgment.
No,
on the-
sir. When do you deposit?
My lords, if I may take your lordships to the
No
trial
on
court.
merits. I'll grant you 4 weeks time deposit. I'm not interfering.
My lords, for a moment, if I may take your lordships to the trial court judgment, my lords.
No, sir. Let it be anything.
My lords, he says he's a vegetable vendor, making about 25 to 40 lakhs a month. And he
Vegetable vendor.
says, vegetable vendor.
ಈಗ ಮಾಡ್ತಾರೆ sir.
This happens in 2011, my lords.
Vegetable vendors and
He says
fruit
vegetable
vendors
vendor,
make more
and
money now.
and he says he has given me 25 lakhs cash. Trial court judgment says that I have not proved that I have not. I have
Notice
not.
to the respondent, there shall be an interim order of stay of the impugned order till the next date of hearing.
Grateful.
110.
Lord,
petitioner, my lord, is a manager of the financial institution. Apparently,
103 and 108. Against him, 108.
but there is no abatement.
ಏನಿದು ಮರ್ಡರಾ?
Accused number 1 was
Complainant's father commits
suicide after killing his wife. and
ಚಾರ್ಜ್
his
ಶೀಟ್
son.
ಆಗಿದೆಯಾ?
ಇಲ್ಲ investigation.
No.
But he is not involved in that, my lord. He has taken
Come immediately after charge.
he has blood petitioners.
ಬೆಳಗ್ಗೆ ತರ ಆಗುತ್ತೆ ಆಮೇಲೆ.
The petitioner's father has not availed the loan. Petitioner's
No,
mother
sir.
has availed the loan, and that too in the month of April, just 2 months before. So they
ಮರ್ಡರ್ ಯಾರ ಮೇಲೆ?
against the deceased father, he has murdered his wife as well as son. Then he commits suicide. That is a complaint. Page 18 may be.
Who are
kindly
you?
seen. I'm the financial of financial institution.
So you have troubled them so much they kill themselves
Lord,
and
that
this.
is, I also produced a loan agreement. The loan
No,
was
no,
only in the month
let
of
the investigation-
April. Like April 2026, a loan.
They want to
put
come
over.
after investigation or you want a finding now? 108, the abatement to suicide, rarely we interfere.
Please, madam, but
ಬೆಳಗ್ಗೆ ಆ 3 ಮಕ್ಕಳಲ್ಲಿ ಒಂದು ಹೋಗೇ ಬಿಟ್ಟಿದೆ.
Transaction started in the month of April.
No, sir.
2 months early, there cannot be any kind of follow up or anything such, my lord. Where they can allegation of
ಯಾವ
abatement can be
ಫೈನಾನ್ಸ್ ನೀವು
L&T Finance.
ಮಾಡಿರ್ತೀರ?
Lord, he has also said that the private loan gali ಬೇರೆ ಬೇರೆ ಇದೆ, ಚೀಟಿ funds ಎಲ್ಲ ಇದೆ.
No,
Maybe
no,
that may be the reason.
nothing doing. Come after charge.
Down to the extent of killing wife and son.
No, sir. The petitioner, accused number 4, is before the court calling in question the registration of a crime in crime number 89 of 2026, which is registered on 9/6/2026. Even before the ink on the crime could dry, the petitioner is before the court. The learned SPP submits that the fulcrum of the case is gross. The petitioner, who is a financier of L&T Finance, is said to have lent some money and has immediately followed up for return of the money.
That allegation
Ali,
is
our
not there.
submission, sir, has followed up for the return of the money. Being frustrated, the who kills whom?
The deceased kills his wife and son.
The deceased, the father.
Father.
The father kills his wife and son, being frustrated. And the acts of abatement has now fallen upon the present petitioner for having pestered the return of money from the hands of the said deceased. Therefore, there can be no question of interdicting the proceedings immediately after the crime is registered, which is just a month old. Therefore, not even a month old. Therefore, investigation shall ensue. The petitioner is at liberty to knock at the doors of this court in the event of filing of the final report and the final report going against him. Bail ಸಿಕ್ಕಿದ್ಯಾ? ಸರಿ. Ajay?
It's a DA case coming for the first time, but my lords, in this matter, 1998 public servant, my lords, he gets his check period is taken from 209, 11 years, income itself is not taken. My lords, we have prepared the irregularity in the source report, no PE done, and straight away FIR registered.
B. Latif is directed to accept notice for the respondent Lokayukta, petitioner to serve set of papers upon the said council forthwith, 16th fresh matters.
I've given the set of papers. my lords,
ಕೊಟ್ಬಿಡಿ
I
ಅದು.
fixed.
Yes. Hmm.
Then 12.
Yes, my lord, I filed a impleading application. I am a original complaint before the police, my lord. This honorable High Court, my lord, directed on
DRK.
1/7/2026, direct the provide all digital documents. Even till today, my lord, they are not provided.
ಈಗೇನು ಕ್ವಾಶನ್ ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು?
No, my lord, they are saying
Why
that.
have you come in? Doctors ಕೇಳ್ತಾ ಇದಾರೆ ಅವರು.
Yes, my lord, because of this system, my lord, on 1/7/2026,
Sir,
my
I'll
lord,
tell you, an unfortunate thing has happened.
Yes, ma'am.
It has happened. Now, if the doctors have taken adequate care and this has happened, how can you go before the medical board? Medical council.
Medical board only.
Medical council.
Medical council only directed that the police to provide all documents. Even the police.
Medical board ಮುಂದೆ ಹೋಗಿದಾರಾ?
Yes, my lord.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
That's my whole.
Where is the medical board thing?
Medical board only.
They have not
issued-
even gone. That's my grievance, my lords.
Where have you gone before the medical
I
council?
On the
filed a
last-
complaint before the police. And in turn, my lord, they submitted to the, as per the Jacob case, my lord, they submitted before the medical council. Medical
ಎಲ್ಲಿದೆ?
council, my lord, it's in the
ಮೆಡಿಕಲ್
document.
ಕೌನ್ಸಿಲ್ ಹೋಗಿದಾರಾ?
My lords.
Medical council, my lord. in turn, my lord,
ಅರ್ಚನಾ ಮೇಡಮ್
medical-
ಒಂದು ನಿಮಿಷ. ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ ಹೋಗಿದಾರಾ?
They filed a complaint.
Who has filed? Yavat?
Medical council, my lord, issued a notice to the
When did you file the complaint?
complaint, my lord. 25/2026.
25.
25/2026.
What did the medical council do?
Medical council issued a notice to the judicial police to collect all the documents. In turn, my lord, the judicial police sent a
ಯಾಕೆ
letter.
ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ಗೆ ಬೇರೆ ಪವರ್ ಇಲ್ವಾ? ಪೊಲೀಸ್ ಮೂಲಕನೇ ಮಾಡ್ಬೇಕಾ?
Yes, my lord, because they have to recover those documents. That's the reason, my lord, that digital
madam.
document.
My lords, on the last occasion, I will request your lordship for just 2 minutes. My lords.
Yes.
On the last occasion, your lordship had asked me to give them all the documents.
ಹಾ.
Like, I have given all the documents. They were harping on one anesthesia
ಹೌದು, ಲಾಗ್.
log and the monitor log.
Hmm.
Lordships, that is a transient data. Now, I would like to produce, this is the manual of those two instruments, my lords. Although it runs in 500 pages and just
Aye.
excerpts from that, I am producing. before
Atoli
your
Lakshman.
lordships.
Yes.
My lords, two dates are important, my lords. 25/2026 is the date of the death, my lords. 19/6/2026 is the notice date where they asked me to give this data. Your lordship may kindly have a look at this trend graph. Either you can review TV, PV, PEC, ECMO, PLATS, so and so within maximum of 24-hour operating time. When the anesthesia machine is restarted,
the trend graph
the
is
trend graph
recorded
is
anew.
recorded anew. My lords, in the next page, my lords, you can recall so and so data at the selected resolution within a maximum of 24 hours. This further, my lords, idu patient monitor operators manual, my lords. Except the data storage release standard capacity up to 120 hours of the trend data. Like I said, my lords, on 25/2026, the incident happened. They sent me the notice on 19/6 after a month, my lords. Now, it is not that this is a transient data, it's a live data. It has been recorded. I have produced the file, my lords, on the last occasion. At page 90, my lords, our file.
ಈ ಫೈಲ್ ಅಲ್ಲಿ.
ಇಲ್ಲ.
ಈ ಫೈಲ್ ಅಲ್ಲಿ.
Please, my lords. At page 90, your lordships. ಆದ್ರೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಇವಾಗ ಕೊಟ್ಟಿದ್ದೀನಿ.
90.
90, my lords. Live data has been recorded. It's not that as and when it is showing in the monitor, my lords. Mailgade, if your lordship would kindly get it, NO2 after there's a saturation which is coming down. It has, everything has been recorded. It's not that we have, my lords, their apprehension and their allegation was that I have erased data, I have not given them. That is not the case, my lords. I have written it in this log clearly that the patient is collapsing, the pulse is coming down. It is very much recorded, my lords. This being the case, your lordship, may I take your lordships to two decisions of this, one of this honorable court and one of the Supreme Court, my lords. Just a moment. Para 23 and 24 minutes. May I read, my lords? As pointed out in Jacob versus Matthew, the state of Punjab so and so, simply because a patient did not favorably respond to the treatment given by a physician, or if a surgery failed, the doctor cannot be held liable as per applying the doctrine of res ipsa loquitur. This edict was reiterated in Martin F. D'Souza so and so, wherein it was pointed out that no sensible professional would intentionally commit an act or omission which would result in harm or injury to the patient, as the reputation of the professional would be at stake and a single failure may cost him or a dear in that lapse. It was also pointed out that sometimes, despite best efforts, the treatment by a doctor may fail, but that does not mean that the doctor or the surgeon must be held guilty of medical negligence unless there is some strong evidence or suggests that she is. It is also pointed out that the courts and the
No,
consumer.
the stage has not yet come that you are held for medical negligence at all. You need not go to that step. Now, what is being sought is two documents. And two documents, now you have said that it does not record data.
Record data.
That is what they have given.
In ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ, my lords,
No, sir, crime register ಆದಾಗ ನೀವು ಬನ್ನಿ, you have no locus now.
my lords, and your lords own judgment, my lords.
Own
which-
judgment?
Yeah,
Huh?
sorry. Your lords
Yes.
judgment, my lords, which clearly has mentioned how the doctor should not be harassed, my lords.
ಯಾವ್ದು yesterday, sir?
July 2nd, my lords.
Oh,
July
so
2nd.
oncologist, yes.
Please, my lords.
Hmm.
My lords, one submission. 25, 2026, the death happens. 25, they register UDR and conduct Mahajar. They take certain documents and again 21, they send another
Now
notice.
we will leave it open for them to complain before the medical board, medical council, and the medical council constituting a board and getting into the issue. Now, insofar as UDR is concerned, the investigation, what they have done, they will file whatever report they want to file. Now, what is there is there. It is what it is. What to do?
Just one statement. In the letter dated 19 June 2026, they said these data we don't maintain. That is what they're making submission.
That is exactly what the manual also says.
Thereafter.
See, it is an anesthesia log.
Correct.
If the anesthesia log, it goes on a cycle, the old will go and new will come in. So how can it be maintained, sir?
No, there are not just anesthesia log, my lord, there are other.
Now,
things which are
I'll
sought.
tell you one thing. In a case of this nature, police cannot decipher what treatment is given, what treatment is not given. It is the best persons would be the medical council to constitute a board and see what is the treatment given. Merely, it may be an influential person's relative has passed away.
No, there is
That-
there is nothing like that, my lord. I think the
That doesn't,
statement was
no,
made.
that is the allegation. I don't know about that.
Sorry to say, there are no
But
such.
even if it is a common man, I'm not saying that. The thing is, police cannot decipher what the doctor should do. It is a medical council that should do, that should constitute a committee and see if there is medical negligence, pin them down.
I understand, my lord. I am not on that point. My point is.
ಈಗ UDR ಅಲ್ಲಿ ಎಷ್ಟು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೀವು? FIR ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ದಂಗ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ UDR?
UDR only thing we need to understand cause of death, nothing beyond that.
Correct. The cause of death is told.
No, that's the two
I think
documents.
Manipal Hospital, the patient dies of coronary thrombus.
Correct.
That is heart attack. So that's all that is there.
Your lordship may see this. One document says.
Jagdish sir, I am for one. Unless the doctors are guilty of culpable act individually, should not harass the doctor.
I understand.
The impact of harassment is not on that, it is on other patients.
I understand.
Then they are also human beings.
I understand.
Matte?
We are not interested in harassing them, and we are not harassing them.
Aito.
Only
Alla,
issue-
I told you a hypothetical situation. Yes.
No, one statement, my lord. They said that this document does not exist. They also write to us, you come and inspect.
You come and inspect whatever is there.
But then they say, ivattagalla nale agalla. So
ಅಲ್ಲ,
they
ಇವತ್ತಾಗಲ್ಲ.
said that it is
ಇವತ್ see, if they have not cooperated with investigation for a UDR report, I will direct, no problem. But if you want to decipher what is the reason for death,
So we are
the
not
IO is not competent to do that
We are not doing
at all.
We only wanted to.
Submission, my lords. Moor Mahajar ಮಾಡಿದ್ದಾರೆ. They have taken everything. After that, my lords, on 23/6, they send notices, 8 notices, cut copy paste to 7 women, my lords. How can they summon? Who gives them carte blanche to summon the women, my lords? 179 ಅಲ್ಲಿ. There's a proviso clearly. They are asking, they're harassing nurses, clinicians. ಅವ್ರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಕಳ್ಸಿದ್ದಾರೆ. ಬಂದು police station ಬಂದ್ಬಿಟ್ಟು ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ. If this is not harassment, what is harassment?
FIR.
No, let them show all these things. No,
Where are the
Let them
notices?
file- No, let them file an
Kodi-
affidavit.
Notices ಕೊಡಿ ಅಲ್ಲ.
Let them file an
Give
affidavit.
all the
I'll
notices
respond.
here.
Let them file an affidavit.
One ನಿಮಿಷ, let the notices be here.
These are what we have received.
No, let them file.
One ನಿಮಿಷ ಕೊಡಿ.
Ask me to give me
No,
number
ಕೊಡಿ
of
madam,
people who
notices
are
ಕೊಡಿ.
present.
Wait,
ಎಲ್ಲರಿಗೂ
wait.
As per the medical board direction, my
Wait,
lord.
sir, wait. Complainant is not to be heard in this.
notice
Wait.
ತಾವೇ ಕೊಟ್ಟಿರೋದು ತಮ್ಮ ಹತ್ರ ಇರೋದು.
179 notice. ಯಾರಿಗಿದು? ಜಯಂತಿ BT, ಮೇಘಾ G,
All
ಲಾವಣ್ಯ G, ನರ್ಸಿಂಗ್ ಕೇರ್, ಸ್ಪಂದನ ನರ್ಸಿಂಗ್ ಕೇರ್, ಸ್ತ್ರೀ ರೋಗ ತಜ್ಞರು, ಸರಿತಾ ನರ್ಸಿಂಗ್ ಕೇರ್. ವೈ ಸರ್? ಏನ್ ಮಾಡಿ FIR UDR ಇದು?
No, no, let them give copy, madam.
ತಗೊಳ್ಳಿ, ಇಲ್ಲೇ ಕಾಪಿ ನೀವೇ ತಗೊಳ್ಳಿ.
I'll respond.
ತಗೊಳ್ಳಿ ಕಾಪಿ ಇದು.
I'll respond, madam.
Take this.
I'll file my objections. madam.
Take this
I
copy.
think They
No,
don't
why
want to
did you
give-
issue, why have you issued so many notices to these people?
No, I'll respond, madam.
Why?
I don't know because I've
ನೋಡಿ
not,
ಅಲ್ಲಿ.
I've not
Notice
been
ನೋಡಿ
privy
ಅಲ್ಲಿ.
to this notice.
179 notice ನೋಡಿ ಅಲ್ಲಿ.
I understand, madam.
Why have you issued notice of nursing section women?
I'll ask them.
Now, this is why when an influential person is behind all this, these things happen.
No, then I'll respond. I'll ask them. to
What
explain.
is this?
No, I'll ask them to explain. Your Lordship, have it. I'll ask them to
This
explain.
is not correct.
I'll file my affidavit.
It's as per the medical
You,
board.
ನೀವು ಸುಮ್ನೆ ಇರಿ sir.
Medical board direction, my lord.
ಯಾವ ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಡೈರೆಕ್ಷನ್ ಎಲ್ಲಿದೆ
Yes,
ಸರ್?
my lord, it's there.
ಕೊಡಿ.
Medical board is constituted and medical board, my lord.
Medical board is constituted by whom?
Last year.
ಕೊಡಿ.
This page.
Medical board will issue independent notice. Why do they need police to issue notice? ಡೈರೆಕ್ಷನ್ ಎಲ್ಲಿದೆ ಪೊಲೀಸ್ಗೆ ಕೊಡಕ್ಕೆ?
Last page.
They issued a notice on that basis.
Now you,
my lord.
SPP ಅವರೇ, you tell me in every case, medical board takes the assistance of police, is it, to get notices? You tell me one instance where medical board has taken the assistance of police to secure documents from the doctor? Are the doctors not obliged to give all the material once the board asks?
They are obliged.
What, sir? Why should the police interfere in all this? UDR ಮಾಡಬೇಕು ಕೊಡಬೇಕು, ಏನಾದ್ರು ತೊಂದರೆ ಇದ್ರೆ ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ನೋಡ್ಕೊಂತಾರೆ. ಬೋರ್ಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಿದೆ. What is all this? And why have you issued 10 notices to women? Nursing care women, why?
No, I'll
Police
verify.
station ಬಂದು ಕೂತ್ಕೊಳ್ಳಿ ಅಂತನಾ?
I'll verify, my lord, what is the reason for issuing this notice.
Let not the investigating officer behave too much. UDR ಮಾಡಬೇಕು ಬಿಡಬೇಕು, ಮಿಕ್ಕಿದಲ್ಲಿ ಬೋರ್ಡ್ಗೆ ಬಿಡಬೇಕು. FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ರೆ ಆಲ್ ರೈಟ್. ಏನು FIR ಹಾಕಿದ್ದೀರಾ? UDR ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
No, I'll verify, my lord, why they
What,
issued.
sir?
Let them respond, my lord. I think it.
Who?
Police.
Let them respond. Yes. The heard the learned counsel Archana KM appearing for the petitioner. A death happens in the hospital. Detail order ಮಾಡಿದ್ನಲ್ಲ last time.
17 ಅಲ್ಲಿ your lordship directed, my lord, to provide the digital document.
On 1/7/2026 the following order. On 3/7/2026 the following order. Hospital Cloud9 is now in the fulcrum of the list for the reason that a patient gets treated for polypectomy and at the time of treatment the pulse goes down. It is recorded in the sheets of the hospital.
Page 90.
In the sheets of the hospital maintained in the sheets of the hospital that the pulse goes down and the patient becomes critical. The patient then was shifted to Manipal Hospital. She dies in Manipal Hospital. While this is an unfortunate incident of a death of a patient, but that unfortunate incident should not lead to every doctor being dragged into the crime, every doctor bringing every doctor into the dragnet of crime. While they are not, what the police is wanting to investigate is on an unnatural death report, a UDR that is to be filed. In furtherance of the UDR, it transpires 10 women staff of Cloud9 Hospital have been issued 179 notices for appearance before the police station. It is ununderstandable as to why the women staff of the Cloud9 hospitals hospital is directed to appear before the police for the purpose of conclusion and closure of an unnatural death report. Contemporaneously, it transpires that the complainant has approached the medical council, Karnataka Medical Council. The Karnataka Medical Council?
Yes, sir.
Karnataka
I
Medical.
filed a complaint before the police and by internal, my lord, they are
The complainant has registered the complaint before the police, and the police have referred the medical council police refer madidra. Yes, have filed a complaint before the medical council, Karnataka Medical Council, after which the medical council is said to have directed the police to secure documents. It rather shocks that the medical council is now wanting to use the police to get the documents, while the doctors are obliged to reply to the notices issued by the medical council as a mandate of the statute. Notwithstanding this, it appears the police is now wanting to show undue interest in the case by issuing notices to all women staff of Cloud9. The learned SPP to secure instructions as to why and how such notices have emanated from the police to the hospital. Until such time, the police shall not, investigation ಆಗಿದೆಯಲ್ಲ ಎಲ್ಲ. Till such time, all further proceedings of in the UDR, where the petitioner hospital shall remain stayed.
Digital data, my lord,
Instead of stay.
Data ಇಲ್ಲ, ಅದು ಬರಿಲ್ಲ?
No, my lord.
Data ಅದು ಬರಿಲ್ಲ?
ಅಲ್ಲಲ್ಲ, ನಾನು since from 25, 2026, I am saying that, my lord, they are saying manual data they are providing.
Sir, if the
Digital data is
medical board is holding them guilty, punish them.
That's only.
If the medical board is holding them guilty, punish them. I am not for that. Police should not enter into doctoring.
Only they have to provide digital data, that's all. my
Correct,
lord.
sir. ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಏನ್ ಡಿಜಿಟಲ್ ಡಾಟಾ ಇದೆ?
That manual data they are.
ಒಂದ್ ನಿಮಿಷ, ಮ್ಯಾನ್ಯುಯಲ್ ಡಾಟಾ ಆಯ್ತಲ್ಲ, ಡಿಜಿಟಲ್ ಡಾಟಾ ಇದು ಬರುತ್ತೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಾ?
Because
ಒಂದ್ ನಿಮಿಷ, ನಿಮಗ್ ಗೊತ್ತಾ? ಒಂದ್ ನಿಮಿಷ
manufacturer,
ಸರ್,
my lord.
ಇದರಲ್ಲಿ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ 24 hours ಅಲ್ಲಿ ಇಟ್ ಗೆಟ್ಸ್
Because that entire has to be sent to the FSL, my lord. It's a recovery of.
ಕರೆಕ್ಟ್ ಸರ್. ಈಗ ಏನ್ ಡಾಟಾ ಇದೆ ಅದು ಕೊಡ್ತಾರೆ, ಅದು FSL ಕಳಿಸಿ. ಈಗ ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ವಿಲ್ ಅಸೆಸ್ ವೆದರ್ ದಿಸ್ ಮಷೀನ್ ರೆಕಾರ್ಡ್ಸ್ ಡಾಟಾ ಆರ್ ನಾಟ್. ಕ್ಯಾನ್ ದಿ ಪೊಲೀಸ್ ಅಸೆಸ್?
Why they are hesitate to give medical data, the data?
ಎಲ್ಲ ಇರೋದೆಲ್ಲ ಕೊಟ್ಟಿದಾರಲ್ಲ.
No, my lord, kindly say.
According to you ಏನಿದೆ ಕೊಟ್ಟಿಲ್ಲ?
36 minutes they are given.
1 minute. Let the medical board decide to summon everything, and what is not given, what is given, the medical board will decide. Police ಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ? ಇದು flow, TVE, MV, peak. ಅವ್ರಿಗೆ ಗೊತ್ತಿರೋದು ಒಂದೇ ಲ್ಯಾಂಗ್ವೇಜ್.
With the assistance of the technician, it's a manufacturer of that company.
First let the medical board decide it. If the ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ, the direction now issued will not come in the way of the medical board pursuing further on its own with regard to the data that is available and the data that is to be provided by Cloud9 to the complainant, since the complainant has approached the medical council of Karnataka Medical Council as well. Doctors will decide what is the problem with doctoring. Police will decide what is the with crime. ಈ ಸಿವಿಲ್ ಕೇಸಲ್ಲಿ, ಡಾಕ್ಟರ್ಸ್ ಕೇಸಲ್ಲಿ ಇದು ಗೊತ್ತಾಗಲ್ಲ ಅವ್ರಿಗೆ.
Yes, my lord. Your lordship gave a direction on 17 data has to be given. They said that, my lord, this entire data is given, but they are not at all given. Only 36 minutes data given.
How do you know it is not at all given?
Not at all given because of this system, my lord, sir.
No,
36
sir,
minutes.
one ತಿಳ್ಕೊಳ್ಳಿ. The data which the complainant wants to be given, ಅದು ಸಿಗೋವರೆಗೂ ನಾಟ್ ಗಿವನ್ ಅಂತ ಹೇಳಿ.
ಇಲ್ಲ, ಒಂದು ಮಷೀನ್ ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮತ್ತೊಂದು ಮಷೀನ್ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಯಾವ ಮೆಷಿನ್ ಕೊಟ್ಟಿಲ್ಲ ಮೇಡಮ್?
ಒಂದು ಮಷೀನ್ ಮಾತ್ರ.
ಅನಸ್ತೇಷಿಯಾ ಮೆಷಿನ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಎರಡೂ ಇದೆ.
ಅನಸ್ತೇಷಿಯಾ ಮೆಷಿನ್ ಬರಲ್ಲ ಅಂತ 24 hours ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. I'll tell you one thing, let the medical board decide. If they are guilty, let them be punished. Police cannot do this.
Machine manufacturer, my lord.
ನೀವು ಪೊಲೀಸ್ ಪವರ್ ನ ಅವ್ರ ಮೇಲೆ ಯೂಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಮೆಡಿಕಲ್ ಬೋರ್ಡ್ ಡೆಫಿನೆಟ್ಲಿ ವಿಲ್ ಡಿಸೈಡ್ ಇಟ್. I am not.
I understand. Just 1 minute from my lord, see page 54.
54 of what, sir?
Petition.
Petition ಕೊಡಿ. Petition ಕೊಡಿ.
Annexure D3.
ಇಲ್ಲ ಇದೆಯಾ ಸರ್?
Annexure D3. I'm not saying, my lord, whether we have to do it or medical board has to do it.
D3.
Yes, my lord. Annexure D3, page 54. Your lordship may see what anesthesia they are saying it's not available. I understand, my lord, I'll accept it.
All right.
Operation theater, OT monitoring records and association monitoring data, according to them not available. ECG recording in digital format, according to them not available.
ECG recording ಇದೆ ಇರುತ್ತೆ. That you can't deny.
My lords, your lordship may kindly.
ECG recording ಕೊಟ್ಟಿಲ್ವಾ?
157
ECG recording ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
Everything has been given.
No, now your lordship may see page 63.
Page 60?
Page 63. Page 63, they say point number 3 to 7.
Point number 3 to 7, we do not maintain or have a position. Yes.
My lords, adralli, that monitor, my lords, as the procedure is going on, the
No,
anesthesia and
ECG data is available. ECG data you can't.
adrallene bandide.
And if the patient is collapsing, if that is your indication, it is clearly shown in the ECG monitor.
My lords, page 90 li, the entire whatever is shown on the monitor.
Where is the ECG recordings? ECG. ECG data will not be erased. It's not a portable ECG that comes into it. You have a ECG machine. No. Through her, yes.
No, I leave it, my lord, whether we have to
It's a
collect it or
running
police
ECG,
report.
my lord.
Sorry, medical.
Even if it
The
is a
running
running,
ECG
even if it is a
again,
running ECG,
same
even if it is a
machine.
running ECG, unless it's a portable ECG, data is always there.
Allah, it is there in the same monitor, the second idralle irutte.
Correct.
So as it's a transient data again
It's,
during the
no,
time of,
ECG is not a transient
yeah,
data
at the
file.
time of surgery, my lords.
It's
Ad
not,
nadista-
ECG is not transient. Very ella okay, yes. Check the ECG data. See if there is a variation in the heartbeat that is shown in the ECG.
ECG is not
Correct.
done, my lords.
Huh?
Physical ECG is not done.
Physical ECG is not done.
ಮಾಡಿಲ್ಲ. Pre ಮಾಡಿದ್ದಾರೆ. During this, it was not required. They have not done it. Is what?
Anyway, medical board let it
No, I understand.
examine everything.
I'm not saying, no, my lord, but this is the conduct of the petitioner.
There is no.
They
conduct.
cannot come and
Everything
say.
is there, my lord.
ECG data you can't say it is
So
not
was
there.
ಅಲ್ಲ ಸರ್ಜರಿ ಟೈಮ್ ಅಲ್ಲಿ ಏನೇನ ಮಾನಿಟರ್ ಅಲ್ಲಿ ಇದೆಯೋ ಎವ್ರಿಥಿಂಗ್ ಹಸ್ ಬೀನ್ ರೆಕಾರ್ಡೆಡ್ O2 ಲೆವೆಲ್ಸ್ ಎಟ್ಕೋ ಎಲ್ಲ ಇದೆ.
ಅಲ್ಲ, see, O2 levels is a
Lordship
common
may
thing that
kindly
has to
SP,
be
O2.
recorded. SP, O2 ಎಲ್ಲ ಒಂದೇನೆ. Yes. SP, O2 recording will always be there. ECG data, it is a running data at the time of surgery, because at the same time of surgery, the variation would show only on the ECG. ಮಾಮೂಲಿ TMT ಟೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ECG ಡೇಟಾ ಇರುತ್ತಲ್ಲಿ, because that's the most important thing.
That is not
ECG data ಇಲ್ಲ ಅಂದ್ರೆ no.
In the same machine, if your lordship would kindly see right ಅಲ್ಲಿ heart rate.
ಈಗ whatever, which is the ECG machine you are using there?
It's the same. ಇದ್ರಲ್ಲೇ if your lordship have bear
Page?
with me just 90, my lords. 90 ಲೇನೆ.
ಇದು ಇದಕ್ಕೆ SPP ಅವರೇ, ಇದು ನಮಗೂ ಗೊತ್ತಾಗಲ್ಲ, ಪೊಲೀಸ್ನವ್ರಿಗೂ
No, I
ಗೊತ್ತಾಗಲ್ಲ.
understand. I'm not
Doctors should know this.
No, I'm not coming in
Because
there. Only
data
thing is.
ಕೊಟ್ಬಿಟ್ರೆ ಸಾಕು ಅಂತ ಅವ್ರು ಡಾಕ್ಟರ್ಗೆ
ನೀವು data ಕೊಡ್ತೀರಾ?
ಕಲೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೊ ಮತ್ತೆ we are not at all concerned about anything my lord. So only data they have to provide.
ಏನ್ ಮಾಡ್ತೀರಾ ಸರ್, ಅದು ಇಟ್ಕೊಂಡು ಸ್ವಲ್ಪ ಅವ್ರು ಪನಿಷ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಡೇಟಾ ಬೇಕು ತಾನೆ.
Yes, well, because why they are hiding that data?
There is
Because
nothing to hide,
even then available, they are manually given.
Medical board will assess their culpability, not the police. All right.
Your lordship,
Yes.
ಅದ್ರಲ್ಲೇ heart rate, if your lordship may kindly see it,
Idal,
90.
I saw the heart rate here, but is it that the running heart rate is recorded by the monitor in the time of surgery, or separate ECG you took?
ಇದ್ರಲ್ಲೇ monitor ಅಲ್ಲೇನೆ.
That is why ಏನಾಗುತ್ತೆ, these things, see whether with the OT data itself, ಅಂತ that's only doctors will know. ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ, ನಿಮ್ಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ?
The only thing, they also asked us to, okay, you come and check with technician. We went with the technician. It's not that we went it. We took the technician, went technician. Only thing they could have allowed to access the technician to see. I am not saying that I'm a competent person. I took the technician with competent person. They could have allowed us to.
ಅದ್ಯಾಕ್ ಬಿಡ್ಲಿಲ್ಲ?
ಬಿಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ. I have given, I will show the photographs also I have produced before your lordship.
Anyway,
We have
why you issued those notices?
Yes.
Reply ಕೊಡಿ.
Mahajar,
But check with the ECG data and file an affidavit that the same monitor operates for the ECG also, and no separate ECG is used. We'll get it checked with the medical board. Yes. ನಾಡಿದ್ದು ತಗೊಳ್ಳ, Friday ತಗೊಳ್ಳ?
Next week.
Next Tuesday. Yes.
Let's see, my lord. Page number 73, they themselves admitted that my lord is they will provide, if a technician will come. Technician is ready, my lord. Machine manufacturer is in
Which
within
machine?
24
One minute. Which machine is that? Siemens?
Mahindra.
Mahindra.
Huh?
They went to the spot.
The one that
Went to hospital. They are not allowed.
Annual, my lords, first of all.
Tomorrow itself, my lord, they will go to the, because the data will destroy, my lord.
Data they will not destroy. Why?
Because they are saying
They've
that
already given what is
using
there
that
to
machine.
destroy, my lord.
That's why, my lord, we will take
The
a
pen
chance
drive
tomorrow
of the
itself.
entire procedure is also
We'll
given.
list it on Tuesday. Tuesday in the fresh matters list.
Tomorrow itself, my lord, because they will go to the spot and they will collect the data. It's just only 5 minutes job, my lord. It's only 5 to 10 minutes job.
May request one thing.
What?
Let technician go and inspect.
Of what?
Of that machine, if it is possible to collect data or not possible to collect.
Tomorrow,
that report can
Permit
be.
that. So
We
what?
have permitted, my lords, your lordship.
Oh,
I've
why?
sent
All
you
right,
the
you
photo.
permit the technician.
ಅದಕ್ಕೂ ಬಿಟ್ಟಿದ್ದೀವಿ.
You permit the technician. They will not harass you. The technician will come, look into the machine and go ask.
The problem, my lords, here lies is, ಇದ್ ಮಾಡೋದ್ ಮಾಡ್ತಾರೆ. ಈ ತರ ನೋಟಿಸ್ ಕಳ್ಸ್ತಾರೆ.
ಅಲ್ಲ ಮಾಡಲ್ಲ.
Only 10 minutes.
This is what
All
has
that,
happened.
I'll,
Halak Mahajan
all,
ಮಾಡಿದ್ದಾರೆ.
I have
UDI.
said all that. Nobody will send you any notice, but the technician will come, record the data, whatever it is, and fine.
And all these notices my learned friend is talking about, we should, before your lordship directed me to. After then, we have done
After ಅಂತ
nothing.
ಹೇಳಿಲ್ಲ ಅವರು.
After ಅಲ್ಲ.
After ಅಂತ ಹೇಳಿಲ್ಲ.
So we will not do anything.
Notices issue ಮಾಡಿ. Yes.
We will not do
The-
anything. Let them allow us to.
ನೀವು
inspect the
ಸ್ವಲ್ಪ
technician.
ಸುಮ್ಮನೆ ಇದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ. The learned, the hospital shall permit inspection of the instrument that was in the operation theatre when the subject surgery took place. For the permit at the hands of a technician of the very company, very company of the machine that is installed. In the garb of such taking of data, the petitioner shall not be harassed. ಮಿಕ್ಕಿದ ಆರ್ಡರ್ ಹಂಗೆ ಇರುತ್ತೆ, ಇದೊಂದು ಮಾತ್ರ ಬಿಡಿ ನಾಳೆ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
If any surgery is going on, we will
Of course.
probably request them to.
ಸರ್ಜರಿ ನಡಿಬೇಕಾದ್ರೆ ಒಳಗೆ ಹೋಗ್ಬಿಡ್ಬೇಡಿ.
No,
ಅದು ಆಗಿದೆ ಅಂತ
any timings may be fixed.
Let them say the time.
ಅದೇ ಒಂದ್ ನಿಮಿಷ ಸರ್, ನಾನು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಸರ್ಜರಿ ನಡೀತಾ ಇದ್ರೆ ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ವಾಟ್ ಇಸ್ ದಿಸ್?
Let them say time, my lord, we will go there.
ನೀವು
Time they are convenient for them, we will go there.
whatever time you tell them, but surgery ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಾಡಿ ಅಷ್ಟೇ.
Please.
Yes. You cooperate with that. Then if that is the only thing that is necessary, next time we'll close everything.
Please.
Yes.
Grateful, your lordship. Is that ಇವ್ರು ಹಿಂಗ್ harassment ಮಾಡಿದ್ರೆ ಯಾವ
ಮಾಡಲ್ವಲ್ಲ.
police
ಈಗ ಹೇಳಿದ್ರೆ ಮಾಡಲ್ಲ. The SPP once he says that it is not, will not be done, it will not be done.
grateful.
Because as he said, all those notices are prior to my order.
After that, we have not even stepped into the hospital.
I am not.
Yes. But medical board will have to be constituted. Medical board will have to assess your culpability.
That is independent of.
Either tomorrow or day after tomorrow, whatever convenient for them, we'll send the technique.
Fine. Next, before Tuesday, ಮಾಡಿ ಅದು.
Agbo.
And then 13.
But this is a case where your lordships dismissed the challenge to the, your lordships rejected the challenge to the FIR. Not I am the complainant.
ಯಾವ್ದೋ ಶ್ರೀಮತಿ ರಾಧಾ ಅಂತಿದೆ. ರಾಧಾ. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಈಗ?
No. Now, my lord, I have sought for a direction to shift the investigation to CCB. Because the
CCB, why?
Avlalli police are now not only delaying, my lord, they are not able to handle the FSL and documentation properly. So therefore, my lord, CCB is a specialized agency.
Correct.
It can go to it, my lord.
Let us shift it to CCB. ಇನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗ್ದಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
In spite of your
The
lordships.
FSL report.
ಅಲ್ಲ SLP ಡಿಸ್ಮಿಸ್ ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆ.
Yes. FSL report, send it for FSL report.
Let the CCB handle it, my lord. Fair investigation.
We'll send it to the CCB and direct completion of investigation within a time frame. Yes, allowed.
Great.
Next, heard the SPP. Yes.
Reporting.
ಅಲ್ಲ 2:30 ಮೂಡ್ ಮಾಡಿ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ 6 ಗಂಟೆ ಕರೀರಿ ತಂದ್ರೆ ಕಾಯಿಲೆ ಎಷ್ಟಿದೆ ಮೇಡಮ್ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್? 2:30 ಮೂಡ್.
230 mood matters. Fresh matter, still number 1, Ashok T.
My lords, the false promise of marriage, my lords, after 9 years, an affair is registered against the.
9 years you had an affair.
Please, my lords, as per the complaint, they were in love, my lords.
Madam.
My lordship, kindly complaint in page number 22, my lords. Provision of POCSO is also invoked, my lords, against.
Why, sir?
My lords, kindly see page
At
number.
what age did you start loving the victim?
My lords, they were classmates, my lords, in first PUC, my lords. They were loving each other, and my lords, after
16 years in the.
9 years in the, my lords.
But problem is he began at 16. In the meantime, yes. Next.
Correct. Serial number 2 also.
ಅದ್ಯಾರು?
My lords, this is boy, my lords, that is their parents and relatives, my lords.
Parents and relatives will stay. Boy ಆಗಲ್ಲ. Yes, next.
Great, my lord.
Boy, secondarily, learned SPP is directed to accept, HCGP is directed to accept notice. One emergent notice, second respondent. First one in the meantime.
Number 3.
Yes, ma'am.
This homestay.
Yes. Now charge sheet has been filed.
Hmm.
Insofar as A2 is concerned, what was 64(1), 351, which is criminal intimidation and harboring, all those charges have been dropped. There are only two offences which have been pressed against me.
What's
One
that?
is an offence under an act which is no longer law has been repealed, Foreigners Act 1946. According to them, I have not submitted Form C to the concerned officer. That act was repealed in September 25. And under the new act, that act in any case is compoundable with 50,000 payment. But in any case, they have not yet set down the procedure.
So that is
under the
one.
new act.
Innondeno?
That is one. Another one is 239. Now here, Lord, it's intentional omission to inform the offence. Now,
The complainant itself says she did not inform you.
that's one. Even if you assume she has in fact informed, the other two ingredients are that I must have intentionally omitted in respect of an offence for which I had a legal duty to inform. Now that legal duty
Like
is set
21
out
in POCSO.
Yes, no. Like 21, there's a mandatory duty cast on all persons who come to knowledge of the offence to inform. In the BNSS itself, there's a specific procedure. 33 sets down what offences the public is under a duty to inform. Offences against the state, not offences against terrorism offence, sexual offences don't form part of section 33 BNSS. So on that short point plot, 33 goes, because 33 does
239 goes.
239 goes, and the only other is offence under a repeal that let them answer not how they to justify it.
One HCGP ಕಂಪ್ಲೇನೆಂಟ್ ಸುಮೋಟೋ ಅಲ್ವಾ?
No, no, no.
ಆ ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ಲಿದ್ದಾರೆ, ಅದೇನು ಸರ್ವ್ ಆಗಲ್ಲ ಬಿಡಿ.
Not some amicus your lordship may appoint because
No, no, no.
We'll see.
amicus can
We will intimate, my lord. We will have to intimate.
Email ಅಲ್ಲಿ ಇಂಟಿಮೇಟ್ ಮಾಡಿ.
we'll intimate.
Yes. The complainant who's now in the United States be communicated by the respondent by way of an electronic mail. In the light of the charge sheet now filed against the petitioner for offence punishable under the Foreigners Act and 239, the learned counsel Angat Kamath appearing for the petitioner submits that the offence under the Foreigners Act cannot even be maintained as it is alleged under the repealed act. Insofar as 239 is concerned, there is no statutory obligation to report the said offence to the authorities. Therefore, in that light, there shall be an interim order of stay of all further proceedings qua this petitioner Obrela, qua the petitioner till the next date of hearing. Yes. Email ಬಂದ ತಕ್ಷಣ ಬರಲಿ. List the matter on 30th.
Your lordship may clarify, my lord, that should not come in a way of other proceedings against other.
It is made the pendency of this petition or the interim order granted qua accused number
2.
Accused number 2 will not come in the way of further trial or proceedings or investigation, whatever the case would be, qua the other accused.
Story has now subsequently improved. Apparently, there was a driver, Lord, who is said to have given an Ayurvedic massage and then committed rape.
Ayurvedic
before the
massage?
cook had done. Yes, a page 191, your lordship will see.
All right, let me see.
A3 has come into the story. Yes.
Now anyway, that I have reserved, Allah.
Yes.
I'll
Now,
look into
Lord,
this,
the dropping
like
of
into
the-
this also now.
Dropping of the rape charges is vindication of my claim earlier that I was illegally
Rape charge was
arrested.
not against you at all.
The only way, then all other offences are
They were non-cognizable. That will see.
Only thing in the grounds of arrest, we had given,
Not about grounds of
no,
arrest.
we had given
That's
him.
a post-arrest
They have not
safeguard.
made use of it is what, we have not said even the grounds of arrest that he committed. Their allegation is that he is not
Arrest
guilty.
ಮಾಡ
For a non-cognizable offence, there's no question of grounds
La,
of arrest
ಏನಾರ್-
because you can't arrest in the first place.
We'll see. Yes. You'll get the order. Wait.
Yes, great.
Number 4,
Yes.
Aditya's judge.
Because this was directed to be listed today in ED proceedings, where I'm impugning.
ಇದ್ಯಾಕ್ pending matter
Two
move
other
ಮಾಡಿದ್ರಿ?
matters. Because it was actually supposed to be for tomorrow. I had requested tomorrow. It has come up today.
2:30 move ಮಾಡ್ಲಿಲ್ಲ ಅವರು. Yes,
Because
pending.
there are two more matters connected with this.
ಕೊಡಿ,
that
tag
may
along,
take-
tag everything.
May I only request, my lords?
Tagged already. ಎಲ್ಲ ಇದೆಯಾ?
Yes, my lords, all of them are there. May I only request, my lords, consider it for 1 minute. Because this.
No, not. Yes. It's a pending matter. You can't do that. Yes. List the matter day after tomorrow.
My lords, may I
Thursday.
request Friday, my lords?
All right, Friday.
Great.
Next.
Other connected matters, my lord, there is an interim order that can be.
Interim order ಎಲ್ಲಿದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes.
Number 5, that is Shruti.
Petitioner is an NHI engineer. A lorry crashes into a divider at 5:30 in the morning. There's no injury to life or a person. What has happened is that cognizance has been taken against him for offences under sections 281 and 285. He could plead out, but unfortunately he's an NHI engineer. And now NBW has been issued.
La. ಆನಿಯನ್ ಲಾರಿ ಡಿವೈಡರ್ ಗುದ್ದಿದ್ರೆ ಬೆಳಗಿನ ಜಾವ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
Divider ಕಾಣೋದಕ್ಕೆ reflector ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ ಅದು ಬೇಡ ಬಿಡಿ ಯಾಕೆ ಲಾರಿ ಬೆಳಗ್ಗೆ ಹೊತ್ತು ಓಡಿಸ್ತಾ ಇರ್ತಾರೆ. The petitioner is said to be a site engineer working with the National Highway Authority of India. A lorry carrying load of onion is said to have been driven in a rash and negligent manner and crashes into the divider and not the gap in the median in NH 209 at about 5:30 a.m. The petitioner is now hauled for rash and negligent act of a lorry crashing into the divider on the score that there was no signboard near the divider. And now pursuant to which the learned magistrate, the concerned court has now issued a non-bailable warrant against the petitioner even. In the light of ಅದು ನೀಟಾಗಿ ಇದೆ. ಯಾವುದೋ ಅವರೇನೋ ಬೇರೆ ಕಡೆ ಪಾರ್ಕ್ ಮಾಡಕ್ ಹೋಗಿದ್ದಾರೆ ಅಷ್ಟೇ. Yes, in the light of the ingredients of the offense itself not making out, there shall be an interim order of stay away the petitioner till the next date of hearing. Stay of all further proceedings. Yes. Next.
Order seal number 6, Shemvi Charat.
Right, for the petitioner. Lord, the complainant has been made as an accused. Lord, he was working as an executive officer in the cooperative society. He had collected certain amount. Lord, due to his daughter's illness, Lord, he had to travel to Mysore. There's a housebreaking. Lord, thereafter, I lodged a complaint. Lord, subsequently, I have been treated as an accused, saying that, and they go to my brother's house and seize 8 lakhs. When I had issued receipt for 14 lakhs and all details are there, I have put 16 years I have worked, Lord, and I have been without any blemish. All records are produced. Lord, 16 lakhs, when I was there in Mysore, there's a break, Lord, of the society building. Then I file a complaint. They in turn allege me as an accused and say that, Lord, I have
Misappropriated.
taken the amount. There are receipts issued to it.
Wait. Learned HCGP is directed to accept notice. Again, move ಮಾಡಿ 2:30 ಗೆ ಏನಾಗಿದೆ?
Lord, they are now filing a charge sheet. Lord, I have given what I have done is I have given the
Learned HCGP is directed to accept notice and secure instructions in the matter. The prosecution shall not file the charge sheet without the leave of the court.
Please.
Yes, next.
Number 7, Dilip Kumar IS.
Lord, false promise to marry, my lord.
False promise to marry.
There have
How
been
many years,
obstructions
sir?
From 2022.
3 years, sir.
Oh, there have been no section 64, my lord.
64, 69, 351. Now you will marry.
No, my lord, he is in JC.
Now
He's been
ಜೈಲ್ಗೂ
arrested.
ಹೋಗಾಯ್ತಾ?
He's been arrested.
ಈಗ 69 ಗೆ ಬಿಡ್ತಾ ಇದೀವಿ ಅಂತ 64 ಇನ್ವೋಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Tomorrow ಆಗಲ್ಲ, day after tomorrow fresh matters. ಬರ್ಲಿ. Bail rejected, ah?
Bail rejected.
Coordinate bench?
No, not paid.
Let's the matter day after tomorrow in the fresh matters. We'll release you day after tomorrow.
Admittedly, there is a consensual matter.
Day after tomorrow we'll release, yes.
Seal number 8, Timothy Charles.
The learned, ಅದು ಮೇಡಮ್ ನಾಡಿದ್ದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ಇದ್ರು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ಹೇಳಿತ್ತು.
Petitioner 2 and 3 are the parents of petitioner number 1. This is a 498 case, my lord. The respondent 3 files a complaint before the Yelahanka police. Based on that, we receive a notice and we apprehend, arrest and we take anticipatory bail. After anticipatory bail is taken, she approaches the Davangere police, same script, same character, same allegation, a fresh FIR is being filed.
The
And I'm challenging
petitioners
this.
are accused 1, 2 and 3. The complainant is the third respondent, the wife of accused number 1. The learned counsel for the petitioner submits that a crime, what is the FIR number? Illidu?
82 of 26.
A crime in crime number 82 of 2026 is registered before the
Davangere police.
Allappa, illi. First crime yavadu?
First was not crime, it was an LTP.
Yes.
LTP, but I got notice to appear.
You're in custody.
No, we got anticipatory bail here.
You got Allah, yes.
Then an FIR comes to.
That's all right. We'll state que others. The 1 HCGP, 1 and 2 HCGP, 3 emergent notice returnable by 30th. There shall be an interim order of stay quay for further investigation in crime number 82 of 2026, the accused number 2 and 3, insofar as the first petitioner is concerned, the same would be considered on the appearance of the wife list on 30th.
My lord, we are already appearing before respondent 2, Yelahanka Police Station.
For what purpose?
Appear.
For what
They are
purpose?
investigating and mediation, all these
Close
proceedings are
agide
going
in-
on.
Yes. The petitioner, the first accused number 1 shall not be directed to appear in a proceeding that ended in crime number?
82 of 26.
Oh, illid yavdu.
This is no crime number, LTP.
Then leave it. Yes, next.
My lord, tomorrow they will summon me in Davangere. Here
Davangere,
proceedings-
go.
No, here already proceedings are going on.
No.
Here I am
Crime is-
attending.
No. Husband, yes.
My lord, here counseling, everything is going, and that may turn into an FIR. We may look at double jeopardy.
Which
again.
one?
Here in Yelahanka,
Double jeopardy barad convict admele.
no, they may file another FIR here.
Let them file.
My
Amel
lord,
you.
to overcome this anticipatory bail, they can't file a fresh FIR. My lord.
No, sir. There is no crime registered first.
But-
Anticipatory bail is pre-arrest bail.
Yes, but that
So
FIR is not a
pre-complaint
sine
bail,
qua non.
actually.
My lord, due respect, FIR is not a sine qua non for an anticipatory bail.
Are you correct, sir? If anticipatory,
LTP, I
anticipatory
apprehend
bail
that
is granted even pre-complaint.
Yes, but
Yes.
with the same cause of action, filing
If
another
it was a
FIR,
crime registered here, I would have granted stay for everybody. It's not a crime registered here.
a
And
complaint was registered. A complaint was registered, notice was issued. Lordship may see the notice.
No problem. Yes.
And
ಈಗ husband ಗೆ ಏನ್ problem ಹೋಗ್ ಬರಕಲ್ಲಿಗೆ?
no, it's already being investigated by the jurisdiction.
Not
police.
investigated, mediated.
Pre-investigation.
Let it become a crime, we'll see. Yes.
Wait.
One HC.
Lordship has given a relief trade in interim application.
Stay application ಇಲ್ವಾ?
ಇದೆ.
ಕೊಟ್ಟಿದ್ದೀರಿ ಇದ್ರ ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಕೊಡಕ್ಕೆ.
Yes. ಅಷ್ಟೇ. Next.
Nine.
Lord, I appear for the petitioner, my lord. The
Hmm.
offences are unlawful assembly and writing.
Hmm.
Now, my lord, on 27/6/2026, my lord, there's a procession that happens. There's a
Where?
public function that's conducted, my lord, in Chikbalapur. Now, the allegation on me is this, my lord, that there's a procession that's conducted from a temple to this public event where the function is happening. And there are certain provocation that's done by the sitting MLA, and the allegation on the present petitioners are that I've used the words Hucha and Ayogya against him. That is only an allegation. Now, out of if your lordship-
Defamation ಹಾಕಿದಾರಾ?
No, my lord.
ಮತ್ತೆ what is this?
It's a you know,
Unlawful assembly
unlawful assembly and writing, my lord.
of 800 to 1000 people.
Out of 800 to 1000 people, even according to their own complaint, they have
And
identified these four petitioners.
how are you picked up in 800 to 1000 people? How many people here?
My lord, I have produced
Four.
photographs. Four, my lord. I have produced photographs to show the event where it's happening also, my lord. Page
So many people are there?
7, 48, 49.
Incident which happened in Chikbalapur where
ಆಯ್ತು 800 ಜನದಲ್ಲಿ 4 ಜನ ಮಾತ್ರ ಕಂಡ್ರಾ?
they have barged into the function and created a nuisance. We'll secure records, my lord.
Secure. They heard the learned counsel, Srimati Kirti Reddy appearing for the petitioner. The petitioners are said to be a part of an alleged unlawful assembly, which was a congregation of 800 to 1000 people. It transpires that the certain words are uttered by these petitioners are berevara.
It's alleged that it's
by
my lord. I've also
by
produced-
several persons against the sitting member of the legislative assembly. This ought to have been the subject matter of a defamation if the said said legislator was aggrieved. Not picking these four people for unlawful assembly, of unlawful assembly, the learned SPP to secure instructions with regard to how only 4 people were found out of the 800 people to choose and register the crime against them. In that light, further proceedings, further investigation, qua this petitioner still the instructions are secured, shall remain stayed.
Like it is not 800 people, the gathering of 800 people.
ಅದಕ್ಕೆ
Page 43, my lord, the statement
Yes.
given. Obliged.
Bill number 10, Kumar Kumardi.
Speedy disposal.
ಯಾರೇನು ಅನ್ಲೇಬಾರ್ದು. And
matter related to speedy disposal, my lord. Matter is 2010 matter, my lord.
ಯಾವ್ದು ಸರ್ ಇದು?
Serial number 10, my lord.
D0.
A triple murder, my lord. More than 100 witnesses there.
ಏನು offense ಏನು?
302, my lord.
16 ವರ್ಷ ಆಯ್ತಾ?
Also, my total 19 accused is there, my lord. And also Supreme Court also direction ಕೊಟ್ಟಿದೆ. But
8 weeks. Disposal in 8 weeks. ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
Defense evidence ಇದೆ, my lord.
ಅಂದ್ರೆ 12 weeks. 3 months. Yes. ಅದ್ ಬರ್ಕೊಂತೀನಿ ಆಮೇಲೆ. Speedy disposal 3 months. Yes, next.
Seal number 11, withdrawal memo.
In terms for withdrawal. Yes, next.
Reporting settlement.
ಎಷ್ಟಿದೆ?
Seal number 50.
ಪ್ರಣೀಂದ್ರ ಸರ್, ಇದಾದ್ಮೇಲೆ ತಗೊಂತೀನಿ.
Seal number 50, DP Mahesh. Sir.
Yes.
Reporting settlement, seal number 50. 51.
For respond number 2,
My lord, sir, appearing for the petitioner, my lord.
List on 17th. Yes, yes, next.
My lords, there's a submission to be made in this petition, my lords.
ಅವ್ರು next week ತಗೊಳ್ಳಿ ಅಂತ ಇದ್ದಾರೆ, ನಿಮ್ದೇನು?
ಇಲ್ಲ sir, ಅಲ್ಲಿ in spite of us approaching them, they are not even responding, my lords. Not even whispering. Approach ಆಗುವಾಗ settlement ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ, ಇಲ್ಲಿ ಬರುವಾಗ one week ಅಂತ ಕೇಳ್ತಾ ಇರ್ತಾರೆ, my lords.
ಈಗ ನೀವು petitioner respondent.
Important case one.
Petition is
One
present.
minute. Entry ಮಾಡ್ರಿ ಇದೆಯಾ?
Entry ಮಾಡ್ರಿ ಇದೆ, my lords.
Entry ಮಾಡ್ರಿ ಇದೆಯಾ ಸರ್? ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ? List after 4 weeks. Yes.
My lords, there's a request made, my lords. Let it be listed next week, my lords.
Yes. 17th.
52.
Filed joint memo for reporting
Offense.
settlement. Offensive, my lord.
ಅದು ಫಸ್ಟ್ ಹೇಳಿ ಆಮೇಲೆ.
380, 448, 504 and 506.
Yes. ಕೊಡಿ.
Dispute between the owner and tenant. They both have settled in MFA. In view of the
MFA order ಇದೆ.
MFA order ಇದೆ.
ಕೊಡಿ.
Mentioned in the return.
ಜಾಯಿಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ಸರಿ ಆಯ್ತು. Close. Next.
There is a counter complaint.
Case and counter ಇದೆ.
ಇನ್ನೊಂದು ಯಾವುದು?
ಇನ್ನೊಂದು ಇದು 751.
ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ?
No, that is pending before magistrate. We are cooperated to close the case, my lord.
ಅದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ
I
ಇದ್ರಲ್ಲಿ?
have mentioned in joint memo also, my lord.
Yes. Next.
This case, this petition may be allowed.
Close.
53. Latif B.
Last, I have filed one more petition. It may be tagged together. Already
ಯಾವುದು?
416/2022. And before the family court is reported, this case it may be closed.
ಟ್ಯಾಗ್ ಮಾಡಬೇಕು ಅಂದ್ರಲ್ಲಪ್ಪ ಈಗ.
Please, 416/2022.
ಅದು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ನಾಳೆ ಮಾಡೋಣ ಎರಡು.
Please.
ನಾಡಿದ್ದು ಮಾಡೋಣ. Day after tomorrow. ಮೇಡಮ್ ನಾಡಿದ್ದು ಹಾಕಿ. ಟ್ಯಾಗ್ along with 416. Yes.
54.
498 filing joint memo.
ಕೊಡಿ. ಇಲ್ಲೇ ಆಗಿದೆಯಾ ಸೆಟಲ್ಮೆಂಟ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಲ?
Family court.
ಅದೆಲ್ಲಿದೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿರೋದು?
ಅದು 15th ಇದೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಮಾಡಬೇಕು.
ಇನ್ನೂ ಇಲ್ಲ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Please madam.
ಜಾಯಿಂಟ್ ಮೆಮೊ ತಗೊಳ್ಳಿ. Yes.
And 50. Please. ಇಲ್ಲ ಆಗಿದೆ.
Yes, next.
59 also.
55.
59 also.
Connected matter.
54 and 59.
Please sir.
ಆಯ್ತು ಸರಿ. Yes, next.
59 ಅಲ್ಲಿ ವಕಾಲತ್ filed for respondent 2.
ಕೊಡಿ.
Same order. Please.
55.
50 sir present.
Lord, 55 and 56 are arising out of the same crime, my lord.
Offense.
115 and 117 subclause 2, my lord.
Yes.
College students. 56 for complainant wakalat.
Joint memo.
ಕೊಟ್ಟಿದ್ದೀನಿ.
57. Odd sheets.
Offense.
Not the 137
Respondent
subclass
number
2, 310
2 and
subclass
3,
2,
Lordship.
61 subclass.
Filing wakalat for
61.
respondent.
Yes, ma'am. 310 subclass 2. This
61 is what?
criminal conspiracy.
No, 120B.
Filing wakalat for respondent number 2 and 3.
Cheating and criminal conspiracy.
About
318 and 120B.
criminal, not kidnapping and dacoity section. is
364A idea.
also- Yes, my lord. In BNS, it's 310, my lord. Actually,
364A.
yes, my lord. Which
Then
is
no.
137 subclass 2 now in BNS, my lord. My lord, this
But,
allegation is against only 6 persons, my lord. This petitioner is not present, my lord.
Maybe, we'll see.
Complainant says that, my lord,
17th, list on
my
17th.
lord, they have come from far, my lord.
Far
Even
Elli.
they have filed an affidavit
Far
with-
Elli.
from Kerala, my lord. Complainant, my lord. They have not.
Wait, pass over then.
Apply.
So give the copy to SPP. Yes, next.
58.
58, my lord, I appear for the petitioner.
Offense.
Offense of 4, 6 and 12 of
You're not
Pox
well?
Act. I am well.
Hmm.
But only thing, we have settled the,
4-6 of POXO.
yes,
No,
my
sir.
lord. No, but it's a boy, it's a, in fact, the complaint was that, my lord, the mother has given the complaint.
You come on merits, will not settle it.
Lord,
No,
kindly see
sir.
the
4 and
complaint.
6 I will not settle at all.
Kindly see the complaint. It is only that, my lord, say, communally sensitive
Hey,
area.
you, whatever it is, you come on merits. I'm not going to settle it. Yes. 4 and 6, I'm not going to close by settlement. Yes.
But,
There can be no settlement in the case at hand. In boy of what age?
boy of 9 years.
Ah.
My lord,
Boy of 9 years sexually harassed by whom?
it is said by the complainant saying the petitioner harassed the boy. But the fact is
You're
that-
also a man.
Yeah, he's a man.
Hmm.
The complainant is the mother of the victim.
Hmm.
It is said. But the fact is that he came to near to the house of the complainant.
No.
And
No settlement, sir.
Allah,
Nothing
thereafter they say that.
No settlement, period. Yes.
And my lord, kindly come.
Come on merits, Igalla. We fix a date. List on 17th to be heard on merits next. Don't get the parties also.
Number 60.
I'm for the petitioner, my lord.
Respondent number
66
2.
impersonation and cheating, my lord. We are paying the money back, whatever have come to my account, so that only with regard to the petitioner, this case can be closed, my lord. With regard to others, that let it continue. We are pending
Where the
back.
petitioner? Yes.
DD is handed over.
Parties?
Parties are.
All right, yes, next.
Order sheet signatures.
ಆಮೇಲಿಂದ ಮಾಡಿ ಎಲ್ಲ ರಶ್ ಕಮ್ಮಿ
Petitioner
ಆದ್ಮೇಲೆ
is not present, my lord. Petitioner is available online, so the complaint is present.
Yes. Complaint council ಇದಾರಲ್ಲ? Ah, yes.
61.
No, 61 offense of 420. Offense of 420. No, DD is handling. 6 lakhs.
Yes, next.
Order sheet signatures.
No, DD is handed over.
ಆಯ್ತು ಬರ್ದಿದ್ದೀರಲ್ಲ ಅಲ್ಲಿ. ಅಲ್ಲೊಂದು ಲೈನ್ ಹಾಕಿ. The petitioner hands over a demand draft of rupees 6 lakhs to the respondent council, same is acknowledged by them. Yes, next.
62.
Dispute between husband and wife, your lordship.
498.
498 POXO and
POXO.
Please, lordship.
No.
Marriage agide husband and wife. 25/10/2025, lordship. It is married. Filed a marriage certificate also, your lordship. In-laws accused idare swami idರಲ್ಲಿ. And parents of the respondent number 2 also accused, your lordship, in this case. Page 136, your lordship, order, your lordship. Page 136, lordship's order. Lordship, it may be. Compromise.
Yes.
Lordship, petition number 1 judicial custody, lordship. Release intimation to be.
ಹೌದಾ? In view of the settlement, in view of the marriage of the settlement is arrived, settlement is accepted on account of the marriage of accused number 1 with the victim, who is age ಎಷ್ಟು victim?
19 years, your lordship.
Who is now 19 years old. In that, and the learned counsel submits that the accused number 1 is now in judicial custody in the light of the offense being one on the POXO Act. In the light of the closure of the proceedings, the petitioner, the accused number 1, shall be released from the prison. The registry is directed to communicate this order to the present authorities to enable his release without broking any delay. But nalene order.
Please, Lordship. Deeply blessed.
Yes. Next.
63.
Offense is 85, 498. Can I pass? Joint affiliate.
ಅಲ್ಲಾಗಿದೆಯಾ ಇಲ್ಲೇನಾ?
ಇಲ್ಲ.
Mediation ಲಾಗಿದೆಯಾ?
Mediation ಅಲ್ಲ, ಅದು circuit day.
ಕೊಡಿ. Yes, yes.
Order sheet.
ಸರವಣ
498 ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ.
ಎಲ್ಲಾಗಿದೆ?
ಮೀಡಿಯೇಷನ್
ಕೊಡಿ. ಮೀಡಿಯೇಷನ್ ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಪೇಜ್ 16 ಪ್ಯಾರಾ 6 minutes.
ಪೇಜ್ 16 ಬರ್ಕೊಡಿದೆ.
ಪ್ಯಾರಾ 6 is the clause.
Yes. Madam ಇದಾರಲ್ಲ. Yes.
Respondent number 2 Malad.
Huh?
Respondent.
Correct. Yes. Next.
Order sheet signatures.
ಏನಪ್ಪ?
65 and IFA and 65.1 Malad.
Offense.
Offense Malad is 468, 471.
Or the respondent
Respondent
number
is
2,
here.
Yes.
There are two connected matters.
All right. Yes. ಕೊಡಿ. ಅಡ್ವೊಕೇಟ್ಸ್ ಯಾಕೆ ಅಷ್ಟೊಂದು ಜನ ಇದ್ದೀರಾ ಅಲ್ಲಿ? ಅವ್ರು ಸೈನ್ ಮಾಡಕ್ ಬಿಟ್ಬಿಡಿ. ಕಮ್ ದ ಸೈಡ್. ಎಸ್. ಅವ್ರು ಮಾಡಕ್ಕ. ಆಲ್ ರೈಟ್. ಎಸ್. ಮುಗಿತಾ?
Order sheet signatures.
Great.
330 matter.
Bill number 114.
May it please, my lord.
Yes,
My lord,
sir.
shall I continue now, my lord?
You should, sir. Yes, yes.
Yes.
No, yesterday there were 500. I was exhausted. Today is okay. There are only 200.
I am obliged, my lord. My lord, just a brief recap, my lord.
Not necessary,
Four-
sir. I know. No
Very good.
recap
Four-
necessary for this court.
Very well, my lord. 3 or 4 issues that are arising, my lord. Could the ED become an informant, get an FIR registered? My learned friend says,
He has
I'm
not
going
argued
into
that
it.
at all, so don't worry.
He's not argued. Second is, does the complaint and given by us, the information and the FIR disclose the offences? My lord, am I audible? Third is, my lord, was there any bar by virtue of the interim order? The interim order was there which said consequential proceedings pursuant to the ECIR are stayed. One of our letters of 10th of February 2025 was after, one day after the 9th of February order, and my lords, in the subsequent interim order staying the ECR and the FIR said, I'm sorry.
ಏನು ಕೇಳಿ madam? For 1 minute, sir. Huh?
Yes, my lord.
Friday there is inconvenience.
ನನಗ? ನಿಮಗ್ ತೊಂದರೆ ಇದೆಯಾ? ಮಂಡೇ. Yes, yes.
So, my lord, the third issue, my lord, was there any bar by virtue of the interim order in
Why is that
us
lady
in-
waiting?
Sorry.
Why is she waiting? It is over ಅನ್ಸುತ್ತೆ ಕೇಳಿ. ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ? ಇನ್ನ ಒಂದಿದೆಯಾ? It may not reach, madam. We'll take it another day. You don't wait. 2 weeks bit on date ಕೊಟ್ಟಿರಿ.
Your Lordship, I appear for the petitioners in the matter. The trial court matter is scheduled on the 14th. I'm
On?
speaking on the 14th of this month.
We'll take this on Monday, 13th.
Great.
Monday.
38 serial number.
13th.
Yes. So we continue.
Third issue, my lord, was there any bar in us sending that information on the 10th of February, which was a continuation of the earlier information of 2nd of February?
The 2nd of December.
2nd of December.
So 2nd and 10th, 2 dates are important.
Are important has to be
One
read.
follows the other.
One follows
or
the other.
One swallows the other. Yes.
Yes, my lord. My lord, ultimately, what will be swallowed, we'll have to wait and see, my lord. That will depend
Yes,
on the
sir.
view my lord takes.
Yes.
My lord, the 9th, because why this issue is important, while passing the interim order, my lords observed that the 9th February ink had not dried and you send the 10th February information, which led to registration of FIR. Was there
Correct.
any embargo? Interpretation of my lord's interim order will have to be done. Fourth, was the same predicate offense sought to be revived, which was stayed in the earlier round? Fifth, my lord, complainant need not be the person cheated. Now, first, hurdle that I have to cross is, my lord, is the offense made out at all? Before any of the other ancillary issues comes up. Now, in that context, my lord, I had taken the liberty of preparing that convenience compilation, which contains more or less the documents that, my lord, yesterday, my lord, was referring to.
Ah, yes, yes, all right.
That July compilation, my lord.
Yes, yes, sir.
Now, my lord, please see, one of my learned friends' contention was that, look, I have only entered into a lease cum sale deed. It's an agreement to sell. There is no transfer. There is no cheating. Lamb is not cheated. The person who I have taken money from and parted with the property has not cheated. I am presenting the case a little bit differently, my lord, please see. The lease cum sale deed with KIDB, there were certain mutual obligations. My learned friend says it's a simpliciter breach of contract. It's a civil dispute which the ED has tried to extrapolate and make it into a criminal offense. My lord, 39 crore was paid by embassy way back in 2007, which as allotment consideration. The initial term was 11 years. From time to time, came to be extended. There was some yearly consideration. The object was for setting up an IT infrastructure project, my lord. Over a period of time, these properties, around 78 acres, which was taken, were mortgaged to various financial institutions, and almost 3,000 crore loan was availed over a period of time and utilized for purposes other than what the loans were taken for. They were utilized for various purposes, sent to sister concerns for their business purposes for personal enrichment at the cost of the public property, my lord. There was a negative covenant that without permission you cannot mortgage, 11B of that clause. Out of 11 mortgages, permission taken only for 2. 9 of them, no permission taken. A nudge came from this honorable court that KIDB should take some action vis-a-vis these various irregularities that are going on, which led to the resumption order. Now, 2 clauses are important, my lord. I have shown from yesterday. Prior permission is required for subleasing. Prior permission is required for mortgage. 11A and 11B, my lord. That, my lord, will find
No permission is taken.
prior permission for subleasing they have taken. But as far as mortgage is concerned, 9 out of those 11, no permission is taken. 21A, my lord, is an interesting clause. If I may only request, my lord, to turn to that clause, which is a clause which permits sale as well. And this is a case which my lord will recall.
Yes,
they have attempted to sell it and they have received 1125 crore rupees as consideration in the escrow account, out of which 900 crore has stands withdrawn by embassy by the petitioner. Now, my lord, please see just 2 clauses if my lord will have. Page 168, my lord may see. 11A, written request from the lessee, lesser may permit the sublease. Lesser being KIDB, lessee being embassy. 168, foot of the page, my lord. On a written request from the lessee, the lesser may permit the sublease of leasehold rights of the scheduled property or any part thereof in favor of the project developer solely for the construction of building and allied purpose in pursuance of the implementation of project as cleared by the government. And 11B, lessee may mortgage the right, title and interest in the scheduled property after obtaining consent in writing from the lessor. My information which I have sent clearly mentions at page 152, my lord, that out of 11 such mortgages made, 9 of them no 11B permission taken. And therefore, my lord, there appears to be clear cheating. There appears to be ingredients which are made out. Now something which is important, my lord, may please see. Page 311. As far as the specific transaction of March 2025 with LAM is concerned. Page
Yes.
311.
Yes.
They take consent. This consent, if my lord will see, nowhere is there any information given that they are going to also enter into an agreement to sell vis-a-vis this very property. And contrary to what my learned friend said the other day, that there has been no handover of possession, Mr. Jitu, who is, my lord, the person in charge of the affairs of the company, in his
His
section
name
50.
is Jitu,
Yes, he's one of the accused persons, my lord. Mr. Virnani, my lord.
ಅಷ್ಟೇ ನೇಮ.
Accused number, petitioner number 2. He is one of the accused in the, he's accused number 1 in the FIR.
ಅಯ್ಯೋ ಜಿತೇಂದ್ರ ಸರ್.
Okay, I mean,
I'm
most
searching who is
places,
Jitu.
I'm sorry, in most places it is written as, I beg you. Now please see page 311, my lord. 311 is a consent cum permission under 11(1)(a). 311 is only for the purpose of lease, subleasing. 311, when it is issued by the CEO of KIADB, he is not informed. There is a complete suppression and concealment. My lord, it is, I'll place some authorities where even a concealment of a relevant material fact, making somebody part with a valuable security, which, my lord, in section 2 subsection 31 of the new Bharatiya Nyaya Sanhita is the definition which is borrowed from the earlier definition in 41. Page 311 is a valuable security which confers rights upon embassy to sublease the property. This is obtained by way of a fraudulent misrepresentation that they are seeking consent only for subleasing. Now, please see for a moment, my lord, 2 or 3 submissions that my lord may consider. Embassy never intended to develop this property. The executive engineer's report is there that even though the sublease is permitted only for a project which is to be developed, it was never intended to be developed. Embassy, my lord, made fraudulent misrepresentations. It deceived KIDB to issue this consent letter, which is a valuable security.
All this will have to answer. Yes.
Third, please have a statement issued by the CEO of KIDB, who himself in a section 50 statement says, three or four very important thing he says. The consent letter was only for sublease and not for sale. Number 1. Number 2, no knowledge of agreement to sell. KIDB was never put in knowledge that embassy was entering into a sale agreement or agreement to sale for the purpose of this very property. Third, my lord, embassy was not entitled to sell the property or enter into an agreement to sell. My lord, may only have that statement 3 questions and 3 answers. I will not trouble my lord with anything more than that. Just 3. Question 8, 11 and 15, my lord. If I may just read it while my learned friend is tracing it, my lord.
Yes.
The question is, I am showing you the letter dated 10th February furnished by you in respect of permission. This is the CEO who is giving his statement under section 50, my lord. These are admissible. My lord is aware I need not carry coal to Newcastle, my lord. I am showing you the letter dated 10th February 2025 furnished by you in respect of permission granted by KIADB to the Allotti company. This is question 8, my lord. Please go through the same and explain the purpose for which permission was granted by you.
Question number?
8. My lord, 8, 11 and 15 I would be placing before my lord only.
8, 11 and 15.
Yes, and 12 also, my lord.
Who is this answering your questions?
This is the
Assistant
CEO.
Director. CEO?
No. CEO of KIDB. Assistant Director is the person taking it.
Correct. CEO of the KIDB is answering?
Yes. My lord, may see question number 1. Last 3 sentences, he says, currently I'm posted as CEO of KIDB since 14th June 2023.
Yes, sir.
The consent letter is of February 2025. So he was the CEO at the relevant time who has, my lord, given this consent. Consent cum permission. Consent is a valuable security that I will place a decision, my lord. The consent which confers valuable rights on the person receiving the consent is a valuable security as understood under section 2 subsection 31 of the Bharatiya Nyaya Sanhita. Now please see the ingredients of the offense of cheating is clearly made out because KIDB is made to part with this valuable security on a false and fraudulent misrepresentation that I am only subleasing this property for the purpose of development. He has never been informed that there is going to be an agreement to sell. Otherwise, they would have rejected it. My lord, may please see. Question 8. I have gone through the letter dated 10th February and signed the same. I hereby confirm that the permission was granted to sublease the leasehold rights of 25 acres in favor of LAM Research for the purpose of construction of building and construction related activity. I wish to state no permission was granted to embassy to transfer or sell KIADB's land to any other entity. That's one. Number 2, para 11, my lord. You have stated that the land allotted to the company is leasehold and the allottee can't sell or transfer the land to another entity. Now, why this expression transfer, my lord? In Mr. Jitendra Virwani's statement, he confirms that possession has been handed over. Therefore, my lord, the implication of 2 or 3 things: agreement to sell followed by possession being handed over, coupled with 1125 crore, which is the entire consideration, sale consideration received in an escrow, out of which 900 crore withdrawn by embassy. Therefore, whether transfer has happened or not, my lord, implication of
So money is
53A,
withdrawn
etc.
anyway.
900
Money,
crore is withdrawn.
money is withdrawn.
Yes, money is withdrawn, my lord. Public land exploited in this manner without anything coming to KIDB, multiple times courts have been nudging them. My lord, even various offences which are probably not in the FIR would also get triggered if, my lord, any investigating agency examines these aspects very closely, my lord, possibly involvement of KIDB as well. Now, my lord, may please see the answer to question number 11. I have gone through the agreement to sell dated 20th of March 2025 between LAM and EEBL and signed the same in the token of being seen the same. I wish to state that this agreement, this is very important, my lord. The Supreme Court, in the case of Iridium, says non-disclosure of relevant information would also fall within the definition of fraudulent misrepresentation and deception attracting cheating. Non-disclosure of material information. He says, I wish to state this agreement to sale is not in the knowledge of KIDB. However, going through the same, I state that this agreement to sell was made by embassy in favor of LAM for sale of 25 acres of land, which is a part of allotted KIDB land to EEPBL at Kadugudi. I further state that seeing the content of the agreement, this sale agreement is illegal, as EEBPL cannot execute any sale agreement for this land. KIDB has given NOC only for subleasing, that is for construction of the building for sanctioned project. Then para 15, my lord, may see. Question 12 also, my lord. I have gone through the agreement to sell. I wish to state EEBPL is not entitled to execute the sale deed. KIDB is the absolute owner of the scheduled property. I state no such permission was granted. Question 15, again he reiterates, my lord, that KIDB has not granted any approval. So, my lord, 2 or 3 basic points that for the purpose of ingredient of section 3184, which is, my lord, parimateria with 420 and 415. First, my lord, suppression of material fact, misrepresentation, consent obtained. Nowhere is there a request for sale. Second, in the subsequent sale agreement, agreement to sell along with come lease, please see one of the representations that they make to LAM. That will also be a subject matter of investigation. They say at page 316, clause 9, my lord, the seller is fully entitled to execute the sale deed to convey the scheduled property absolutely. My lord, sorry.
Yes.
My lord, may I have 316 serial 9? My lord had seen this. Seller is absolutely entitled, fully entitled to execute sale deed to convey the scheduled property absolutely in favor of the purchaser. This is the representation being made, which on the face of it and on the basis of whatever little evidence that we could gather during the brief period that the ECIR was alive and active, my lord, that this is a completely false misrepresentation. Second, my lord, he says in recital in page 323, it is important because they say, my lord, that they are entitled to enter into transactions. And then, my lord, the expression transaction may only be seen as to how it is defined for a moment, my lord. My lord, for that, may I request, my lord, to have for a moment page Lord, may first have, I'm sorry, my lord, page 338, clause 7.1.2. 338, clause 7.1.2. The seller has full right, power, and authority to enter into this agreement and to consummate the transaction contemplated hereunder. Because the expression transaction is a defined term in the contract, my lord. Page 338, clause 7.1.2, my lord. So he said that the seller is fully this, that is embassy, holding out to Lamb that it is entitled to consummate the transaction, my lord. Now, in that context, my lord, may please see how is the expression transaction defined at page 323, just 3 or 4 clauses before that. Transactions are defined, my lord, is a defined term, shall have the same meaning ascribed under recital C. Recital C, my lord, is at page 316. I will read it out, my lord. Includes both sublease and subsequent purchase. Purchaser being desirous of setting up an R&D center, laboratory, and office premise that is defined as permitted use on a portion of a larger ad measuring 25 acre in Schedule B and hereafter referred to as scheduled property, approach the seller seeking grant of a sublease and subsequent purchase of the scheduled property. So in effect, he says and holds out that I am entitled to absolutely consummate the transaction, including not just the sublease, but also the sale and conveyance of the property. Completely contrary to what is his right flowing from the original sale cum lease deed with KIDB. Because the lease cum sale deed with KIDB is contingent upon KIDB entering into a sale agreement, selling the property to embassy upon fulfillment of all the conditions. My lord, may please have clause 21 for a moment of the original lease cum sale deed. My lord, for that, my lord, may please turn to
You showed it to me yesterday.
clause 21. My lord has not seen. My lord has seen 11A and B.
Correct.
21A is at page 176. I'll just read it, my lord. Lessor shall sell the scheduled property to lessee, that is KIDB, shall sell the scheduled property to embassy during currency of the lease period or at the end of 11 years, if the lessee has performed all the conditions contained herein. Conditions
Yes.
of development, etc., has not been performed. This eventuality has not taken place. So unless 21A is triggered, the representation given in the Lamb agreement that he is entitled to consummate the transaction of sale is a false representation even made to. So two set of false misrepresentations being made, my lord. One to us that we are only subleasing the property, one to KIDB that we are only subleasing the property, and the second, my lord, to Lamb that they have the absolute ownership or absolute right to convey the property. Then, my lord, may please see, I need not trouble, my lord, with the meaning of valuable security. My lords have held repeatedly that even a consent letter, please have one Bombay High Court decision, my lord, where consent is been treated as a valuable security. It's an honorable single judge, so it can only have persuasive value before this court, my lord. Ravindra Patil versus Rajendra Patil, para 11, my lord.
Where is it? Where do I get that?
My lord, my colleague will hand it over, my lord. It's
Yes.
one short judgment, my lord. Para 11, my lord, may see.
Valuable security.
Yes, that even a consent letter Even a consent letter, a permission letter, para 11, if my lord will see, amounts to a
Rajasthan
valuable
High
security.
Court. Bombay.
Bombay High Court. Bombay High Court.
Justice Saldana, yes.
Yes, my lord. Then,
Yes,
my
sir.
lord, may please have, for a moment, only, my lord, I have prepared a compilation volume 3, if my colleague will hand it over, for 2 or 3 propositions for my lord's consideration. First is, my lord,
How many documents are you giving? Too many convenience compilations will make it inconvenient.
that's true, my lord. That's true. My lord is right. But this is only a judgment compilation, my lord.
All right, give it. Yes.
Lord, may please have page. Sorry. My lord, this arose in the context of the Income Tax Act, page 126. It's an old judgment, my lord. Old judgment
Sandesh sir is
issued.
the happiest. Yes.
My lord, old judgment of the Income Tax Act, Ishwarlal Girdharilal at page 126, my lord, will see the issue was that when a person misdeclares his income and makes an assessing officer prepare an assessment order and part with it, is it a valuable security for the purpose of cheating? Now, in that, my lord, we just see only para 14 at page 129. I'm not going into the entire discussion, my lord. May please have para 14 at 129.
We have no time to get into discussion, sir.
Yes, my lord. That's why I'm not getting into it, my lord. I've seen my lord's board. I've seen my lord's pace. I'm also trying to adapt to it, my lord.
Yes, sir.
In Delhi, sometimes we get spoiled, my lord, but I'm adapting to my lord's pace, my lord. My lord, may please see. Please have, my lord, page 129, para 14. An offense under section 420 IPC will also be made out if it is established that the accused have cheated and thereby dishonestly induced the income tax officer to make a valuable security. This takes us to the question, is the assessment order valuable security? We have already held that section 30 IPC defining valuable security. Assessment order is a document. Order of assessment creates a right in the assessee in the sense he has a right to pay tax only on the total amount assessed, and his liability to pay tax is also restricted to that extent. Therefore, an order of assessment is a valuable security. To that extent, drawing an analogy, the permission or consent letter that he took, my lord, on the basis of which he was able to enter into an agreement with
So
Lamb
that
and
forms the valuable security, and
a
that
valuable.
forms the ingredient of cheating.
Yes.
Is your
Yes.
submission.
Yes.
Yes.
And please have, my lord, I won't trouble my lord with reading it. Please have the index for a moment, serial number 4. Non-disclosure of relevant information would also amount to misrepresentation leading to deception. In Iridium, the Supreme
That
Court
is
said
that is rudimentary, sir. Yes.
that is also settled law, my lord. Third, my lord, in some cases, Supreme Court says even transfer of a property is not necessary. If you have made a person do something by virtue of the deception or omit to do something, that is, my lord, serial number 3, Devendra Kumar Singla. Therefore, even that is not necessary. Fourth submission, my lord, may consider, if nothing else, there is a conspiracy to cheat. Even assuming the cheating has not finally culminated, there is a standalone
Meeting of minds have happened.
meeting of minds
Whose
have
mind
happened.
has met whose mind?
Please see the accused persons, my lord. Please see 3 or 4 accused persons, my lord, who are.
Oh, they all met and conspired to cheat.
There is a conspiracy to cheat, my lord. The investigation is at an incipient stage, my lord. The conspiracy to cheat is evident from the conduct where, my lord, the properties are being used in a manner where it is not intended for the purposes that it is being used. There be mortgages of thousands of crores being created without permission. Properties are being sold when they're holding out to authorities that they're not going to sell it. Therefore, my lord, it is irrelevant as to who is being cheated. Criminal law can be set into motion by anybody. It is settled law, my lord, in a year, Antule, etc. Now, for a moment, my lord, may please see if there is a conspiracy to cheat. Pavana Dibbur, my lord, Supreme Court, as far as because we are ED, as far as PMLA is concerned, if there is a conspiracy to commit a scheduled offense.
That I'm aware, sir. My judgment is reversed. Bhavana Dibbur is acquitted there. I mean, since quashed proceedings.
Proceedings are quashed
I
on
had
the
I had dismissed it that it does some money trail is enough. The apex court reverses it on the ground that 120B was not even the offense.
Please have only for a moment. I'm making a slightly more, my lord, slightly subtle point. 447, my lord Missy. The Supreme Court says in that case that 409 is a non-scheduled offense. A conspiracy to commit a non-scheduled offense will not trigger PMLA. But while saying so, it clarifies, because, my lord, there are cases where a conspiracy does not fructify. There is a person who gives a contract for a murder, which is a scheduled offense. Murder does not happen. There is a person who gives a contract for committing a terrorist act. Terrorist act does not happen. But as far as the proceed of crime is concerned, it can be generated from a conspiracy to commit a scheduled offense. Supreme Court clarifies that in Pavana Debut, that if it's a conspiracy to commit a scheduled offense, 120B alone being a standalone offense is sufficient to attract PMLA. But if it is a conspiracy to commit a non-scheduled offense, you will render the scheduled OTOs because you can bring in everything under the sky by virtue of 120B. That's the ratio of Pavana Debut. Therefore, my lord, para 31E of Pavana Debut, if my lord will see only one sentence, conspiracy to commit a scheduled offense will attract PMLA.
There's no doubt about it.
Yes, therefore, my lord, in the
The
present
crux
case,
is it should be a scheduled offense, that's all.
that's all. Therefore, conspiracy to commit a scheduled offense of cheating will also attract, and conspiracy need not fructify. Fourth submission, my lord. Now, my lord, please see, as far as the interim order that was operating is concerned, my lord, may please see, there was a similar, the Supreme Court has taken a view that section 66(2) is not a proceeding under an ECIR.
No, there's no doubt about it.
Section 66(2) is an independent obligation. Therefore, my lord, the view taken in the interim order, my lord, and my learned friend's contentions throughout the petition that we could not have sent a 66(2) because there was a stay on the
He has
ECIR.
dropped that, sir. He has given up.
Did not even say 66(2) is a proceeding.
No, he has given up those things.
Very well. Then,
no.
because my learned friend was, my lord, half giving it up, half retaining it. So if
No,
he's
no,
not,
there's nothing half. Ella full. Yes. He's given it up in full, 66(2).
yes, my lord.
Yes.
Now, my lord, may please see as far as the third submission was concerned of my learned friend, that you are reviving the very same predicate offense. If my lord will have this very compilation, page 141, the document compilation, the order accepting the closure report rejected ED's protest petition saying that you have no locus. However, while accepting the closure report, it said it is a dispute in personam with the original Mr. Nautiyal. Refused to take any of these larger issues into consideration, and therefore, my lord, this is a case which is not a case of reviving the old, very same allegation. In fact, why it is so? Because, my lord, the contract, which is the subject matter, the sale agreement, is of March 2025. Whereas the earlier FIR, my lord, is of a much prior date. That, my lord, will see is of April 2024. So an April 2024 prior FIR could never have within its realm subsumed a subsequent event of March 2025. So, my lord, it completely defies logic to say that an earlier predicate offense is sought to be revived by sending a 66(2) because it's a subsequent event. The event of the sale of March 2025 to Lamb was not the subject matter of the earlier FIR, my lord. My lord, lastly, I had put together a note on the basis of the petition that my learned friend had filed. If my lord permits, I can hand over that note.
Oh,
And
please.
but many of the issues my learned friend has given up. So, my lord,
No, only one issue, 66(2).
66(2), revival of the earlier predicate offense. Now, please see on the issue of revival of the earlier predicate offense, my lord, may just have my note for a moment. I have taken the liberty of, my lord, placing those line of judgments where, my lord, if there is a different conspiracy, even though there may be some overlapping facts in the complaint, it will not render a subsequent FIR in any manner illegal. I have placed those as well, my lord.
All right.
So therefore, my lord, in summation, if I may only point out, my lord, the public property as far as embassy is concerned has been, my lord, not developed. They may have some extraneous reasons, but the obligation was on them to get clearances and develop it. 2007 to 2025, they have been illegally profiting from it by putting them to mortgage, availing huge loans to the tune of 3,000 crores. Thereafter, my lord, utilizing those for purposes other than development, and my lord, finally selling the land without having any authority to sell, possession being handed over. My lord, may please see Mr. Virwani's one sentence, only one sentence from his statement where he says that even possession is handed over. My lord, may please have that statement, my lord. Question 39, if my colleague will.
Possession is handed over to Lam.
He says in his statement under section 50.
All right, yes. All right,
He
we'll take it.
says entire consideration received, full consideration of 1125 crore received and possession handed over. Even if possession is not handed over, according to my submission, my lord, it makes no difference because the property as far as KITB is concerned was the consent which they made a fraudulent misrepresentation, and my lord, they
All right, yes.
forced them to part with it, induced them, my lord, obliged.
Tomorrow. Name the tomorrow.
After your lordship completes.
I have not made that submission on the. I've restricted it only
Half,
to
half.
101. Lord, I have restricted myself to 101. If my lord wants, I
Yes.
can.
B group tada. Sorry, B report tada.
B report.
That
I
yes,
can make that sub. If my lord wants, I can make that submission also. But my lord,
B
or
you're on locus.
What B
No, B
report
report to challenge B report locus ತಾನೆ ನೀವು ಹೇಳ್ತಿರೋದು.
locus ಮಾತ್ರ ಅಲ್ಲ. The impugned order is absolutely right. I will point that out, my lords. The impugned order passed by the court below in accepting the B report is absolutely right. Law is set in motion by a person. He is asked to come to give statement. He doesn't come. B report is filed. After the B report is filed, they would come and file an application seeking leave to file protest, after which they file an ECIR. Then, my lords, in between all this 66-2, they give information, second FIR done, second ECIR done. So, my lords, the object of having an investigation so far as KADB, they have been able to achieve it through the second FIR and second ECIR.
ನೀವು ಸ್ವಲ್ಪ
no,
convenience
in fact, our case is.
ನಂದು ಒಂದು 5 dates
Convenience
ಕೊಡ್ಬೇಕು. No,
compilation,
my lords, 5 dates. My
5
lords will be
dates.
convinced so far as the first FIR.
I'm ready, my lord. I'm ready with this with that other matter also. If my lord wants,
I'm not ready, sir. Yes.
Tomorrow, my lord. Tomorrow.
Yes, yes.
Obliged.
ಅಂದ್ರೆ 4:30. You
4:30.
don't waste your time. 4:30 ಗೆ ಬಂದ್ಬಿಡಿ.
4:30, my lord. 4:30.
No, don't come. I will not take it at 3. ಏನ್ ಮಾಡೋದ ಮುಗಿಸ್ಬೇಕಲ್ಲ. ನಾನು ಏನೇನೋ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತೇನೆ. ಬೆಳಗ್ಗೆ ಅಡ್ಮಿಷನ್ ಹಾಕಿ ಮಧ್ಯಾಹ್ನ ಇದ್ ಮಾಡಿ ಸಮ್ ಪರ್ಮಿಟೇಷನ್ ಕಾಂಬಿನೇಷನ್. ಅದಕ್ಕೆ finish everything and come.
In a way, for me also it is better, my lord, because all courts would have risen by the time I address, my lords.
Oh. Yes, sir. Come at 4:30, sir.
4:30,
Yes.
my lord. Deep,
You will take another 5 minutes.
another 15 minutes on my other
15
3992.
for what, sir?
5-10 minutes, my lord. My lord, I have already truncated my argument so much, my lord. 5-10 minutes. Obliged,
Yes. ನೀವು ಒಂದು 5 ನಿಮಿಷ ಅಲ್ಲ. ಆಮೇಲೆ ಪುಣ್ಯದ ಸರ್ ನಿಮ್ದಿದ್ಯಾ? ರಿಪ್ಲೈ ಕರೆಕ್ಟ್. ನೀವೇನಾರು ಹೇಳೋದಿದ್ಯಾ? ಇಲ್ಲ. ಬಹಳ ಸಂತೋಷ. So if you send too much liquid, it will become solid there. ಮೂವೇ ಆಗಲ್ಲ.
Thankfully, stay was there. This much only we could
ಓ
find.
ಇಂಟರ್ಮೋಡರ್ ಇಲ್ಲ ಅಂತಿದ್ರೆ ಇಮ್ಯಾಜಿನ್. ಎಸ್ ನಾಳೆ ಆಗುತ್ತಾ ಮೇಡಮ್ ಇದು? ಮೇಡಮ್ ನಾಳೆ ಆಗುತ್ತಾ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹೇಳಿ.
Lordship, may I be allowed to make a small submission?
Yes, madam.
List number 2, serial number 36, connected matters there pending before the same bench. Can it be tagged?
Collect ಮಾಡ್ಬಿಡು.
List continue. List number 2, seal number 34.
ಎಷ್ಟಿದೆ ಅಡ್ಮಿಷನ್? ತುಂಬಾ ಇದೆಯಾ? $34. 34 22nd. ಅದು ಅಷ್ಟೇ 35 22nd. ಎಲ್ಲ PC Act 22nd. ಜಯಶ್ಯಾಮ್
36 same lot.
ಏನ್ ಮೇಡಮ್ ಅದು? 36 ಸೇಮ್ 22nd. 37 ಜಯಶ್ಯಾಮ್. 2 weeks IO. Next.
Your Lordships, if I may, serial number 38, Your Lordships had directed for it to be listed on Monday. It may be listed under fresh matters, my lords.
My name appeared as a respondent. Wait. What's the urgency?
It's listed for IA for stay. The trial court matters listed on the 14th of this
You
month.
told me. Monday fresh matters.
Serial
My
number
name is, 1938. I'm appearing for R2.
Just need to print the name of, what's your name, sir?
Moinuddin. Moinuddin.
Yes, so and so.
Read for minutes.
Monday fresh matter.
Krishna, my lords.
Inter matter ಇದೆಯಾ?
No, my lords, fresh matter.
ಇದು 22nd. Yes.
Short date.
Objections if any by the next date ಮಾಡ್ಬಿಡಿ.
40.
ಇದ್ರಲ್ಲಿ ಏನ್ ಇನ್ನೂ ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ಅವ್ರೇನು ಇವ್ರದೇನು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ, ಅರ್ಧಂಬರ್ಧ ಆಗಿದೆ.
ಆಯ್ತು, ಸ್ಟೇ ಮಾಡ್ಬೇಡ ಹಂಗಾರೆಲ್ಲ.
ಸ್ಟೇ ಆಗಿದೆ
ಬಿಡಿ ಮತ್ತೆ.
But Chalke who appeared on the other day, he said
came
not
on the last occasion.
close it.
My lords, from
Right.
our end,
Yeah,
there is nothing
you
to say.
need
All accused, my lords, proceedings stand.
ಅಲ್ಲ, ಆಕ್ಸ್ ಟು ಗ್ರೈಂಡ್ ಒಪ್ದೆ, ಮಿಸೈಲ್ ಟು ಗ್ರೈಂಡ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು. ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಹೆಂಗ, ನೀವು ಯಾವತ್ ಬರ್ತೀರಾ ಮತ್ತೆ?
It's close so far as everybody is concerned, my lord. Nothing is there, and I have nothing to offer.
Not on merits.
My lords,
Not on
I have
merits.
nothing to offer, my lords. The entire complaint is of conspiracy. My lords, I have no.
ಎವ್ರಿಬಡಿ ಎಲ್ಲ ಕ್ವಾಶ್ ಆದ್ಮೇಲೆ ಕಾನ್ಸ್ಪಿರಸಿಗೆ ಒಬ್ಬರನ್ನ ಇಟ್ಕೊಂಡು ಕಾನ್ಸ್ಪಿರಸಿ ಮಾಡ್ತೀರಾ? ಇಟ್ ಇಸ್ a standalone offense. Nobody can stand alone.
I'll also not.
No, I have nothing to offer here apart from saying that.
17th finally. Yes. Entry
Can I request on 20th?
ಅದೇ 2 ವಾರನೇ, ತೊಂದ್ರೆ ಇಲ್ಲ. 20th finally. 20th ಬೇಡ, 21st.
22nd.
22nd. Yes.
Fresh.
IO. Fresh matter, of course.
Fresh matter top of the list of serial.
ಎಲ್ಲ ಆಗೋಗಿದೆ.
ಅವತ್ತು ಅರ್ಜುನ್.
Yes, next.
41.
IO 22nd.
Lordship, one more matter is connected in this.
ಎಷ್ಟು PC Act ಅಲ್ಲಿ ಎಷ್ಟು ಕನೆಕ್ಟ್ ಮಾಡೋದು? ವೇಟ್. 42. 22nd. Yes. Fresh matters. 43. Post immediately after service of notice of respondent to.
Intermodal.
Intermodal continues, sir. Yes.
Please.
44. Fresh matter ಇರ್ಬೇಕು. Monday fresh matters ಕರೆಕ್ಟ್ ಬಿಡಿ. ಸ್ಪ್ಲಿಟ್ ಇರ್ಬೇಕು ಮೇಡಮ್ ಇದು. 22nd. Yes. Satish. 22nd. 13 or 7?
13.
22nd. Yes.
IOU.
Intermodal continue.
46.
13 minutes.
Same day.
47.
Doctor.
My lord.
Intermodal ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. But my lord, in this case, needs to be quashed, my lord.
Needs to be quashed.
Yes, my lord.
ಅಯ್ಯೋ.
The petitioner is 65 years old.
ಅದಕ್ಕೆ it should be quashed.
He is a retired medical officer.
ಅದಕ್ಕೆ it should be quashed.
My lord, there was no prima facie case.
I have myself stayed it, madam.
It's not stayed.
No,
my
it
lord.
is stayed.
My lord, it's not stayed because this is 2007 matter, my lord.
ಗೊತ್ತು ಮೇಡಮ್, ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ.
ರಿಟ್ ಪಿಟಿಷನ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಏನ್ ಬಂತು? ನಾನೇ ಸ್ಟೇ ಮಾಡಿದ್ನಲ್ಲ ಇದನ್ನ.
2007 ಇಂದ ನಡೀತಾ ಇದೆ ಸ್ವಾಮಿ. Plus the matter was taken to Supreme Court after it being quashed earlier here.
Anyway, we'll see. List on Tuesday in the fresh matters list. Yes.
Obliged.
Next Tuesday is 14th. Yes. Prasann Kumar. ಏನಿದು? DA 22. ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆಯಾ? ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಎಸ್. ಸಿರಾಜುದ್ದೀನ್ ಅದು 29th ಹಾಕಿ ಮೇಡಮ್. ಅಷ್ಟೆಲ್ಲ.
Password seal number 5.
But there's also not DA.
For seal number 5.
5 lots.
ಒಂದು ನಿಮಿಷ. ಇದು ಅರ್ಬಟ್ಟಿ ಬೆಳಗ್ಗೆ ಇದ್ರಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಪಾಸ್ ಓವರ್ ಯಾಕಾಗಿದ್ದು? ನೀವು ಬರ್ಲಿ ಅಂತ.
ನಾನು ಅಲ್ಲಿ ಅದೇನೋ ಡೇ ಟು ಡೇ
22nd. ಎಸ್. ಇಂಟರ್ ಮಾಡಲ್ ಕಂಟಿನ್ಯೂ ಇದ್ರೆ
Please, ಇದೆ.
15, 29th ಹಾಕಿ ಮೇಡಮ್. ಎಸ್ ಸಾಕು. 83 ಆಯ್ತು. ಓ ಅದು ಅವ್ರಿಗೆ ಡೇ ಆಫ್ ಫ್ರೈಡೆ ಹಾಕ್ಬಿಡಿ. ಎಸ್
84 ಒಂದು.
ಏನದು?
ದರ್ಶನ್ಸ್ ಮ್ಯಾಟರ್ 154.
ಮಂಡ್ಯ ಕೇಳಿದ್ರಲ್ಲ
ತೊಂದ್ರೆ.
ಹಸ್ಮತ್ ಪಾಷಾ ಅವ್ರು ಮಂಡ್ಯ ಕೇಳಿದ್ರು.
Madam, 57.
ಯಾವತ್ತು ಮೇಡಮ್? ಮಂಡ್ಯ ಅಲ್ಲ, ಮಂಡ್ಯ.
My lord, 57 is passed over.
ಸೆಟಲ್ಮೆಂಟ್.
Yes, my lord.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು?
My lord.
That is kidnapping for ransom, my lord.
364A.
363,
Some of the
my lord.
accused are murder case also,
7 years
my
in prison. My lord.
ಬರ್ಲಿ ನೆಕ್ಸ್ಟ್ ಬರ್ನೆ ಕೇರಳ ಇಂದ ಬಂದಿರ.
Even on the day of complaint, my lord.
One minute. SPP sir.
Yes, my lord.
Can be done.
No, there are murder cases also against some of the accused, my lord. We will have
Yes.
There is judgment of Supreme Court, my lord.
No sir, I will not take it to Supreme Court.
My lord, he was not there.
Murder cases ಇದೆ.
There is an earlier case, but this is not, in this case he is not involved. But police forcefully they have taken him. On the day of complaint also, he have submitted, my lord, before the police. Police have beaten this complaint.
You are not on merit. You are on settlement. It's a discretion whether I should settle or not. You have no right to ask
Yes,
for
my lord.
settlement
Lord,
that
if
way.
TIP have done, they would have, without doing any TIP, they have arrested this petitioner because he have,
Who's in custody now?
he is out on bail. He have filed affidavit, complaint have filed affidavit before the trial court, my lord, that
No.
he was not present, my lord.
No problem.
Lord,
ನೋಡ ಯಾವತ್ತು ಬೇಕು ನೋಡಿ ಲಿಸ್ಟ್ 17th. Yes.
But list 1 serial number 44. It's a fresh matter, my lord.
44
Yes, my lord. My lord, the offense is under section 353, 279. Lord, no cognizance. There is no order of cognizance, no sanction. Lord, trap ಮಾಡ್ಬೇಕಾದ್ರೆ
ಟ್ರ್ಯಾಪ್ ಗೆ 250 ಏನು offense ಏನು 7A ಅಲ್ವಾ?
350 section 353 of the
ಟ್ರ್ಯಾಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವು
ಟ್ರ್ಯಾಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದುಡ್ಡು ಕೊಟ್ರು, ದುಡ್ಡು ನಾನು ತಪ್ಪಿಸ್ಕೊಂಡು ರ್ಯಾಶ್ ಅಂಡ್ ನೆಗ್ಲಿಜೆಂಟ್ ಡ್ರೈವ್ ಮಾಡಿದೆ ಇಸ್ ದ ಎಲಿಗೇಷನ್. ನೋಡ
ನೆಕ್ಸ್ಟ್.
My lord, one submission, my lord. List number 2, serial number 41, my lord. The connected matter has been issued with the interim order, my lord. The same may be issued to the case in hand, my lord.
ಅದೇನು?
ಅಲ್ಲ,
PC Act ತಾನೆ?
ಹೌದು, PC Act.
ಏನು?
Connected matter has been issued with
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಯಾರು ನಾನು ಕೊಟ್ಟಿದ್ದೀನಾ?
ಹೌದು, ನಾವೇ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಡಿ ಇಲ್ಲಿ 41.
I have already placed the memo also.
ಕೊಡಿ ಇಲ್ಲಿ ನೋಡೋಣ ಯಾವ್ದದು. ಎರಡು ವೆಕೆಟ್ ಮಾಡೋಣ, ಎರಡು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ನಾಳೆಗೆ ಹಾಕಿ ಅದು.
Serial number 41, my lord.
Offense 7 ಏನ 13?
13.
41 ಕೊಡಿ. Your accused number?
Accused number 4, my lord. Accused number 2 and 3 already or before your lordship, my lord.
No, accused number 4 ಯಾರು?
4 bandi AE, my lord. She was working as a in a technical.
13 ಅಲ್ಲಿ 4 ಜನ ಹೆಂಗ್ ಬರ್ತಾರೆ? It must be 7A.
ಇಲ್ಲ ಇಲ್ಲ
or criminal misconduct.
ಇಲ್ಲ 13.
ಇಲ್ಲ offense ಯಾವುದು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಲ್ಲ.
13(1A) and 13(2).
13(1A) ಸರ್. ಯಾರು ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು ಯಾವುದು?
Stay in 797, my lord.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
I have placed a memo before your lordship, my lord, in the last date of hearing.
ಅದು ರಿಸರ್ವ್ ಆಗಿದೆ.
ಹೌದು.
ಇರ್ಲಿ ಬಿಡಿ.
My lord, one more submission.
ಇದರಲ್ಲಿ ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅವತ್ತು ಡ್ಯೂಟಿಲಿ ಅಂತ ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು.
ಇಲ್ಲಿ ನನ್ನ
ನೀವಿದ್ರ ಇಲ್ವಾ?
ಅಲ್ಲ ನನ್ನ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ, the respondent Lokayukta itself have filed a report under section 12
ಏನಂತ?
stating that I don't have any material records to show that I have committed such offense.
Where is that?
It is at page number 30.
ಯಾರು? who is the respondent? ಲೋಕಾಯುಕ್ತ ಯಾರು? 41 Monday fresh matters ಹಾಕಿ. Monday fresh matters. Let the Lokayukta council be present.
That's all.